Do we know what order they go to?
What do you mean? Are you drinking coffee?
What?
Good morning, everybody. Welcome. Please, in the next couple of minutes, you want to get a little more something to drink or eat and bring it to your table, please do. I'm just going to make some opening remarks and welcome you to the 2016 Samuel Dash Conference on Human Rights, which this year is being co-sponsored both by the Georgetown's Human Rights Institute and our Juvenile Justice Clinic. And we have a real exciting program today. I'm looking forward to spending the day exploring how we can all promote the fundamental rights of children. Many of you know me. Those who don't, my name is Andy Schoenholtz. I'm the director of the Human Rights Institute. I also co-direct the Asylum Clinic here, CALS, as well as I'm a deputy director of the Institute for the Study of International Migration. And I am also joined, Wally was here a moment ago. There's Wally, thank you. I'm also joined by my colleague, Wally Malenik, who's been a leading expert on children's rights and clinical legal education for decades. And we're really delighted this year to have partnered with Wally's clinic, the Juvenile Justice Clinic. And I also want to thank the clinic's director, Chris Henning, for her support of this program. Wally's made a huge difference in shaping what you'll experience today's conference, and ensuring that leading human rights lawyers and experts guide us through a meaningful conversation on the very important children's rights issues, in addition to our own student lawyers who will be presenting their findings this morning that I'll talk about in a moment. But let me say a couple words about the person who we're here to honor, Sam Dash. As many of you know, the Dash Conference is an annual event organized by the Human Rights Institute and held in honor of Professor Sam Dash, who was a member of our faculty for nearly 40 years. When he passed away in 2004, Professor Dash's family, friends, students, and colleagues came together to create this conference in his memory. So each year, the Dash Conference is an opportunity to remember Professor Dash and engage on the issues that were so important to him, specifically the protection of fundamental human rights. You can read more about Sam Dash's truly inspiring career in your programs. In addition to teaching here at Georgetown between 1965 and 2004, Professor Dash served on the board of the International League of Human Rights and traveled the globe pursuing justice. He led a human rights mission to Northern Ireland to investigate the 1972 Bloody Sunday incident, and traveled to the Soviet Union and Chile. In 1985, he was the first American to visit Nelson Mandela in prison and was involved in the mediation efforts that eventually led to Mandela's release. Professor Dash also served as chief counsel of the Senate Watergate Committee's investigation into the Nixon administration's involvement in the Democratic National Committee break-in, which ultimately led to President Nixon's resignation. We're very thankful today to be joined by one of Professor Dash's daughters, Rachel. Unfortunately, Judy couldn't be with us this morning, but we know in spirit that she is. And so thank you so much for being here, Rachel. Your family has been for a long period of time, intimate members of the Georgetown community, and so we really appreciate you being here and other members of your family who have always supported your dad in this conference. Sam Dash inspired generations of lawyers who went on to pursue Georgetown's mission of doing justice in the world. And we are really grateful to his contribution and his family's continued support to the law school, and our students in particular. So before we jump to the substance of today's discussion, which I'll just say a word on, and walk you through what the program is, I want to take a moment to recognize the members of our team who made today's event possible. And naturally, the first person I'm going to thank is not here right now, and that is Patrick Griffith, who is our Dash Muse Fellow. So you'll just have to tell him I said really nice things about him. Now, why do I want to say such nice things about him? He is the real organizer for today. He is the one who's been in touch with everybody who's going to be talking and presenting today. He really thought through this program, clearly with the great help of Professor Malenik and the two wonderful professors who I'm also about to introduce. But Patrick really made a huge difference in making this happen. Now, he worked closely, as it turned out, with one of our presenters this morning, Zanande Boy, who is a research assistant for the Human Rights Institute and a member of this year's fact-finding group. They worked together developing a framework for today's discussion, which is a concept note that has been circulating, and you should have that now. We've also had great help from all the staff at Georgetown who work on these events, Deb Gales from the Special Events Office, as well as, I hope you've already started to appreciate, the catering facilities and the AV office who make these conferences work well. So I also want to send my thanks, my personal thanks, but Human Rights Institute's thanks to Michelle Branet and Jen Potkel, who have served as adjunct professors for our Human Rights Fact-Finding Project for the last 2 years. They have given so much of themselves to our students, all while continuing their full-time research and advocacy at the Women's Refugee Commission. You'll be hearing from their students in just a moment, and when you do, it will become immediately clear how lucky the students are to have Michelle and Jennifer as advisors for the project. So many thanks again for everything you've done for our community and particularly for our students. So we're all here today for a conversation about international human rights protections for children and how those protections are translated into the lived experiences of some of our society's most vulnerable members. Many children, as you know, today face serious harms and problems that go to the heart of their well-being, whether they're living in or fleeing from conflict and poverty, seeking to secure an education and better future despite irregular immigration status, accused of committing a crime, or working for a paycheck in dangerous conditions. Over the course of the day, you'll be hearing from experts across a range of practice areas who seek justice when children's fundamental rights are violated. The idea behind this conference arose last semester when Somalia ratified the Convention on the Rights of the Child. The discussion later in the day will touch on the substance of that treaty, but the action by Somalia left the United States as the only member of the UN that is not a party to the most widely embraced human rights treaty in history. That seemed like a reason to ask not just why is that the case, but particularly what are human rights lawyers in the United States doing to promote the rights advanced by this yet-to-be ratified treaty? And what we immediately found were a number of lawyers and activists who have continued to seek justice for children in the U.S., often by using international arguments, despite the U.S. government's outlier status when it comes to the convention. And our discussion today will highlight some of the very important and worthwhile work that these lawyers and activists are doing. But first, we'll be hearing from members of the 2016 Human Rights Fact-Finding Project, who this year investigated access to education for undocumented children in the U.S. Exploring the fundamental right to education, they investigated barriers to enrollment and full enjoyment of that right. This morning, they present their findings and policy recommendations to address some of the violations that they identified. And this year, we're very excited that the report itself is a joint project with the Women's Refugee Commission. And you can find copies out there that are hot off the press, and they're also on the Human Rights Institute website. After the morning panel, we'll have lunch and hear from our keynote speaker, who is here. Thank you very much, Dr. Bissell. Dr. Susan Bissell is here. She is the director of the Global Partnership to End Violence Against Children, and I will give her a more formal introduction later at her keynote address. After the keynote and a short coffee break, our afternoon panel will feature lawyers and activists who've been at the forefront of protecting the rights of children in the United States. That discussion will be moderated by Professor Malenik, our colleague from the Juvenile Justice Clinic, and will highlight the ways that domestic and international standards are being used in litigation and policy advocacy to protect children who face a host of hurdles to the full realization of their rights. We are also excited that Christine James Brown, who is the president and CEO of the Child Welfare League of America, will provide some closing thoughts and an announcement from the Campaign for the U.S. Ratification of the Convention on the Rights of the Child. After the formal discussions are finished, we will invite everyone to join us for a reception to continue our conversations. So again, thank you so much for being here today at the beginning of our conversations, and I'm now happy to hand it over to the members of the 2016 Human Rights Fact-Finding Project and the release of their report entitled Ensuring Every Undocumented Child Succeeds, a report on access to public education for undocumented children. All yours.
Good morning, everyone. Again, welcome to the 2016 Samuel Dash Conference on Human Rights. My name is Shruti Swaminathan, and I am a member of the Georgetown Law Human Rights Institute fact-finding team. Today, I will be moderating 3 panels consisting of my fellow teammates, and I will be facilitating a discussion on this year's research topic, access to education for undocumented children in the United States. I now have the honor of introducing you all to my teammates, who will be rotating on and off stage for each 5-person panel presented to you. I will begin with Raimi Reyes, Caitlin Callahan, Zenande Boy, Alexandra Hughes, Genevieve Fougere, Caroline Kurtz is at the table, along with Michaela Harris and Alexander Kramarczyk. So an estimated 2.4 million school-aged immigrant children live in the United States, and an estimated 770,000 of them are undocumented. Since 2014, more than 100,000 unaccompanied children under the age of 18 have entered the United States in search of protection. Upon taking residence in a community, children, including undocumented children, have the right and, in fact, a legal obligation to enroll in school. Because many of these new arrivals are settling in areas that have traditionally not had immigrant communities, schools are facing new challenges in serving their rapidly changing population. This report is the product of an investigation into how schools and communities have met these challenges in ensuring access to education for undocumented children. In particular, this report examines enrollment procedures and services available to undocumented children once they are enabled to enroll in school. The fact-finding team also examined undocumented children's ability and willingness to attend school in the wake of Immigration and Customs Enforcement, commonly known as ICE, 2016 enforcement operations. These operations are part of the Obama administration's efforts to detain and deport adults and children who have arrived since the 2014 influx across the southern border. Our report documents the effects these actions have had on undocumented children's enrollment in school and how school districts and schools have responded to such actions. So this report is the culmination of a year-long research project undertaken by 9 Georgetown University Law Center students, a Human Rights Institute fellow, and 2 attorneys, Michelle Brunet and Jennifer Podko, of the Women's Refugee Commission. The fact-finding mission was conducted in January of 2016 in Texas and North Carolina. We spent a week interviewing government and school officials, practitioners, and families with undocumented children about their experiences with the U.S. public education system. We selected Texas as a fact-finding location due to its extensive history of immigration from Central America and Mexico. We selected North Carolina as our second location to diversify the geographic breadth of this report and to include a state that has more recently received a large immigrant population. In addition to our fact-finding trip, we conducted desk research regarding practices in both Florida and New York State. So our report investigates the right to education as it is actually experienced by undocumented children in the United States. In doing so, we seek to showcase the strong legal precedent that serves to protect the educational rights of this population and the standards for which states, districts, and schools are accountable. I will turn it over to my colleagues, Raimi and Caitlin, to speak respectively to the international and domestic legal frameworks.
Thank you, Shruti. My name is Raimi Reyes, and I'll be speaking on the international human right to education without discrimination. Education is a fundamental human right, and it's essential for the exercise of all other human rights. It promotes individual freedom and empowerment. Without it, none of us would be here today. The right to education has been widely recognized by countries worldwide, and consequently, it has been codified in international treaties and instruments. These instruments promote and develop the right of every person to enjoy access to education of good quality without discrimination or exclusion based on race, color, descent, national or ethnic origin, sex, gender, religion, birth, or other status such as immigration status. But most significantly, these treaties are proof of the great importance that states and the international community attach to normative action for realizing the right to education. Countries around the world recognize that international human rights law has protected the right to education since the adoption of the Universal Declaration of Human Rights in 1948, requiring all member states of the United Nations to provide free compulsory primary education and to prohibit discrimination in schooling. Several relevant international treaties bind the United States with regards to ensuring the right to education. First, as a party to the Convention on the Elimination of All Forms of Racial Discrimination, the United States has an obligation to guarantee equality between citizens and non-citizens in the enjoyment of these rights. This means that the United States must ensure that public education is accessible to undocumented children and the children of undocumented migrants. It is contrary both to international and domestic law to bar a child from enrolling in school because of its immigration status. Likewise, by ratifying the 1967 protocol relating to the status of refugees, the United States has agreed to give refugees the same treatment as is accorded to nationals with respect to elementary education. At a regional level, the United States is bound to respect and ensure the right to education to all persons subject to its jurisdiction by the American Declaration of Rights and Duties of Man. It is important to note also that the United States has signed but not ratified other conventions that relate to the right of every child to enjoy access to education. As a signatory of this convention, the United States has agreed to act in good faith, that is, to not defeat the object and purpose of this instrument. Namely, these conventions are the International Covenant of Economic, Social, and Cultural Rights, the Convention on the Rights of Persons with Disability, and the Convention of the Rights of the Child. This last one, the Convention on the Rights of the Child, will be discussed in our afternoon panel, but we'll just note for now that the best interest of the child principle has attained the status of customary international law, and it is present in the United States domestic legislation. Additionally, some provision of other international treaties regarding the right to education have been integrated into U.S. legislation, as my colleague Caitlin will note later on. The right to education is not only a fundamental right in itself, but it also enables individuals to realize other civil, political, cultural, economic, and social rights. Because education promotes individual freedom and empowerment and yields important development benefits, the Committee on Economic, Social, and Cultural Rights has strongly suggested that countries should not take retrogressive measures in relation to the right to education on the basis of availability of resources. In practice, that means that the United States should not argue that a lack of funding prohibits the implementation of a policy to help counter discrimination, including those in the education sector. In conclusion, under international human rights law, it is the duty of every country, including the United States, to ensure full access to education under equal conditions to every person within its territory, regardless of their immigration status. I will now hand it over to Caitlin to address the domestic legal framework.
Thank you, Raimi, for that overview of the relevant international law. I will now provide a brief general outline of the domestic legal framework that guided our research and explain the standards to which states, districts, and schools are held accountable under our federal law. My colleagues will delve further into the specific provisions applicable to each subsection of our findings later in this presentation. The legal framework that protects the educational rights of undocumented children can be divided into two subsections. First, the civil rights-based framework, which focuses on preventing discrimination and promoting equal access to education. And secondly, funding structures that mandate the provision of services necessary to meet the needs of undocumented children. The education system in the United States is largely decentralized and managed by the individual states. As a result, our findings varied across states, and especially between districts that welcomed new immigrant populations and those with historically large immigrant populations. However, at the larger level, federal statutory law and jurisprudence dictate standards for which all states, districts, and schools are held accountable. And there is strong legal precedent that protects the educational rights of undocumented children in the public education system. First, federal law prohibits discrimination based on race and/or national origin in the public education system. The Supreme Court first recognized in Plyler v. Doe in 1982 that the Equal Protection Clause of the 14th Amendment prohibited districts from denying children enrollment in school due to their immigration status. In that case, a class of school-aged children, originally from Mexico, were excluded from enrollment in Smith County, Texas, because they had not established legal residency in the United States. In their ruling, the Supreme Court proclaimed that, quote, education has a fundamental role in maintaining the fabric of our society. We cannot ignore the significant costs borne by our nation when select groups are denied the means to absorb the values and skills upon which our social order rests. The court goes on to explain that the inability to read and write creates a great toll on the well-being of the individual. The value placed on education as a requisite tool for individual achievement was echoed in the communities we visited. The Civil Rights Act of 1964 and the Equal Educational Opportunities Act of 1974 are two pieces of legislation that help to implement the Plyler Court's holding. Title VI of the Civil Rights Act of 1964 prohibits recipients of federal funds from discriminating based on race, color, and national origin. All states receive some version of federal assistance for their education programs, and those districts that benefit from the funding are bound by the terms of Title VI. Additionally, the Supreme Court held in Lau v. Nichols that under Title VI, all institutions that receive federal funding must ensure that English learners are given the same meaningful opportunity to participate in their education as their English-speaking counterparts. The Equal Educational Opportunities Act of 1974 requires states and school districts to, quote, take appropriate action to overcome language barriers that impede equal participation by its students in its institutional programs. The U.S. Department of Education and the U.S. Department of Justice have issued guidance notifying states of their legal obligations. Some of the guidance is issued in direct response to reports of discriminatory behavior. These policy guidance also outline best practices to provide adequate services and to facilitate enrollment, including recommendations for alternative enrollment documentation. Relevant policy guidance that has been recently released by the two agencies include the January 2015 Guidance to Ensure English Learner Students Have Access to High-Quality Education, and the May 2014 Guidance for School Districts to Ensure Equal Access for All Children to Public Schools regardless of immigrant status, which can be found in the appendices of our report. Secondly, federal funding structures specifically provide for the implementation of programs to meet the needs of newly arrived immigrant children. As mentioned previously, all states receive some form of federal educational assistance, and those resources can help to supplement state budgets, especially to meet the needs of specific populations. The Elementary and Secondary Education Act is the primary source of federal funding. It was reauthorized in 2012 by the No Child Left Behind Act, and more recently by the Every Student Succeeds Act in 2015. The Elementary and Secondary Education Act and its successors mandate the allocation of funds to provide specific assistance for language instruction of English learners. Under both the civil rights-based frameworks and the funding structures I have described, there is substantial legal precedent to protect undocumented children's rights to equal access to and meaningful participation in their education. We found, however, that compliance with these laws was uneven due to a lack of knowledge, lack of resources, and purposeful discrimination. As a result, undocumented students were denied their educational rights provided for both under international law and federal law. I will now turn it back over to my colleague, Swati.
Our findings can be broken down into three main categories: barriers to enrollment, language accommodation, and ICE enforcement operations and their impact on access to education. Over the course of our research, we encountered school and school district practices that both discourage and delay the enrollment of undocumented children into the public education system. The first panel you will all be hearing from today will discuss our findings related to barriers to enrollment. My colleague Zinande will begin by discussing issues related to documentation.
Thank you, Shruti. I will be dealing with challenges faced by undocumented families in meeting residency documentation requirements for the purposes of enrollment. Education is a matter dealt with at state level. To this end, states set general requirements for access to free public education. Both North Carolina and Texas, as most other states in the United States, set age and residency or domiciliary requirements for the enrollment in public schools. However, districts have a lot of leeway in their application of these requirements and in determining what suffices to establish, for example, that a person is a resident in the district as required by state law. In setting and applying enrollment procedures, states and districts are limited in their discretion by Supreme Court judgments that provide that these processes cannot be discriminatory or too burdensome. We found in our research that issues relating to the establishment of residency are twofold. They relate to producing acceptable documentation for the proof of residency and guardianship. In enforcing residency requirements, most districts require traditional forms of documentation, such as a lease, a bill, or a payslip. During our research, we found that many undocumented families have no formal documents linking their names to their homes, and thus may fail to meet the proof of residency requirement even when they live in the district. A common reason for this is that many undocumented or mixed families or unaccompanied minors live in doubled-up households, such as sharing homes with multiple other undocumented or mixed families. People living in these situations typically do not have documents linking them to the homes that they live in. Because of their status, people are wary of providing documents that could lead to attention, that could bring attention to their status. So requiring families to give affidavits from leaseholders or landlords is not as easy for this community as may be expected. We spoke to a service provider in Houston who had a case with an undocumented mother who was trying to enroll her recently arrived child. She was living with her employer in a doubled-up situation after having moved around for a few times. The school would only accept a bill, a lease, or an affidavit from the person she was living with. But her boss was unwilling to provide her with an affidavit, and only after the practitioner advocated on her behalf was she able to enroll her child. This can have the effect of unnecessarily delaying or even preventing the enrollment of learners. We came across a number of accounts from various practitioners and advocates that were very similar to the experience I have just set out. And this is worrying because only a small number of undocumented families have access to service providers that are able to advocate on their behalf in this way. The issue of proving guardianship is usually encountered by unaccompanied minors that travel to the United States alone and do not have parents or guardians that live here. When children arrive, the federal government processes them and releases them as soon as possible to wait out their immigration proceedings in the communities. The government tries to reunite the children with their parents or legal guardians, but this is not always possible. In these instances, children are released to qualifying sponsors that are usually family friends or other relatives. Issues arise when children living with sponsors that are not their legal guardians attempt to enroll in school. The sponsor-sponsee relationship does not create a legal guardianship relationship. There is sometimes pushback when someone without legal control over the child attempts to enroll her. Attempts have been made through advocacy by practitioners to try and have schools accept documents from the federal government that are given to sponsors when the children are released to them. This is usually the only document available that links the child to the sponsor. This has been useful in many ways, but practitioners pointed to issues that arise in cases where the sponsor-sponsee relationship breaks down and the child leaves, or the child leaves to live somewhere else for other reasons. This can give rise to relationships that school officials are not used to seeing. And these caretakers have additional issues enrolling children because they do not have legal guardianship and they do not have access to federal government documents that are given to them upon release of the child. We were told of a 14-year-old who left her sponsor to live with her 18-year-old sister School officials told her that her sister could not be her caretaker because she was already enrolled in school. The sister. Her ability to enroll was significantly delayed as a result. As a way to illustrate how other states have tried to clarify ways in which this community can be best accommodated in the context of school enrollment, I will refer to recent actions taken by the state of New York. After a number of reports detailing challenges faced by undocumented children when attempting to enroll in school, the state of New York amended its regulations to provide guidance on how districts can comply with their obligations to accommodate the needs of undocumented families. The regulations set out documents that a school is allowed to request, set out documents that a school is not allowed to request, and provides a non-exhaustive list of appropriate documents to request. The regulations also stress flexibility on the part of schools when applying the requirements so as not to unnecessarily delay the enrollment of learners. In light of our findings and actions of other states dealing with similar situations, our recommendations include: states and districts should evaluate and revise their enrollment procedures to ensure that residency requirements do not act as a bar to families not able to provide traditional forms of documentation to prove residency. And states should amend their enrollment procedures to recognize alternative means by which a person can show responsibility for a child for the purposes of guardianship. I will now be dealing with testing considerations in the enrollment process. States generally only require that a child that intends to enroll in a school meet the age limits and is a resident in the relevant school district. However, during our fact-finding, we encountered instances where schools implemented intentional and unintentional policies that effectively delay and ultimately discourage enrollment, such as considering the performance standards in deciding whether or not to enroll their child. The performance of school districts and individual schools is evaluated through the use of statewide standardized testing. Schools were sometimes reluctant to admit immigrant children, especially right before or during a testing period, for fear that their testing scores will negatively impact the school's performance reviews. Students were either told or encouraged to come back to enroll after the testing period. This can prove extremely burdensome for many undocumented families that have limited access to transportation and usually have to miss a full day of work so that they can go and enroll their child. Some families do not come back to try and enroll again. Federal law prohibits the anticipation of poor performance as a test. Federal law prohibits the anticipation of poor performance on tests as a factor in enrollment decisions. Testing, however, plays a large role in the monitoring and evaluation of state education systems, particularly those of high school students. To try and deal with the effects of the centrality of testing, under the No Child Left Behind Act, a school was able to apply for a waiver, but that only applied for the first academic year that the child was enrolled in the school. One academic year is not enough time to ensure that a child is proficient for the purposes of testing, particularly because the children that we are speaking of are usually already behind in their formal education. An important development came with the recently reauthorized Every Student Succeeds Act, which replaces the No Child Left Behind Act. It has attempted to move away from extensive testing and has given states some autonomy in setting accountability systems, which can include non-testing measures in assessment. This is an opportunity for states and districts to take measures that work in their context to best deal with the effect of placing too much emphasis on testing. We found during our research that the incidence of the consideration of testing varied across states. This was usually determined by the state's or district's experience in dealing with newcomer immigrant communities. For example, we did not encounter many instances of testing considerations as barriers to student enrollment in Texas. Texas has a long history of having immigrant communities and has statewide programs in place to better accommodate English learners within the testing framework. By contrast, North Carolina, which has a relatively new but growing immigrant population, we found that delays in enrollment due to testing considerations were relatively common. One 17-year-old was told that she could not start until after exams, delaying her enrollment by 4 weeks. In this regard, our recommendations include: states should take advantage of the Every Student Succeeds Act's expanded discretion and move away from depending on testing scores as a means of assessment. The Education Department should give blanket exemption from testing to all recently arrived students and not leave it to individual schools to apply for exemption. I will now hand it over to my colleague, Caitlin, who will be discussing age discrimination in the enrollment process.
Thank you, Zenande. Similar to testing considerations, we found that some schools intentionally delay or deny enrollment for undocumented children based on concerns about their age as it relates to grade placement and prospects of graduation. To provide context, recently arrived children are often behind the educational levels of their domestically born, similarly aged peers. The discrepancy can be attributed to interruptions in their formal education due to the situations in their countries of origin, differences in educational standards of their countries of origin, and those of the United States, or their inability to speak, read, or write English. Sometimes they have no record of their academic accomplishments or are unable to provide transcripts. In effect, undocumented children have often not satisfied or are unable to prove that they have satisfied the academic standards and credit requirements expected for children their age. As a result, schools worry that older undocumented children will surpass the state-mandated maximum age for enrollment before graduating. And if they do enroll them, schools struggle to place children in grades that are both appropriate for their age and their learning level. However, national and international human rights law prohibits this type of exclusion based on age. International human rights law obligates the United States to eliminate all discriminatory practices towards undocumented children. Domestically, federal law prohibits discrimination on the basis of age in the public education system, specifically under the Age Discrimination Act of 1975. At the state level, the age range for enrollment in public education varies. As Zenande explained, in North Carolina and Texas, children who meet residency requirements are guaranteed free public education until they turn 21. Texas law even grants districts the discretion to enroll children until they are 26. Further, not only are eligible students guaranteed enrollment, but compulsory state laws mandate children's enrollment. Despite these legal protections, we found that older students are sometimes delayed or discouraged from enrolling. Illustrative of the pervasiveness of these practices, a school district official in Texas told us that age-related discrimination and enrollment was the most prevalent issue that she faced in 2015. First, schools worry about older children surpassing the maximum age for enrollment before graduating, known as aging out of the system. It happens, for example, when a 17-year-old is enrolled in 9th grade in North Carolina or Texas and is unable to meet the requirements of a 12th grader before reaching 21. We learned that children that age out count towards schools' dropout rates, and that those dropout rates reflect poorly on schools' performance rates, which reward high graduation rates. As a result, schools discourage the enrollment of older children that are expected to age out, or encourage their enrollment in alternative education programs such as GED classes or community college. For example, parents in North Carolina told us that schools ignored their older children's enrollment efforts. Additionally, a complaint filed against several school districts in North Carolina describes the story of 2 unaccompanied children that were directed to enroll in GED programs because they were quote-unquote too old to enroll as 17-year-olds. The complaint asserts that, quote, age is used as a pretext for denying enrollment based on national origin or limited English proficiency. We found similar examples in Texas, where school officials referred older children between the ages of 16 and 18 to adult education programs and community colleges. We read that similar practices were reported in New York and Florida, where formal investigations and suits were underway in response to reports of age discrimination against children ages 16 and 18, respectively. Secondly, if a child is behind the academic level of her peers or is unable to produce a transcript, schools are presented with a real challenge of placing her in a grade that is both appropriate for her learning level and her age. We found that students are often enrolled in classes with children that are much younger than they are, making them uncomfortable and preventing them from graduating before aging out. As one example, a girl told us that she was enrolled in the 10th grade in Guatemala as a 17-year-old. Instead of moving on to the 11th grade upon immigrating to the United States, she was enrolled by her high school in the 9th grade, where she was 3 years older than her peers. She explained that the school discriminated against older students, imposing a no leniency attendance policy under which the repercussions for missing a day of school were much more pronounced for her than they would be for a younger child that did the same. Further, we found out that in Texas, one district enrolled any high school-age child without access to her transcripts in the 9th grade by default. These practices I've discussed effectively exclude older children or limit their participation in their education. In response, we recommend the following. First, in order to remove an incentive to bar older children from enrolling, we recommend that states and school districts should redefine performance metrics to exclude children that age out from their dropout rates. Second, in determining grade placement, schools should balance age and academic level with the goal of creating an opportunity for the student to graduate before aging out. And lastly, states should issue guidance to districts on their obligations to enroll students who are within the age range for whom free education must be offered. And districts should ensure that schools fulfill their obligation to enroll all eligible children. I will now hand it over to my colleague, Alex.
Thank you, Caitlin. In our research, we documented that some districts, rather than creating programs to accommodate undocumented students, particularly older students, forcibly enrolled students without proper documentation in alternative schools intended for children with correctional or behavioral needs. To provide some context, at the federal level, forced segregation based on national origin is expressly prohibited. The Equal Educational Opportunities Act, for example, forbids states from denying equal educational opportunity to an individual on account of his or her national origin, and requires educational agencies to take appropriate action to overcome language barriers that could impede a child's participation in school. Many states, including Texas and North Carolina, have adopted similar provisions that restrict forced enrollment. Despite this clear legal foundation, we found documented instances where schools operate contrary to the law in both rural and urban settings. In rural Texas, for example, we documented instances where a school district forced undocumented students to enroll in a correctional school intended for students with behavioral issues. One mother recounted how a school told her they would not accept her son because, quote, he doesn't know anything, and told her she could only enroll her son in an alternative school intended for students with correctional needs. We also documented similar practices in urban school districts. For example, one practitioner told us of a 14-year-old boy who was pushed to enroll in an alternative correctional high school due to the perception that he was able to keep up with his peers and would serve as a danger to his peers even. Our findings correspond with documented instances of forced enrollment in New York and Florida. In New York, for example, just this last November in 2015, the New York Attorney General launched a class action lawsuit against the Utica School District for its policy and practice of excluding immigrant students from a well-known high school and diverting them into an unequal educational institution. Similarly, in Florida, the U.S. Justice Department sent Palm Beach County a letter in 2015 citing instances where students with interrupted formal education felt pushed into charter schools, alternative schools, and adult education programs. In response to these findings, our fact-finding team proposes a series of recommendations. First, the U.S. Department of Education should issue further guidance to schools regarding what practices amount to forced enrollment and how to respect families' rights to choose alternative placement opportunities. School districts should not force undocumented students into alternative schools and learning programs for discriminatory purposes. And finally, schools should strengthen translation and interpretation services to ensure that parents can consent to alternative placement programs. I will now hand it over to my colleague Genevieve.
Hello, everyone. So far this morning, you've heard about barriers to enrollment and stories of struggle and frustration, but we don't want to leave you completely discouraged. There are ways to help undocumented children and their families enroll in school. In some cases, there are already mechanisms in place to help with enrollment. They just have to be fully implemented. In other cases, there are best practices that can be replicated. I'm going to speak to you this morning about two different ways to improve enrollment for undocumented children. First, I'll speak about the federal McKinney-Vento Act And second, I'll talk about the 30-day grace period for submitting enrollment documentation. The McKinney-Vento Act was passed in the 1980s in response to a growing homeless population. Part of the act addressed education for homeless children. It recognized that homeless children face unique challenges, including high changes in residence or lack thereof, inability to access transportation, and in some cases, lack of a guardian. Because of these challenges, homeless children may be missing the documentation they need to enroll in school. The McKinney-Vento Act imposed a broad mandate for states and school districts to remove barriers to enrollment for homeless children. In part, this requires immediate enrollment of a child who is identified as homeless and lacking a fixed, regular, and adequate nighttime residence, even if they do not have all the required documentation needed to enroll in school. Now, when we think about someone who is homeless, we usually think of somebody who's staying on the street or in a homeless shelter. However, the definition is far more broad and may include when children are living in apartments or homes with multiple families. Sanand referenced this as a doubled up situation. Doubled up situations are often overcrowded and not permanent, and this can be a common situation for undocumented children. We found that some school districts are able to identify these types of living situations and apply McKinney-Vento to help enroll undocumented children who do qualify as homeless. In one district, it was described as a saving grace for enrolling undocumented children. However, we also found that in some rural school districts, there was a lack of understanding about the McKinney-Vento Act and how it would apply to different living situations, especially living situations that are common for undocumented children. For instance, we found that a school counselor refused to apply McKinney-Vento to a doubled-up situation until a service provider offered guidance about the scope of the act. While we are not advocating for school districts to ask about immigration status for enrollment, we are asking that school districts learn the different variations of homelessness, especially those that are common for undocumented children, and apply McKinney-Vento accordingly to get them enrolled in school. While there are some undocumented children that will fall under the McKinney-Vento Act and their enrollment will be easier, not all undocumented children live in situations that qualify as homeless. Nevertheless, they face similar challenges in gathering the required documentation to enroll in school. In some cases, they've traveled thousands of miles and often do not have school or birth records. Another remedy for helping undocumented children enroll is a policy of enrolling children first and then giving a 30-day grace period to turn in documentation that is missing. Again, we are not advocating that schools should ask children's immigration status. However, implementing this 30-day grace period will help undocumented children enroll in school. We found one 30-day grace period best practice in the Houston Independent School District. The policy states that no student may be denied enrollment solely because of a failure to meet documentation requirements. Texas law more generally allows for school districts to implement this type of policy, stating that records for enrollment must be presented no later than the 30th day after the child is enrolled. In North Carolina, the 30-day policy only applies to immunization records and not all documentation. The 30-day grace period policy should be implemented more broadly and should include all documentation. We found that even when the policy is in place, that schools do not always inform parents about the 30-day grace period that can and should be offered to them. The 30-day grace period policy is important for many reasons. First, it is important for children to be in class and not get further behind in school. Many undocumented children have interrupted schooling, and delaying enrollment only places students further behind. Furthermore, the 30-day grace period helps parents, guardians, and sponsors to gather all the documentation that's needed. Without the grace period, we found that parents are forced to miss multiple days of work, gathering documentation, and making trips back and forth to school. This may force parents to make difficult decisions between enrolling their children in school and missing work. A 30-day grace period would help children immediately gain the benefits of being in school, while also helping parents, sponsors, and guardians with gathering the documentation. Understanding and applying the McKinney-Vento Act and implementing a 30-day grace period are two distinct solutions for helping undocumented children enroll in public schools. We recommend that the Department of Education and states provide guidance to schools and school districts regarding the various forms of homelessness that qualify under McKinney-Vento, especially the situations that undocumented children commonly live in. Next, states should permit a 30-day grace period, and schools should implement this grace period. Furthermore, the Office of Refugee Resettlement should distribute information to sponsors, parents, and guardians about the McKinney-Vento Act and how it applies to school enrollment. Lastly, we want to remind you that these are solutions to helping undocumented children enroll. It is not impossible to address enrollment barriers for undocumented children. Our report offers solutions and best practices, and we challenge federal and state authorities to make these changes so that children can enroll in school and continue their education.
Thank you to our first panelists for addressing our enrollment barriers findings. Now we will be switching panelists to discuss findings related to language accommodation. In addition to overcoming barriers to enrollment, undocumented children and families who have limited English proficiency face specific challenges in communicating with schools. Although some undocumented individuals may speak proficient English, many have limited English language skills. Children often need their parents and families to assist them in accessing and realizing their right to education, beginning with enrollment and extending to support of academic goals and achievements once a child enters school. Our second panel will be discussing our findings related to language accommodations within schools. My colleague, Caroline, will be speaking to the nature of translated enrollment documents in schools.
Thank you. As you heard in the previous panel, the enrollment process can be extremely difficult for undocumented students and their families to navigate. We found that these problems were exacerbated when schools were unwilling or unable to offer translated enrollment documents. The law requires that schools meaningfully communicate with parents and guardians who primarily speak a language other than English. The Department of Education recently reinforced this obligation by telling school districts that they must communicate information about school programs and services to parents and guardians in the language that they speak. They should also provide documents like enrollment forms, registration forms, and parent handbooks in the parent's primary language. Similarly, under the Every Student Succeeds Act, schools are encouraged to translate all school documents to the extent practicable. We found that some schools did have some translated enrollment documents available, especially in school districts or communities that have a long-standing or larger immigrant population. However, even in these schools and districts, problems were still reported to us due to the specific characteristics of undocumented and newly arrived immigrant populations. Typically, where translated documents are provided, they are only translated into Spanish. However, many undocumented Central American families speak languages other than Spanish and often have low levels of literacy even in their primary language, so they may still have problems understanding the enrollment process and the forms. Another problem arose when parents tried to find the translated enrollment forms and information on district and school websites. Because the majority of the content on school websites is in English, parents struggle to navigate the web pages to find the relevant translated documents and information. We were also told of administrators and school officials being unaware that translated documents were available, or not giving them to parents when the school district had translated copies. We also found that some school districts lacked sufficient translated documents, especially in districts that had smaller or more recent immigrant populations. One mother told us that she found the enrollment process overwhelming because she did not know any English. She was not able to enroll her child until she had the help of an English-speaking relative, because no one in the school could translate for her. She told us that the process was so frustrating that it brought her to tears. We heard of many similar struggles from families whose children had delayed or deterred enrollment because the parents could not navigate the enrollment system without access to sufficient translated enrollment documents. Because of the problems a lack of translated enrollment documents cause, we recommend that first, districts make every effort to translate all enrollment documents into the languages most prevalent in their communities. While this can be difficult and costly, especially for the more obscure Central American languages, it should be a high priority for schools because of the impact on enrollment for these children. Second, we recommend that districts utilize translation services to facilitate the enrollment process if no staff on site can translate for them. My colleague Michaela will now discuss other difficulties that schools have encountered in communicating with the families of undocumented children.
Thank you, Caroline. Language barriers also have the ability to impede family members' involvement in an undocumented child's education. Although we found that many schools struggle to interact with limited English proficient families, others are making strong and unique efforts to overcome these challenges, recognizing that lines of communication and relationship building are essential. In order for undocumented children in particular to properly exercise their right to education, the form and substance of the education, including curricula and teaching methods, have to be relevant and culturally appropriate to students, and in appropriate cases such as this, to their parents. Additionally, our findings highlight the importance for parents to understand when their children are having behavioral issues at school so that they may adequately address and respond to these issues and foster growth in their children. Disciplinary issues can prove especially detrimental to this population because undocumented children are often considered to be at risk of dropping out of school. The further exclusion of their parents from the disciplinary process of the school can leave both children and parents unaware of what happened. As you previously heard, the Every Student Succeeds Act has changed some of the previous rules. One specific change that relates to this topic is in regards to effective parent and family engagement with parents of English learners, including specifying the need to provide report cards to the extent practicable in a language that parents can understand. While this new standard is an improvement, it still leaves much to an individual school district's discretion, which presents both the possibility of innovation and that of stagnation. Our interview showed that many schools struggle to communicate with limited English proficient families, including in the communication of student records, like report cards and disciplinary proceedings. In Texas, we learned that the outreach to parents typically fell to newcomer programs where they existed because newcomer programs often have a dedicated parent liaison. Such liaisons facilitate parent groups, assist with teacher conferences, and work to increase parent involvement. Children and parents in schools or districts without parent liaisons may lack a way to interact with schools. In North Carolina, a state with a much newer newcomer population, we heard it was often a challenge to find someone who spoke Spanish in the schools. We heard further reports that some schools wouldn't or couldn't provide translations of report cards, and that sometimes, even where translated copies were provided, they were done so poorly they weren't even comprehensible. And as previously mentioned, sometimes offering Spanish translation isn't enough, as some limited English proficient families aren't literate in Spanish or speak only indigenous languages. To address this, schools must find more creative ways to communicate with parents. This reality illustrates the need for varying and nuanced approaches to accommodating parents that allow for their meaningful participation in their children's education.
When family involvement decreases, it negatively impacts the student support system at home, just as it would for any child. We heard, though, that it is often abnormally challenging for these students to find someone in the school system who they can communicate with to replace the support missing at home. However, some schools and organizations are working hard to ensure these children have strong support systems at home and at school to enable them to be successful. We found some promising practices that had been developed at one middle school to bridge communication barriers with limited English proficient families and keep them informed. They offer an anonymous phone line that parents can leave comments and concerns on. They also use a color-coded system in student planners to mark progress or problems based on general color norms: green for good, yellow needs improvement, and red for the need for redirection. This more easily allows limited English proficient families to be aware of their students' academic situation and classroom performance, no matter what language the family speaks. Other solutions we heard of included automated Spanish telephone messages for those families that are identified as Spanish-speaking, sending report cards home in Spanish with translations of teacher comments, and forums where non-English speaking families can engage with the school and with each other. For example, some schools arrange breakfasts where parents can meet with English language teachers. We also saw community organizations and advocates trying to fill the void left in school outreach through their own programming. Some unique outreach we learned about included working with parents to help them get involved with their school's parent-teacher associations, assisting families in communicating with school officials, attending both individual and group parent meetings to serve as interpreters, and hosting parent meetings for limited English proficient families to provide them with information and answer questions in a language they can understand. For children with disabilities, there are further specific federal and state regulations requiring communication with parents that my colleague Caroline will address.
Thank you. As Michaela mentioned, there are special communication provisions for families who have a student with a disability. The Individuals with Disabilities Education Act gives the parents of a child with a disability the right to fully participate in the planning of their child's education. Part of this planning includes the creation of an Individualized Education Plan, or IEP, which are given to students with disabilities in order to help them successfully learn and grow in schools. Individualized education plans often include life skills, goals, and learning strategies that are to be used both in school and at home. To effectively participate and support their child's education, parents must understand the Individualized Education Plan, and when a parent does not speak or read the language that it is written in, this is considered to be a failure by the school to provide an appropriate education for a student with a disability. We found that some states, like Texas, require the plan to be written and audio taped in Spanish or, where practicable, into any other native language. Laws like this assist not only with translation, but also help to address the low literacy levels that some parents have. Other states do not require the translation of the actual document, and some states use a software program to generate individualized education plans. This program will only produce a plan in English. In these cases, teachers and schools are often not allowed to give parents a written translation of the document. We spoke to a teacher who told us that this was insufficient to meet the goals of an individualized education plan, because parents might not fully understand how to help their child and reinforce behaviors, strategies, and skills that are used in the schools. Because of the various problems that schools have generally communicating with parents and families, we make the following 4 recommendations. First, that the U.S. Department of Education should identify promising practices and develop guidance to release to state agencies and schools to improve and implement the family communication strategies encouraged by the Every Student Succeeds Act. Second, that the U.S. Department of Education should support districts in leveraging their resources to obtain translation services while taking budget considerations into account to help schools comply with communication requirements under the Every Student Succeeds Act. Third, that districts with large immigrant populations should prioritize funds to hire parent liaisons and also develop relationships with community organizations who can help schools to more effectively engage and communicate with parents and families. Finally, that districts should ensure schools effectively communicate and translate all student records for parents, including disciplinary actions and individualized education plans.
In January of 2016, Immigration and Customs Enforcement, ICE, initiated a series of immigration enforcement operations targeting recent arrivals from Central America. These operations are causing widespread fear and panic throughout immigrant communities across the nation that is severely disrupting people's day-to-day lives. Our research documented that the enforcement actions are having a chilling effect on a child's ability to meaningfully participate in their education. Our third panel will be discussing the impact of ICE targeted enforcement on families and on access to education for undocumented children. My colleague Alex will get the third panel started.
So in early January, just weeks before we started our fact-finding, Immigrations and Customs Enforcement, otherwise known as ICE, initiated concerted immigration enforcement operations in immigrant communities across the nation, targeting families, including mothers and children fleeing violence in Central America. We found that as news and rumors about the operations spread throughout North Carolina and Texas, they created a climate of fear among immigrants, and that fear was adversely impacting undocumented children's access to education. Parents are too afraid to let their children go to school. Children are afraid to go to school both because they're scared for their own safety, but also because they're afraid that while they're at school, their parents will be apprehended and deported and their families torn apart. ICE's most recent immigration enforcement operations include its roundups on January 2nd and 3rd and Operation Border Guardian. During the January 2nd and 3rd roundup in Georgia, Texas, and North Carolina, ICE targeted undocumented mothers and their children who entered the states January 1st, 2014 or later and apprehended 121 individuals. In Operation Border Guardian, which began January 23rd, ICE began a nationwide effort to target undocumented youth who entered the states January 1st, 2014 or later and are now 18 years or older. As of March 9th, the operation has netted 336 individuals to be deported. The enforcement operations and the fear they have created are problematic for a number of reasons. As mentioned, parents are afraid to let their children leave home, and children are scared both for themselves as well as for their parents, who they don't want to be separated from. As a result, undocumented youth are missing days on end of school. Research shows that chronic absenteeism has a negative impact on children's learning. The result is presumably only all the more pronounced among children like the ones we researched, who are already behind because of the legal, social, and cultural barriers that my colleagues addressed. To make matters worse, most schools are at a loss how to respond and have little to no guidance from local, state, or federal officials. They do not know how to react if ICE intervenes on their campuses or how best to calm frightened students. However, some school districts like Durham Public Schools and Los Angeles Unified School District have taken action and issued resolutions condemning the recent ICE operations and the fear that they create. In addition, on April 7th, over 50 educational institutions, including the Chicago Public Schools, joined United We Dream and its institutional and state partners in a National Coming Out Day in support of undocumented youth. Our own university, Georgetown, is itself committed to supporting undocumented students. The school supported student groups Hoyas for Immigrant Rights and Undocu-Hoyas when they partnered with United We Dream to help execute its 2015 National Coming Out Day, and has convened a working group to focus on strategies to support undocumented students on campus. Before I hand things over to my colleague Rami, who will discuss our Texas and North Carolina findings, I just wanted to briefly touch on two additional points. First, in 2011, years before widespread public awareness of the influx in migrants across the border, ICE adopted a policy memorandum that it would not conduct immigration enforcement operations at or near sensitive locations, including schools, churches, funerals, or public demonstrations. But this policy is self-imposed and can be revoked at any time, and there are a number of important exceptions to the rule. ICE can still apprehend people on their way to and from sensitive locations, obtain records, documents, and similar materials from officials or employees at sensitive locations, and conduct enforcement operations at a sensitive location if other law enforcement agents led them there. The memo has so many shortcomings, undocumented children and their advocates aren't sure what protections they have in relation to ICE. More importantly, the reality is people are afraid. The ICE operations have created a climate of fear that a policy memo like ICE's is not going to address. It is hard enough paying attention in school when you're young. Imagine, though, that on top of everything else, on top of mastering the material, getting good grades, navigating the social scene. You have to worry about your parents being apprehended by federal agents and deported. You try to listen to what the teacher says, but you can't pay attention because you're gripped by fear. These fears are not something a policy memo like ICE's is comprehensive enough to solve. Second, although ICE refers to its actions as immigration enforcement operations, for the people affected, these are effectively raids and not something neutral like an enforcement operation. Raimi will use the word raids in describing our findings.
Thank you, Alex. We visited Texas and North Carolina in January, just 1 week after the announcement and implementation of the recent ICE operation. In North Carolina, we heard of a 13-year-old girl who often told her caseworker how much she loved going to school in the United States and riding the bus with her friends. But now, she's afraid to go to school or to even just stand at the bus stop and wait for the school bus. As news and rumors of individuals being picked up and raised throughout North Carolina spread, migrant parents and children became fearful and were often afraid to leave their homes. We heard from numerous school officials, teachers, parents, children, community advocates, and caseworkers on the effect that the recent ICE operation has on children's right to education. A lot of kids are choosing to drop out because they are so scared to even try to go to school. We heard how the announcement of the raids is definitely affecting the school climate as a whole. Fear about the raids is also causing many children to worry about their family members and whether their parents will still be at home when they get back from school, as Alex indicated. Just 1 week after the announcement of the enforcement operation, one community program in North Carolina registered a large decrease in attendance. They were unable to get in touch with 10 of their students in that week. Regarding children recently released from detention facilities, some parents were hesitant to enroll their children in school because of the raids. The parents feared that the school might report the child or the family to immigration authorities if they attempted to enroll. Many migrant children are so scared they're actually in danger of dropping out of school due to lack of attendance, and some parents are keeping their children at home. One mother from Central America, whose child had already been recognized as a refugee, told us she was fearful for the raids, even though both her and her child had a valid legal status in the United States. In Texas, during our interview in January, we learned that families without documentation were moving or attempting to move to other places to prevent ICE officials from locating them. Many families would rather move and start over somewhere else than stay put and risk being deported from the United States and sent back to countries from which they fled extreme crime and violence. A social worker explained to us how she's working hard to reassure undocumented children and families that school is safe, that parents should not pull their children from school because of the raids. It deeply concerns us that some students who come to school get so worried they pretend to be sick just so they can be excused and rush back home and check if their parents were apprehended and taken away by ICE. In general, we found that the recent ICE raids have negatively impacted undocumented children by keeping them out of the classroom and impeding their education. Most importantly, another factor we identified is that schools don't know how to respond to these enforcement operations. We found no indication that schools knew what their options were if ICE were to show up on campus looking for an undocumented child or a family. Both in Texas and North Carolina, school officials reported that they have not been told what to do if ICE came to school seeking a child, but stated that they would contact their school district legal team to ask for guidance before making a final decision. As Alex indicated, some school districts like Durham Public School in North Carolina have adopted resolution opposing the recent ICE enforcement actions and demanding that ICE suspend the operation and release detained children to their families. Several school districts in California have called on their teacher and other staff not to admit ICE on campus without approval from school superintendent and district lawyers. Meanwhile, in Maryland, officials in Montgomery County have taken steps to reassure the immigrant population and dissolve fear by declaring that county police will not assist ICE in conducting raids and enforcing federal immigration law. Finally, officials in Prince George's County are working with community-based organizations and faith-based partners to support families impacted by ICE recent operations. Given these findings, Alex will now present our recommendation.
So we make the following 5 recommendations. First, that the U.S. Department of Homeland Security and U.S. Department of Education continue engaging in an interagency conversation to discuss how ICE can conduct enforcement actions without disrupting children's access to education. Second, ICE should, consistent with its internal policies, continue to refrain in immigration enforcement operations on school campuses and expand protections to cover children participating in school activities and on their way to school. Third, the U.S. Department of Education should administer guidance to schools regarding ICE procedures and the legal options available to them if ICE engages in enforcement operations on their campuses. Fourth, the U.S. Department of Education should adopt mechanisms similar to the U.S. Department of Labor's practice, allowing the department to request stays of removal for migrants whose complaints are being reviewed by the Department of Education's Office for Civil Rights. Fifth, more school districts and schools should consider adopting resolutions opposing ICE's recent enforcement operations and condemn their negative impact on school children, such as those we highlighted in North Carolina and California.
Education and immigration reform are both at the forefront of the political agenda of 2016. The recent reauthorization of the Every Student Succeeds Act in 2015 holds states more directly responsible for evaluating and addressing student success in schools. With the upcoming presidential election, immigration policy is especially highlighted in conversations among local, state, and federal authorities. In recent years, much of the focus of these conversations has been on the number of children coming to the United States seeking protection. We found that recently arriving children, particularly undocumented children, encounter numerous obstacles in school enrollment. Often, lack of documentation prohibits undocumented children from accessing education to which they have a right under U.S. law and international law. In addition to overcoming barriers to enrollment, undocumented children who are able to successfully enroll are not able to access resources once they enter school. Many recently arriving undocumented children come from backgrounds plagued with violence and hardship, resulting in trauma and little history of formal education. The majority of children arrive with low literacy rates and little to no English language skills. In states and communities with historically small immigrant populations, school districts and staff are faced with new challenges in adapting to and adequately serving this rapidly changing population. Even in communities with well-established immigrant presence, challenges arise in meeting the needs of communities and undocumented children within the public education system. Additionally, recent ICE enforcement actions targeted at school-aged children have fostered fear and anxiety for undocumented children and have had a chilling effect on their ability to meaningfully participate in their education. Although schools have witnessed the harmful effect of recent ICE raids, they lack protocols on how to properly respond. Upon entering the United States, children, including undocumented children, have the right and the legal obligation to enroll in school. We hope educators can replicate model solutions presented to you today in our panels and identified in our report, and modify practices that currently result in shortcomings to ensure that all legal obligations, both international and domestic, are met. The United States has a long and strong history of leadership in access to education and has the potential to serve these children so that they can be productive members of our communities. Thank you so much for spending your morning with us, and please feel free to ask us any questions at this time. As a reminder, this event is recorded, so any question you ask is on the record. And could you please identify yourself and your affiliation with this event if you do wish to ask a question before you ask it? Yes.
Hi, Jill Morrison, Georgetown University Law Center. I was wondering, in having such strict guardianship requirements for evidence before school enrollment, were there any justifications made by any of the institutions? For example, were they trying to say that they wanted to make sure that non-custodial parents who had kidnapped their children weren't trying to enroll students in schools or anything of the sort? Was there any justification?
My colleague Zanande will be able to answer your question.
The guardianship requirement is, it's the way it's explained in the state legislation is a bit convoluted. It's essentially trying to establish that the child has a link to someone that has a link to the district. That's essentially the reason for the guardianship requirement.
Hi, June Gargis with the Georgetown Human Rights Institute. When looking at some of the barriers to enrollment, particularly with testing and the grade placement requirements, it seems that the state has expressed concerns for the student and their ability to perform in the higher level classrooms. And I know Ms. Callahan mentioned that there could be a better metric for looking at this. And I'm kind of wondering if perhaps it's been discussed what the best metric for balancing the student's interest in graduating and being in a comfortable environment against the state's interest in providing the type of quality education that the student needs for their ability, for their grade level.
Caitlin will directly respond to your question.
I think that's a really good question. I think it's something that states are struggling with finding a solution right now as we're turning to the Every Student Succeeds Act. We didn't look particularly at the metrics that states and schools use to identify their performance metrics. We just heard from both schools and families that that was often the reason why they would tell a family to come back and enroll after testing. I think that a lot of times the testing mechanisms are super standardized and there's not a lot of accommodation made for children that don't necessarily speak English as their first language or might be, as you mentioned, have had interruptions in their formal education. So being mindful of that and potentially providing alternatives there. We heard from some schools that there were options for auditing classes or potentially providing credit and not a grade for accomplishment, so that would not reflect poorly on the school and it would not reflect poorly on the child, but it would give them an opportunity to continue with their education as needed.
Hi, my name is Jean Stroud. I'm from Juvenile Law Center. I was wondering if you ran into or saw any issues with truancy in terms of students who failed to be enrolled in school, who enrolled in school and then when an ICE raid or something like that took place didn't go, if you saw any parents or students facing consequences for truancy, for missing school.
My colleague, Raimi, will answer the question.
Thanks. We didn't see any of the legal consequences of unattendance to school yet, as we went in January, just 1 week after the enforcement. Families, the fear that's spreading out throughout communities is just families are hesitant to send their kids to school and are keeping them home. But we still have not seen the results that this might have, but the attendance and dropout rates will definitely be there, and this will definitely have an impact later on their enrollment in school and their permanence in the school year.
Mariah Trish, Georgetown University Law Center. You guys mentioned the 30-day grace period as one of the solutions to collecting the documentation for enrollment. Did you find that the guardians needed extra time to collect documents, especially in cases when they had employers who were unwilling to sign affidavits and things like that? Would the extra time allow them to collect documents?
So we identified the 30-day grace period as a best practice, and that was a best practice because it would allow children to enroll in school immediately. And that is one of the biggest concerns of delaying the enrollment and continuing to delay children's participation in school. And so giving that 30-day grace period would allow parents to be able to get documents from their home country sent that take a while to gather. And so the priority is to enroll students first and then allow for parents, guardians, and sponsors to gather the information that's necessary to complete enrollment.
Brittany Harwell, I'm Georgetown. I'm a student here. In talking about language translation and increased IEP services for parents, school districts talk a lot about the cost of that, and especially for rural districts. Did you guys find anything like, is there federal responsibility? Is there state response? How does the cost breakdown work? And how do you respond to school districts who can't find the money?
I guess to the first point, and then maybe Caitlin can handle the funding question more specifically. But we recommend that schools and districts offer translation where they can, like so to the extent practicable, in line with the Every Student Succeeds Act. Is a priority. And we also only recommend that they do it for the languages that are most prevalent in their communities. Some of these languages are very obscure. Very small numbers of people speak them in the world generally, let alone in these smaller towns or cities. And some of them don't even have like written language that goes along with it. It's oral only. So there are huge challenges that translate into huge costs for these schools. And that's why we tried to acknowledge that by recommending it only for the languages that are most prevalent, with the hopes that that will encourage schools to do it more generally rather than just writing it off completely as this is going to be too expensive, we can't even bother to try. I don't know if Caitlin has anything to add on the funding. If you do, please do.
I think that pretty much answers the question. I would just add that as we tried to highlight in the legal framework introduction, that there are many programs that provide additional funding assistance from the federal government, and hopefully by bringing light to these particular needs, we can kind of readjust the way these programs are funded, or at least highlight the particular needs of this community. My colleague also just mentioned that there's a lot of other ways to provide translation services now. Technology is a great cost-efficient way to do so. So hopefully by shedding light to these needs, we can kind of come up with solutions to get that funding where it needs to go.
Hi, my name is Wendy Cervantes. I'm with First Focus, and I had a question. As you know, the Department of Education put out guidance in 2014, right after the influx, to remind schools of their responsibility to enroll students, and then put out guidance again in 2015 when they were aware of all the issues that were coming up. And so a lot of your recommendations are around the Department of Education providing more guidance and more regulations or recommendations. And I'm just wondering, to what extent do you think that the guidance that's been issued already been helpful? Is it getting to schools? Is it getting to the people that really need it? Just as I think about if more guidance is issued in the future, how do we make sure that it's really effectively being distributed?
We found that there was great disparities between how districts, the awareness that districts had of the Department of Education guidance. In some instances, we ran to administrators who were aware of it, didn't really know what it meant for their particular district. In other instances, we got blank stares where we mentioned the guidance. So what we hope our report sort of begins is an evaluation of how this guidance trickles down. Where does it go when it goes to districts? And then does it go to an administrator's office and just sits in an inbox? Or is it then is there a discussion that happens within the school? DOE has put out a lot of really excellent guidance, and we just found that there were a lot of gaps in terms of how that reached communities.
If I just may add to what Alex said, it's also, let's think about the enrollment process. A person approaches an office and there's a secretary and an administrative assistant. In a lot of cases, we didn't find that the information was actually getting to the person who is the first contact when these children and parents are attempting to enroll in school.
And if I could also add one more point, I think in each case, there has been already a series of guidance executed, and I think our hope in recommending more guidance is that as it continues to be issued, you can't ignore everything, right? So you can't miss everything, hopefully, so that it will continue to trickle down to a greater extent. And that's also part of the reason that we wanted to include those documents in our appendices to our report, so that someone who maybe picks up the report being interested in this topic as a whole then realizes that, oh, this guidance is here, and they have that copy right there. They don't have to go search it out if they would like to read it even more.
Hi, this is Eric Rosenthal from Disability Rights International. I've been serving as the Drine and Human Rights Chair this year. First of all, let me congratulate you. Just the fact that you turned out this impressive research and report in such a short time is really incredible. Great job. I have two questions. One is, there was some reference to the fact that this population might suffer from high levels of trauma, given their experiences, migrants, and witnessing human rights abuses and experiencing themselves along the way. I'm wondering whether you saw this as something that was a barrier and whether there were accommodations in the schools, and whether, in terms of your recommendations and advocacy, whether kind of recommendations regarding proactive efforts to assure those accommodations might be an issue. That relates to a second question, which is what kind of follow-up and advocacy are you considering for the report? I heard from Patrick, congratulations that you were in the Washington Post and in the national press and Associated Press today. So that's fabulous, and that's going to give you a great springboard for future advocacy, and I'd be interested in what your thoughts are on the next steps.
I can address the first question and then pass it on to Michaela for the advocacy question. But we definitely saw that schools were reporting that students had entered with very traumatic backgrounds and histories of violence, especially during the migration process, and then coming to the United States and enduring the process of assimilating to U.S. culture. The more sad aspect of this was that there weren't many services at schools in terms of social service providers or social workers who were able to speak to these children based on like language barriers. There were numerous obstacles to providing children with the assistance they need in terms of addressing past trauma, and that was unanimous in Texas and North Carolina in terms of a general lack of services provided, and this could be definitely due to a lack of resources and monetary and staff. In terms of advocacy,
I actually have one point to add to that. Currently, mental health care within the United States generally has a ways to go, and at the school level, even more so. There is pending litigation in California regarding this issue, as well as there have been efforts by a Harvard Law Clinic to implement in the Massachusetts Code laws regarding access to trauma care. In relating to advocacy, we created 2-pagers that are part of the appendix to our work, which will be distributed to a lot of the contacts that we interviewed for the report, that they can release it to their clients regarding quick fact sheets regarding their rights, regarding ICE, regarding access to education, regarding enrollment. So we've provided that, and we will also be working with the Women's Refugee Commission to further this outreach that we're able to do.
If I may add, we are also providing later on, we're translating the report to Spanish to also reach out to these communities who are mainly Spanish-speaking communities.
First of all, thank you very much. This was incredible. Oh, and I just spilled coffee all over you. That's my typical. I am so sorry. Well, I make a statement. I'm Rachel Dash, and my dad would be just so excited to see the living proof of what you all are doing and how important it is. I'm also speaking as a member of the American Family Therapy Academy, and I also work with trauma and former co-chair of the Human Rights Family Policy Committee for that. And Larry Levner over there is our chair, partner in crime. And we've written policy statements with, for position papers with AFTA, with consultants from our members who are of the immigrant community and advisors. We're an organization that has a core mission of human rights and social justice, because families don't live in vacuums. And we do have a position statement that we wrote on immigration. And I'm listening to this last question and what you're saying, and the question is, we write these position statements, and many of our members are involved as advocates, but have you found ways in which you are working or the communities are working with organizations that not only are advocates, but I know the American Psychological Association also came out with a strong statement so that we can be allies, both providing services, trauma services, but also providing the research about the effect on families and kids so that we could be allies with you into the school systems and thus.
I think that we have definitely tried to work with various organizations that we've been in touch with since the beginning of our research that have directed us in pursuing certain trains. We've also been working since, as we've now have copies of the report, we'll be working on distributing them to various organizations that we've been in contact with and allowing them to further disseminate them to other organizations that they're in contact with to increase the spread of information and work with other organizations to make as much of an impact as we can. That is our clear objective. We further have met with other organizations, and we're continuing our meetings in order to further the awareness.
I want to add one point to that too. So the focus of our report wasn't exactly on like the trauma that the children are experiencing, and therefore I don't think any of our findings or recommendations are directly responding to that question, though it was very prevalent in our interviews as something that came up as having a lack of resources to support it. One thing that we did realize through our work over this last year is that education is a really localized issue, and what we saw that worked best in communities that we visited were smaller NGOs and organizations that provided like very specific targeted services to children in needing help with like school enrollment and access to services once they're in school. Those types of organizations facilitated great relationships between schools and communities, and that would be something that we recommend for other community organizations to replicate. I don't know if anyone else has.
Good afternoon. Still morning. Good morning, and thank you. I'm Carl Mintz, and my question is, did you show the report to local, state, and federal organizations and give them the opportunity to respond, make comments to the report before you published it? And if not, why not?
So we did meet with the Department of Education, and we previewed our findings, and they have been actually wonderful in being willing to hear us and learn about our findings and meet with us beforehand. This was not a formal consultation process. They provided no formal guidance, but we did give them preview of sort of our findings and what we found. When it comes to reaching now back out with the advocates, I mean, the advocates on the ground, those were our major contacts, and now that we have a physical report, now is when the real work begins, and we look forward to reaching back out to them and finding ways we can continue this education process.
Did ICE comment?
We did not present our findings to ICE, but we hope that they will see them.
My name is Patty Malahi-Fougere, and I'm with the Washington Legal Clinic for the Homeless. And just a suggestion in the follow-up stage, when you're talking about reconnecting with advocates, one community of advocates could be the homelessness advocacy community, because as the report points out, so many of the children are living in situations that do technically qualify as homeless, and the advocacy community that works with non-immigrant homeless children may not be as familiar with some of the tools that would be available that you're raising in the report and in the recommendations.
Thank you.
Hi, I'm Tiffany Nelms with the U.S. Committee for Refugees and Immigrants, and we worked quite a bit with Caitlin in the research. We serve unaccompanied kids once they're reunified. And I think going back to the mental health question, although your recommendations don't speak specifically to mental health and trauma, one of the recommendations to give the kids the 30-day grace period to provide the documentation they need to complete their registration, I think would be really helpful, because a lot of our kids do have trauma, as several people have mentioned, and the isolation that they feel when their enrollment is delayed or denied for weeks or even months on end. A lot of these kids have caregivers who are working all day, so they're unsupervised. They don't have that basic safety net because they're being made to stay home. So I think that recommendation is a really good one, and I wish that we do see some school districts that are more informal and will allow something like that, but most do not. And so it creates all of these other issues that then as social workers we're having to navigate, just exacerbating those symptoms of trauma for kids, even 13, 14 years old, that it takes us 4, 5, 6 weeks to get into school in places like North Carolina and South Carolina.
Definitely. And when we spoke to school districts about that, as Genevieve mentioned, 30 days was the best practice, but they often mentioned that more than 30 days would be ideal and necessary for a lot of families. So it's definitely a great recommendation.
Hi, Wally Malinik. I'm on the faculty at Georgetown. I was interested in the comment you just made shortly before this last one, that a lot of what happens in education is local, right? I'm sure that there's some misunderstanding of law. I'm sure there's some misapprehension of law at the local level. But so much of this is attitudinal. This is not a great time to be an immigrant in the United States. And all the immigrant bashing that goes on trickles down, use that word, trickles down into these local communities, and the resistance is often not based on misapprehension or misunderstanding of the law. It's just based on what people feel. So let me ask you, in your studies, did you see different organizations figuring out how to work on attitudinal change? And whether you did or not, do you guys have any suggestions for how these organizations, you obviously now have a great network of organizations, how they can actually begin to change people's minds? By the way, great job on the whole thing.
I think we all think that's a great idea about changing attitudes on a local level. And I know in North Carolina we spoke with some organizations that are trying to bring communities together and hosting events, and especially around religiously affiliated organizations, the church or synagogues or other houses of worship can really play an important role in bringing communities together and fostering a sense of understanding. And so we did see that present, and it was effective. And we also saw in some places that there were direct efforts to halt some of these efforts. So I think we think that having organizations participate and foster these relationships locally will be really important in changing attitudes, especially, as my colleagues mentioned, as the 2016 elections come up and debates get heated and fingers get pointed. We hope that hopefully these organizations will help to foster a better sense of community with these children and these families.
I think your question also hits to the main essence of our report, that these children are our children and are going to be in the community, and providing them with a space to get educated and become productive members of our communities. That is what all of our findings and our recommendations really want to hone in on, is that regardless of whether you allow them to access schools, they're still going to be in our communities. And the best thing to do would be to serve them in their best interest and have them allowed to be participating in the U.S. public education system. Alex is going to add another point.
And I think a big one thing that became crystal is knowing what the ask is for these communities. For example, some schools didn't know that they have the authority to determine whether or not ICE comes into their schools, and as a result, parents don't know to advocate for that. So I think a lot of this is understanding the law, understanding where advocacy possibilities are, and knowing sort of we might not be able to change the national dialogue, but we can make real difference in these kids' lives, and knowing what the asks are is something I think would be really important.
Just one other point. I think we saw in a lot of places a very good attitude from school officials. They were really interested in doing what's best for the children who are trying to enroll in their schools. So at a management level, the schools had all the disposition to welcome these kids to school. But then again, as I said, these are individuals who are acting on behalf of the state, which is the problem. These are state agents. So when they are denied, when a children is denied their right to access schooling, it goes back directly to the state and it reflects on them. But we saw different practice practices. We attended one presentation on Know Your Rights, and the police was there just to tell the community, don't be afraid of us. We're not ICE. We're not enforcing immigration policies. We want you to feel welcome, to not, if there's something wrong, to come to the police and feel safe. So we saw different ways on how schools and communities are trying to come together to make all of these, I would say, just misunderstandings become clear, and understand that these children need to be in school regardless of the immigration status, and that the communities should be and should feel safe.
Andy, if that's all, then could I ask one quick question? I'm Patrick Griffith with the Human Rights Institute. I'm the fellow here. Maybe if I could just ask quickly if there are any particular research gaps or issues that you all stumbled upon or weren't able to investigate that would be ripe for others to continue digging on, perhaps students who will be participating in the fact-finding project in the future.
As someone multiple people in the audience brought up the mental health component to education and the experiences of undocumented children living in the United States in general, our findings did not particularly focus on this, but that is something that someone in this audience should research.
If I may add too, when we were looking at what our research gap would address, we were thinking about the increase of arrivals after 2014 and okay, what's happening to these children after they come to the United States? What happens to them after, if they were in a detention facility after they were released? If not, how are they integrating into the communities? And we found education to be the biggest issue, but still general integration, it's more of a sociological research, but still how are the immigrant communities integrating into the United States, and that has the component of how are they dealing with their past trauma, how are they integrating to be useful to communities. So I think that's something to take into account, and that we will continue seeing, because most of them will probably remain in the United States.
Thank you so much for spending your morning with us and listening to our findings.
So I want to congratulate the students. For those of you who would like to have a copy and you haven't picked up one, they are hot off the press in the back, so please do. Both the report, which I had the privilege of reading at least the final version, or almost final version, recently, and the way that you've articulated the findings, conclusions, and recommendations today was absolutely extraordinary. It's a model of conducting human rights research in a very valuable way. You documented your findings well. The conclusions all follow from them. I love the way that you found best practices. It doesn't happen all the time, and we obviously need more, but where you were able to point to ways forward here, and not just to note and observe the problems and the violations of human rights, but ways to correct that. And I know that right now you're in the middle of beginning your advocacy strategy over what now to do with this report, right? Congratulations on already getting serious media attention today. The major media, the major newspapers we know of, and others have already covered this launch or begun to cover this, and you have so many possible groups and agencies to advocate before, federal government, state government, local government, all the organizations that really care about these issues. This is a real challenge to figure out that advocacy plan, and I can see that why it would be a great opportunity for you all to think that through carefully at this stage, now that you've reached this stage of completing the report and launching it. So first, I wanted to simply congratulate you on this. I'm sure those of you who've now heard from our extraordinary students realize that this really is our Human Rights Institute practicum is a student-driven initiative. With the help of their extraordinary adjunct professors, Michelle and Jennifer, the students have been involved in making decisions about every aspect of this project from the very beginning, including deciding on the topic, finding the particular research gap, conducting their research, and then presenting their findings today. And I think it's pretty clear to you why this fact-finding project has become a central part of what the Human Rights Institute does. So we have a short break now before lunch, and I'll welcome you then, once the lunch is all set up, to begin. We will have our keynote speaker, Dr. Susan Bissell, after you've had a reasonable chance to enjoy lunch, and then we'll continue with our afternoon program after that. So please join me again, a round of applause thanking the students for their presentation.
And I'm also on the advisory board for the National Child Traumatic Stress Network. So I wanted to figure out a way to connect you all to both things. We have an advocacy conference actually next week. Would you like me to sit when I speak?
No, you do whatever you prefer. You can sit, you can stand, it's really up to you.
Okay.
It's always the speaker's choice, it seems
Great.
to me.
Thank you.
Sure. Good afternoon, everybody. Yes, it is the afternoon now. I hope you have enjoyed your lunch and our continuing conversations. We're now going to turn to our keynote speaker, and I want to introduce Dr. Susan Bissell, the director of the Global Partnership to End Violence Against Children, who is going to deliver our keynote this afternoon. We're very excited to anchor our program today with the perspective of someone who has dedicated her career to fighting some of the worst violations of children's rights. You have her full biography in your program, and given its length and impressiveness, I'll just give you an abridged version right now. Ms. Bissell's career has specifically focused on the rights of children. She spent over 25 years working in various capacities at UNICEF. As of January 2016, she's leading an emerging global partnership to end violence against children. The primary purpose of the partnership is to end abuse, exploitation, trafficking, and all forms of violence against and torture of children. From 2009 to 2015, Ms. Bissell served as the Chief of Child Protection in UNICEF's Program Division. The author of a number of research studies, she's worked with UNICEF in Sri Lanka, Bangladesh, India, Italy, at the Innocenti Research Center, and New York City. She earned her PhD in Public Health and Medical Anthropology from the University of Melbourne in Australia. While completing her doctorate, she joined Trudy Styler and the Bangladeshi film team of Catherine and Tarek Massoud to produce the documentary A Kind of Childhood, which has won awards and been screened widely. She also holds a BA and MA from the University of Toronto. On behalf of the UNICEF Child Protection colleagues, of her UNICEF Child Protection colleagues, Ms. Bissell has accepted awards including an honorary professorship at Barnard College, Columbia University, the Dr. Jean Mayer Global Citizenship Award from Tufts University, the Flambeau d'Or from the Panathlon International, and the Queen Elizabeth II Diamond Jubilee Medal. So it gives me great pleasure to introduce Dr. Bissell to you as our keynote speaker. Thank you.
Hi, good afternoon, everybody.
going to move that so I don't spill it on the computer. Before I turn to formal remarks, I actually just would like, if you will indulge me, to make a couple of comments about the panel this morning. Listening to such an impressive group of scholars and already, it would appear, activists, it gives me hope for the future. I really thought that was just an extraordinary piece of work, and the fact that you are, as was pointed out by one of your professors, planning for even more ongoing advocacy, I think is extremely important. I think, we probably needed this about 3 years ago. I worked on this issue, but in the Northern Triangle, actually, in some advocacy with the foreign ministers there and thinking about what to do. And one of the recommendations I want to make to all of you is that we get your recommendations, maybe a synthesis version, but in the hands of the host country so that people are aware of the kinds of things that, including documentation, that are going to be so important to them when they move. Whether or not they have documentation anyway would remain to be seen. But I laud you for your very hard work, and I wish you all the great success in your careers. I've titled this talk, "The Rights of Children Prominent in Agenda 2030," and I'll come to the specifics of what exactly that means. Before I do, a big thanks for inviting me to be here. To Professor Dash and his family, who I've now met, what a wonderful focus on human rights that has been in that family for so long. And then as an aside, I already told Patrick, you're still in the room, so thank you very much for the excellent logistics. When you have a life like mine, being able to walk out of the train station, turn 2 blocks, walk 1 more block, go into your hotel, in the morning come out, walk across the street and go to your meeting, it's really fantastic. I resisted the temptation to arrive here just in time to speak and leave immediately thereafter, which is what I often have to do. But I have to tell you that my interest in your deliberations today are too great, and this is too important an opportunity not to think more deeply with all of you about children within and beyond the borders of the United States. As ever, and I say this after this morning's sessions, it's a humbling, enlightening, and buoying opportunity to be among students and faculty, and I know maybe some service providers and other activists in the room. We need such dedicated minds to address the pressing issues we are focused on here, and to be sure, the Academy itself has a major role to play in preparing the next generation to tackle the enormous challenges children face now and are sure to face in coming generations. So over this period of time this afternoon, I want to share with you a bit of practical history about the rights of children. Chris, I hope I don't sort of step on anything you're going to say or the upcoming panel, but I really am going to do a light touch across a few things, and I'm sure the panel will delve even more deeply. I will take you back more than 25 years to the final days of drafting the UN Convention on the Rights of the Child. I'll spend a few minutes reflecting on the UN as a whole and the way it is or is not set up to defend and safeguard the rights of children. And at that point, I'd like to turn our attention to a number of, in addition to the issues we're talking about this morning, a number of challenges that children are facing today, building on what's already been discussed. And later, by way of concluding, I want to talk a little bit about it's obviously a very difficult subject, but one I'm intending to immerse my own life in for the last 4 or 5 years of my career before I take early retirement, head for the Berkshires and get a Labradoodle. And that is violence against children. And as I mentioned already, Agenda 2030 and all of the targets and ambitious goals that the world has set for itself. So the rights of children. So a couple of weeks ago, true story, I had a call from an American journalist in the Midwest, and this was just prior to my spending a week at Beloit College as the Weisberg Chair, and he was whetting his appetite for what I hoped would be some deeper exploration into the field of children's rights. He asked me point blank, and I can't do his accent, but I'll sort of give you the tone. Do children really have rights? And it was a serious question. If he could have seen my facial expression, it was sort of a deer in the headlights kind of thing, but thankfully we weren't on Skype, we were just on the phone. When you work for UNICEF for 25 years and when your career has grown from the drafting of the UN Convention and you've focused on the implications of that treaty, you never ask yourself whether children have rights or not. They just do. As a little aside, I will say that one wavers slightly from one staunch, hard, fast child rights positions when you have your own children, but I digress. So this query from a journalist reminded me that undoubtedly for most people, the notion of children actually having rights is a foreign one. For many, children are dependents. They lack agentive capacity. They do not vote. They're even seen as property in many parts of the world, or they're just mini adults. As you have by now confirmed, the Convention on the Rights of the Child, and you mentioned this in your opening remarks, is the most widely and rapidly ratified convention in human history. It is a treaty that covers children's economic, social, political, and cultural rights. And the UN Convention on the Rights of the Child, I'm sure we'll hear more this afternoon, has 4 general principles. And these are principles that intend to govern its implementation irrespective of specific context. First, the right to survival, actually in no particular order. Non-discrimination, the best interests of the child to prevail in decision-making, and child participation according to evolving capacity. Governments, non-government organizations, and UN agencies took part in drafting the convention. It took them 10 years to reach agreement on this historic text. So I was actually, in my very first job, the chief photocopier in residence during the last 2 years of the drafting process at UNICEF in New York. I was 24 years old, and with a newly minted undergraduate degree, I arrived in New York from Toronto to take up an internship. I was probably pretty good at it because they did actually offer me a job 3 months later. But suffices to say, I was instantly gripped by the mission of this incredible organization and its newfound commitment to taking a rights approach to children. I use the term newfound deliberately. UNICEF came late into the game of convention drafting. There were many reasons to be hesitant in the mind of the then executive director, Jim Grant. The completion of the convention drafting must be credited to a full range of civil society and other partners. UNICEF helped to bring the drafting to a finish, and I accompanied the clever political maneuvering that resulted in the convention's swift ratification and entry into force. Now, I don't know if you have to be obsessed with children or obsessed with the law to get excited about an international human rights treaty, but for those of us who were concerned with the protection of the world's children, this was a groundbreaking and international human rights piece of legislation, and it still is today. A few facts. Children in the convention are defined as those under 18, and there are articles in the convention ranging from child labor, trafficking, to children and war. Other articles touch upon children having a voice in decisions affecting them. The convention mentions the right to a name and a nationality, and Article 4 of the convention calls upon states parties to allocate financial resources to the maximum extent possible, and also asks for their assistance where they have the capacity to other countries. Equally interesting and important are 3 optional protocols to the UN Convention on the Rights of the Child. I think these protocols demonstrate that this is very much a living convention, that it's adapting to current issues and contexts and looking at things that were perhaps overlooked or too contentious in the drafting process to be included. One protocol refers to the sale of children, child prostitution, and pornography. Another protocol focuses on the effects of children and war. And the third and latest protocol creates a complaint mechanism for individual children. In my opinion, and having seen the convention brought to life in varying degrees in countries around the world, I submit to you that the convention forces us or allows or encourages us to see children in a different way. They are human beings with rights. In so many places, from Europe to Africa to Asia and the Americas, the convention and its relationship to national and state or provincial legislation has triggered a very important process of social change. Now, this is especially true, that social change component is especially true in contexts where domestic law reform involves public discourse and debate. When citizens, including young people themselves, discuss issues and give voice to matters affecting children, and with a view to possibly even codifying them, things start to change. Examples of this are endless, but I want to give you 2, each at opposite ends of the political, cultural, and geographic spectrum. For the first example, travel with me to a small Nordic country. With a manageably sized population and admittedly socialist politics, this country, I'll give you a hint, they speak Swedish there, decides that all forms of corporal punishment against children must be banned. In Sweden, then, there was much public discussion, laws were reformed, information flows about this new legislation were dramatically boosted with public financing, and over the course of a generation, the practice of beating, berating, and degrading children to punish them ended. I don't want to really get into a debate about cause and effect, and I'm most certainly simplifying what is a very complex process and what it takes for social change to be cemented in a culture. But suffices to say that public and dialogue-informed law reform has an important role to play. The second example is a much more current one, and it takes us to South Asia and the beautiful country of countries, India, where I spent a good part of my UNICEF career. You may recall the gang rapes, as we all learned about on a bus in New Delhi in 2012. Sexual violence is neither new in nor exclusive to India. However, the particular case in New Delhi brought with it national and international public outrage. As an aside, 120 million girls around the world experienced sexual violence last year. However, it was in India that students protested on campuses across the country. I would argue that this was at the very least linked to the rapid turnaround of the Verma Commission, and that in part responsible for some important changes in Indian legislation on rape. Has sexual violence ended in India? Most certainly not. As this abhorrent form of violence continues, including on college campuses in the United States, in the Indian case, it is arguable that social change is emerging in the context of this crime. It will necessarily need to be accompanied by changes in attitudes towards women and girls, and in addition to addressing other aspects of discrimination and inequality that prevail in far too many places. Ending impunity is and will continue to be of prime importance. So a little final comment from me on children's rights, rhetoric, and reality. To be sure, enormous gaps exist between the national legal reforms that have followed the ratification of the Convention on the Rights of the Child and practice. And I think we heard a little bit of this morning, actually, where we have the sort of international rhetoric and even maybe some federal, and how it translates is just so fundamentally important. But laws have to be resourced and implemented. Where I see the biggest omission and the greatest inaction are places, even with functioning democracies, where the social construction of childhood is stuck in time. In these places, of which there are far too many, children's lack of political voice translates for policymakers and politicians into inertia. As mentioned earlier, Article 4 of the Convention tells states that they have to allocate resources for children to the maximum extent possible. That is, for too many, far too big a loophole. How long is a piece of string is pretty much synonymous with to the maximum extent possible. The rights of children, I argue, and will continue to argue, are not an add-on or something to factor into whatever is left over at the end of budget talks. They should be front and center. So to turn to the UN itself for a few minutes, when we ponder on the inertia we see and the loopholes I've referred to, it's pretty much everywhere. Who makes things happen for children? Who creates change, and how? Just as it takes a village to raise a child, it takes an international community to save and protect its children. I'll turn to governments and civil society organizations in a moment, and I'll lead with the UN. Rest assured, I hasten to add, I'm not making a plea for the UN as an unflawed, perfectly effective, always doing the right thing institution. I'll let you pause on that for a second. I am saying, however, that having had a frontline view of UNICEF in action in a number of countries, I remain convinced that the world would be a worse place without at least this complex, well-intentioned bureaucracy. I'm equally convinced that we can do better in partnership. So for those of you that are not aware of the organization, it's the leading UN agency when it comes to children, and it was born in the aftermath of the Second World War. UNICEF was then called the International Children's Emergency Fund. The late and very dignified Audrey Hepburn recalls benefiting from milk that UNICEF delivered to her and other children. And just another example of the long recollection of receiving from the organization, there are many elderly people in Japan who recently participated in a survey and who hold UNICEF as dear to their heart as some of their family members for the day that food supplies they received from UNICEF reached them as children. This fund, related to but financially independent from the UN, has evolved from that supply-driven, emergency-focused mission to one which embraces human rights and the rights in particular of children in all settings, so humanitarian as well as non-humanitarian. Other UN agencies also have the rights of children within their mandates. The UN High Commission for Refugees has a special interest in statelessness and children and best interest determination in the context of separated and unaccompanied children. The Office of the High Commission for Human Rights is home to the UN Committee on the Rights of the Child, for example. And this is the 18-member body that oversees implementation of the Convention on the Rights of the Child. The ILO, the International Labor Organization, oversees implementation in particular of its two conventions, 138 and 182, that govern work on child labor. The UN Office on Drugs and Crimes has a special focus on child trafficking, and DPKO, or the Department of Peacekeeping Operations, has had a hand in the work to keep children safe in war-affected settings, not doing so well with the peacekeepers. UNFPA works with UNICEF and others on issues such as female genital mutilation and cutting and child marriage. And finally, but in no way exhaustively, WHO addresses a range of child health issues, most recently including mental health, non-communicable diseases, and importantly, violence. And I quote, this is their resolution on violence against women and girls and children. We could talk about that in Q&A if you like. It's fair to say that there is an unprecedented high level of commitment from the current Secretary General, whatever criticisms or observations we may have about the Secretary General. He has given particular primacy to issues important in the lives of the world's children. I am reminded of a meeting I attended with the Secretary General a few years ago with the New York representative of the Holy See and the chair of the Committee on the Rights of the Child. We were to discuss sexual abuse and the church. And when I left that meeting, I remember looking across the lawns of the UN at the East River, thinking how incredibly historic that moment would be to millions of victims and to the future protection of millions of children. The UN also has a never-before list of special representatives of the Secretary General and special rapporteurs working unstintingly and for no money that are advocating for children. There is a special representative of the Secretary General on children in conflict, a second on children in violence, and a third on sexual violence in conflict. The special rapporteurs, again, not exhaustively, cover subjects such as education, health, torture, trafficking, and the sale of children, nutrition, and a litany of child-related issues. And again, as I mentioned, they work on an unpaid basis to sustain the interest of states parties in fulfilling their obligations and to apply a little pressure where it's needed. I've used this word already, and I want to dwell on it for a minute. Partnership is crucial. In every country where I've been posted, local civil society organizations have been on the ground at the forefront and are there to stay. And I think in the panel this morning, we heard about the importance of those organizations, both advocating for children and also doing some service delivery. These organizations, these civil society organizations, go places that others will not, speak truths that others will not, and are there for the long haul. I have met some amazing people with incredible dedication in these organizations, and they have indulged me over the course of my career as I have learned and grown. Time is too limited to name names, but I have the strongest recollection of working with the late Salma Soban and Hamida Hossein in Dhaka, and I just want to use this as an example. They, together with, and you heard in the introduction, Tarek and Catherine Masood, Bangladeshi-American documentary filmmaking family, basically. Tarek was the first Bangladeshi director ever nominated for an Oscar for his work on the War of Independence in '71 in Bangladesh. So Salma and Hamida and Tarek and Catherine taught me firsthand about the complexities and intricacies of childhood in a place like Bangladesh. Salma and Hamida had a grassroots organization called Aino Shalish Kendra, working with urban slum and street children. And I want to just use them as an illustration of impact of a civil society organization on a very intricate a piece of documentation, which I think is relevant even when we think about migrant children from the Northern Triangle. I know Shailesh Kendra tackled a problem too big for any UN agency and squarely a child rights concern. Street children in Dhaka were being, and during my time there, before and after, I'm sure, picked up by police, brutalized, raped, and even made to disappear in some instances. Unable to get officials to crack down on law enforcement, Salma and Hamida studied the problem. The children on the streets with some kind of identity, a card, a birth certificate, anything stated that someone knew them or they were attached to someone, were not harassed. Children without ID were victimized. I know Shailesh Kendra could not swiftly reform a defunct civil registration and vital statistics system, but they could produce ID cards, and that they did. These were small, laminated cards with the child's name, some identifying features, and with the address and the phone number of I know Shailesh Kendra on the back of the card. The message was clear. If this child goes missing or is hurt, someone will be looking for him or her, and you will be held accountable for any harm. This is but one example of civil society in action. International non-government organizations are powerfully important too. In addition to community-level access, unlike UNICEF, as a government-to-government body, NGOs have an enviable nimbleness and freedom. They can, among other things, work alongside the faith-based community in very simple day-to-day ways, and I'm thinking in particular of World Vision. But others, like SOS Children's Villages, take up very specific issues, such as creating permanent family-like environments for children without parental care. SAVE, Plan, Terre des Hommes, and the Child Fund Alliance are others in the civil society or NGO world that are doing powerful and important work in the lives of children. And in contrast to UNICEF, many of them are operational in high-income settings, like here in the United States, shedding a light on children who bear the brunt of inequity in these societies. It's been a great honor for me to work alongside these organizations during the course of my career. And as you heard in the introduction, that has largely been a career focused on child protection. For the organization, this has been a non-traditional area of focus. UNICEF started, as I said already, with the delivery of emergency foods and medical supplies, and it developed into an organization that really had child survival at its core. Under the leadership of the aforementioned Jim Grant, growth monitoring, oral rehydration, breastfeeding, and immunization with the acronym GOBI became the mainstays. Arguably, nothing has done more to save the world's children than the investment in and delivery of vaccines. The global partnership Gavi has a great deal to be credited with. But for someone like me, who entered into the work in the final days of the drafting of the UN Convention on the Rights of All Children, I was pretty unsatisfied. My first field posting was in Sri Lanka. That might have been why they got me out of New York fast, where there was a real war going on. Its impacts on children were devastating. I arrived there in 1988. Villages were being massacred not once but twice. Children living with disabilities were suffering exponentially. And if you'll allow me to digress for a moment, I want to share with you one thing that, as I was writing this, came up as probably one of my most powerful memories of that work now 25 years ago. But I remember we were visiting a remote village where there was a child living with cerebral palsy, and he was locked in a shed day in and day out. His food was slipped in under the door. He was about 7. And I remember just being so kind of shocked by that. And this was a village that had been experiencing war. And one of the most important lessons I learned at that exact moment was that his parents were not horrible people. They were told he was cursed. They didn't know what to do with him. And with the war raging on, there was little access for experts or even paraprofessionals to help him. I remember then saying to myself, this is it. I knew that just saving children would never be enough for me. Save children from preventable diseases? Yes, absolutely. But then and now, I had a conviction that we must help children live completely, wholly, safely, and with dignity. Lest this sounds heroic or crazy, on some level at about the same time, UNICEF got its first executive board paper on what were called Children in Especially Difficult Circumstances, CEDC. There were people in that boardroom in 1986 reading that paper who learned about children as soldiers, children on the streets in Latin America, and children in brothels in South and Southeast Asia. If those were transformative years for me, they were profoundly transformative for UNICEF. Some of you will recall that by 1996, the seminal study by Graça Machel for the UN Secretary General on the horrific impacts of war on children was completed. She wrote of their recruitment and use as soldiers, the sexual violence they experienced, and of their killing and maiming. What ensued was an extraordinary commitment of the UN and the Security Council to the protection of children from war. The Secretary General appointed the special representative I mentioned earlier, a position occupied today by an incredible SRSG from Algeria, a lawyer and human rights advocate, Leila Zerougi. The creation of this office accompanied a litany of Security Council resolutions of the impacts of war on children, including Security Council Resolution 1612. And this is a resolution that allows the Secretary General to name and shame parties to conflict, and that holds them accountable for ending violence and crimes against children. Interestingly, UNICEF's work to protect children from violence is the only part of UNICEF's mandate that is considered and guided by the Security Council via, in particular, the Security Council Working Group on Children in Conflict. Now, fast forward 10 years, in 2006, not so long ago, again at the behest of the Secretary General, Brazilian lawyer, Brown professor, and human rights advocate Paulo Sergio Pinheiro completed a global study for the Secretary General on violence in children. As with the Machel study, he forced for the Secretary General a discussion at the UN on violence against children, and this time in all settings, with the exception of war, which we all felt had been well covered by the Machel study. I was part of the editorial board of that violence study, and rest assured, there were some very tense moments in the write-up. Taking a public health and human rights approach to violence against children, the study suggested that violence knows neither geographic nor economic nor cultural boundaries. It cuts across all settings, is experienced by boys and girls, those living with and without disabilities, the LGBTQ community. It painted a grim but somewhat optimistic picture, suggesting at the end in its conclusions that violence is neither justifiable but nor an inevitable part of life, that violence against children is preventable, and I'll come back to that at the end of my remarks. The study was published just prior to the adoption of UNICEF's first board strategy on child protection in 2008. So it took the organization a pretty long time to move from 1986 and kind of paying attention to these issues to really demonstrating the conviction from its board that this was squarely at the heart of the organization's agenda. And that's when I got the phone call when I was very happy at the Florence, Italy Research Center doing my work, and would I come to headquarters and help the organization to embrace this new strategy and make sense of it. I'll come back to the strategy for a moment. I want to just take a couple minutes, since we're at a law school, to talk about the alignment of international law for children as it plays out on the many issues that you talked about this morning and that I've touched on. There are, in fact, 3 streams of international law, and maybe you've covered this in coursework, but that are relevant to the protection of children from violence, abuse, exploitation, and neglect. And it's the only part, I think, of work in the field that brings these 3 legal streams together. And of course, I'm talking about, and I'm not doing these in any order, but human rights law, the public law in this category, treaties like the UN Convention on the Rights of the Child or the Palermo Protocol on human trafficking. These are powerful instruments open for state party ratification, and they form a reference point for both advocacy and action. So another stream would be international humanitarian law. It's also crucial to our work to protect children from violence. It is applicable in situations of conflict, and you can think, probably some of you have studied the 4 Geneva Conventions that are particularly relevant. They aim to limit the impacts of armed conflict, in particular on civilians. And within international humanitarian law, we find powerful calls for humanitarian access during times of war, so that supplies and other resources can reach families and children in distress. And the third stream that I don't think probably gets talked about very much, and how all of these 3 sort of come together in certain contexts, is private international law. In this regard, I'm referring to the 3 Hague Conventions that address child protection, child abduction, and inter-country adoption. Private law has neither a humanitarian focus nor universal applicability. It is a law that binds 2 countries calling for their agreement on matters of jurisdiction, among others. And I want to just dwell for a second on the law on inter-country adoption. And I do that because I'm very close friends with the U.S. Ambassador on Children's Issues, who's wrestling with this law every day and doing an absolutely fantastic job. But I think it's kind of a good illustration where best interest is sort of in the Convention on the Rights of the Child. We have it in the Hague Conventions, and it's kind of, it creates some complexities, I think, that are pretty interesting. So to quote the State Department website, to bring this example home for you, the Hague Convention applies to all adoptions by U.S. citizens habitually resident in the United States of children habitually resident in any country outside of the United States that is party to the convention. These are called convention countries. Adopting a child from a convention country is similar in many ways to adopting a child from a country not party to the convention. Sorry for reading this off. However, there are some key differences. In particular, those seeking to adopt may receive greater protections if they adopt from a convention country. So the Hague requires that countries who are party to it establish a central adoption authority to be the authoritative source of information and a point of contact in the country. And this is what I think is so important about the convention, and I know there are criticisms and there are ways it could be improved, but the Hague Convention aims to prevent the abduction, sale of, or trafficking in children, and it works to ensure that inter-country adoptions are in the best interests of children. The convention recognizes inter-country adoption as a means of offering the advantage of a permanent home to a child when a suitable family has not been found in the child's country of origin. It enables inter-country adoption to take place when certain steps have been followed. So I think that I've just really flown through those 3 streams of law, and I'm dying to get someone to write a thesis on the intersection of public and private law and best interest principle or something, just throwing it out there. I've been doing that for the last 4 years. So I wanted to just talk a little bit about the 2008 strategy that I mentioned UNICEF's executive board adopted. And when the board adopts a strategy, it isn't for UNICEF. It's meant to be for the UN as a whole and for member states and then for other partners who are helping to do things for children. So the board recognized, I think, the strategy because, importantly, it was written at a time when UNICEF and major civil society organizations and governments in many parts of the world were realizing that this issue-by-issue approach to keeping children safe really wasn't very effective. So we were seeing sort of, the rescuing of trafficking victims, and then they'd reappear in a child labor site of exploitation. And so the issues, if you just deal with them in a siloed approach, really approaches tend to be not as effective. And I say that both from a cost-effective as well as the perspective of creating sustained change. And I think child trafficking is probably the best example of that, and I think that holds true here. But even the panel this morning, I felt like if we're not taking a systemic approach, also in countries of origin, I think the possibility of sort of stemming the flow of discrimination and marginalization is could be less effective. Shifting focus to establishing and/or strengthening systems from social welfare to justice to law to education to health. Again, relevant to this morning's panel. It's all of those pieces that really need to come together. But I wanted to point out that at the same time there are harms to children. So one part of the strategy talked about system strengthening, but the other really addressed harms to children that are not fixed by service delivery or remedied by service delivery in isolation from social determinants. Again, is such a perfect setup this morning with the panel. I think one of the questions at the end was really, a lot of what's happening to children is about attitudes. It's maybe not that schools aren't there or not that there aren't services, but it's mindsets that need to be changed. And I often refer to these as social norms, societal attitudes and practices, and societal acceptance of various forms of violence, marginalization. There are endless examples, and I'm certain you can come up with a few more of your own, but I'll give you a few that have resonated for me in my career around the world. In some countries, the norm is the abandonment of children born out of wedlock or with a disability. When we see norms change, we see families raising children with disabilities appropriately counseled by medical health and social welfare practitioners, and this is a trend we're seeing in Eastern Europe right now, where children with mild to medium disabilities are actually able to be raised in their families because of the support they're provided and because the medical health professionals don't go, oh my goodness, and react in a way when the parents are told what the child is going to be living with, but in fact, sort of changing the way the medical health professionals counsel families too. The same holds true in communities that would exclude young single mothers. And let's say, and I've seen this in various parts of the world, but you know, a 15-year-old girl who herself was a victim of sexual violence, she is isolated, often abandoned by her own family, and struggles to raise her own child, and cycles perpetuate themselves. The community can be changed by community members from the inside out to accept her and go further, to be supportive and helpful. There are countless other examples of socially determined practices that rely on changing attitudes and behaviors, which one would think is not particularly costly. Child marriage, female genital mutilation and cutting, corporal punishment, and the stoning of women and girls. They depend on people for them to change. At the same time, they're deeply embedded in families, communities, and societies. So change is actually a lot tougher than it looks. It can take a generation or more. The best two examples of this, where there has been change, but where it's taken a very long time, I mentioned already corporal punishment in Sweden. Think about foot binding in China. These are two practices that are now historic, but not without decades of effort, law reform, public discourse, and campaigns. I wanted to talk to you very briefly about a couple of settings, and I think they're important because we're living in very rapidly changing times right now, and the settings where this work to keep children safe from violence are changing, and I'll share with you an opinion about that. Humanitarian settings are contexts where there is a conflict or natural disaster or some combination of both. By contrast, the situations outside of war and disaster have been called development settings in my field. But increasingly, and again, this is an opinion, but you could say you were here when it was sort of put out there, so I think it's going to stick. Not because I said it, but it's the way the world is. The use of the word development is becoming irrelevant. All countries are developing economically in one way or another, and all countries are developing socially. Development used to mean rich countries of the north versus poor countries of the south. Data now tell us that by 2020, the bulk of the world's most marginalized children will live in middle and high-income countries. Now, we may end up, I would posit that we have terminology like humanitarian and non-humanitarian lowering the north-south divide. And this is in part the spirit of the post-2015 agenda, Agenda 2030, that I mentioned at the outset. The so-called playing field is being leveled as an increasing number of countries become middle and high income, and as countries the world over, irrespective of income, find that they have shared challenges and solutions to those challenges. So this will turn me to the last part of my remarks, but the SDGs, Agenda 2030, and this new global partnership to end violence against children. Think of it as the Gavi for violence prevention in childhood. There is no immunization, but we have some solutions. This is a perfect segue into sort of sharing with you, I think, maybe some of the anguish of the first 6 months as the director of this new global partnership. It's being set up as a means of implementation, just one means of implementation of the new agenda, the new Sustainable Development Goals. It is buoyed along by a professor from Georgetown who is my boss, Anthony Lake, who I think had the wisdom to see that we're entering into a new era of work as an organization, and that partnership and this level playing field I've referred to are just so incredibly important if we're going to make a difference. Child Fund, International World Vision, SOS Children's Villages, Plan, SAVE, and a number of other NGOs are a big part of the inception phase of this new partnership. Likewise, the World Health Organization has played a major role, and we are generously supported, in addition to UNICEF financing, by a small group of foundations that refer to themselves as Elevate Children. Violence is a phenomenon that impacts children in every country in the world, including in the United States and in my own home country of Canada. To the point of this being a global problem, I wanted to share with you, after being outside of Sri Lanka for 25 years, 3 weeks ago, I was asked to come to a discussion there on violence and children in the region. And during the few days I was in Colombo, I was consulting with Sri Lankan officials and others in the region on violence. And though the war has ended in Sri Lanka, I listened to story after story of sexual violence, child trafficking, child labor, online violence, bullying, child trafficking, to name but a few of the experiences of children, both in the country and in the region. So indeed, it's true that there is peace in Sri Lanka now, but for countless children, there's no freedom from fear. And globally, the statistics are pretty staggering. Every 5 minutes, a child somewhere in the world dies as a result of violence. I mentioned already that 120 million girls, but also 73 million boys have been victims of sexual violence over the past year. And according to a recent study published in Pediatrics, and the authors were 2 or 3 scientists from the Center for Disease Control, in the paper they published, they suggest that roughly 1 billion children between the ages of 2 and 17 experienced violence during the calendar year 2014, and that's based on some pretty robust surveys that are going on. 1 billion children. I had a New York Times writer just tell me he just couldn't believe it. You couldn't publish the op-ed of a professor at Harvard. He's quite famous for his work in this area because they just thought the number was inflated somehow. And in my opinion, that's 1 billion reasons to step up, speak out, and to take some action. Now, some of you will recall the glaring omission of the protection of children from violence, abuse, exploitation, and neglect in the Millennium Development Goals, or the MDGs, which we've just ushered out. The omission undoubtedly had an impact on the achievement of goals that were in the MDGs, such as in education and health, for example, perhaps also in gender. A child who faces violence on the way to school, or we heard on the panel this morning, who may have come from violence or is fearing structural violence, I think we could call some of what we were listening to, those children will stop going to school. In the same way, success in keeping children alive in the first 5 years, in some parts of the world, those success stories in the first 5 years are lost to violence in the ensuing 10, and I'm thinking in particular about the Northern Triangle. Violence in childhood is a stark and definitive impediment to a country's economic and social progress and a moral outrage. So it's not an accident that on the 4th of January this year in New York, the new global goals entered into force with the protection of children from violence, exploitation, abuse, neglect, torture, etc., became an integral part of the international agenda. Like-minded leaders and dedicated lobbyists and activists had a vision, and they were unstoppable in negotiating the right agenda for children. In particular, in Target 16.2 of 17 Sustainable Development Goals, but in other targets going beyond 16, the rallying cry is clear. We need and want to create a world where it is safe to be a child. So the new global partnership is but one platform for Agenda 2030. Our intention is to change the way all of us, including policymakers, governments, and campaigners, think about the prevention of violence. We need to be winning the argument that societies should and can be safe for children. The partnership is based on a commitment to the rights of all children. It will turn the belief that no violence against children is justifiable, all violence preventable, into a compelling agenda for action. The partnership will serve as a multi-sectoral, multi-stakeholder platform. The stakeholders are governments, civil society organizations, academic institutions, the private sector, leaders of the faith-based community, foundations, the UN, and young people themselves. At the global level, the partnership will focus on building political will to end violence and making violence prevention a priority. It will also serve as a catalyst for expanding the movement to end violence based on an understanding that there must be a change in the attitudes and the norms that tolerate violence. This can be done at all levels, but importantly, the real movement building in the partnership will take place in communities all over the world, ideally with young people active and engaged. Civil society will be a key part of the movement we hope to ignite. We are solution and prevention focused in our zero draft strategy. Experts under the leadership of the World Health Organization and from a variety of sectors have come together to create an evidence-based package of solutions. They are not creating them on the basis of goodwill or some kind of crystal ball. They've actually looked at randomized control trials and other evidence bases that tell us that these solutions, these strategies for violence prevention have been effective over the last 2 decades. They include social norm change, legal and policy reform, early intervention in families, social protection, service provision for victims, and the empowerment of young people and their caregivers. This is one of the most exciting developments, I think, that I've seen in my time. A whole field from child protection to health to education to justice coming together behind a common set of interventions that work. They work differently in different contexts, but we're speaking a common language now and undertaking some common actions. In our Zero Draft strategy, we introduce a concept of pathfinder countries. And these are places where there is demonstrated strong commitment to accelerating efforts to make children safe. In pathfinding countries, for example, partners will provide technical support to a whole-of-government approach to violence prevention. This will involve the development of a roadmap for implementation of the strategic package I just mentioned, and a national commitment to increased financing. We'll create a platform for knowledge, live knowledge sharing across countries, and catalytic funding from an associated trust fund will be provided where possible. And that trust fund benefits from an initial £40 million commitment from the UK government. We're hoping to raise $1 billion over the course of the next 5 years for that fund. These Pathfinder countries will be demonstrating that violence can be prevented. Pathfinders will both innovate and scale up. So unsurprisingly, and there's a bit of a joke about this, that if you can't get Sweden into your partnership, it's probably not a great idea, but Sweden, at the level of the Prime Minister, was the first country to declare interest in pathfinding. Sweden was swiftly followed by El Salvador, Paraguay, Mexico, and the Philippines. The partnership is in conversation with Romania, Tanzania, Indonesia, and Sri Lanka, and we've had informal discussions here in the United States and in Canada and the UK. So you can see it's quite a range, and this really speaks to, and we consider the partnership to be a test case for the universality of the Sustainable Development Goals and Agenda 2030. In 2017, most likely in the fourth quarter, we're going to have a solutions summit, and Pathfinders will share experience of what's working and what the challenges are. From that point, the partnership will continue to strengthen online and other knowledge-sharing means. New Pathfinders may emerge. We have, for example, already been asked if regional bodies, such as the Global Movement for Children in Latin America and SIBAC, the South Asian Violence Against Children Coalition, can become Pathfinders. Chicago also queried us informally about the possibility of being a Pathfinder city. Pretty excited about that. And I was in Beloit, as I mentioned, a couple weeks ago, and I threw that challenge out to them too. As a global platform for advocacy, the partnership will use its convening power to help expand the global movement against violence both within and across borders. There are many efforts in existence to protect children. I'm thinking of Together for Girls, Girls Not Brides, the Movement to End Female Genital Mutilation and Cutting, and the Global Alliance for Children, funded by the US government, to name but a few. We're going to work with these existing partnerships, build on their strengths, and fortify what we hope will be an unstoppable force for change in the lives of millions of children the world over. As I mentioned earlier, this work will have to include strong engagement with civil society that are working in particular to address social norms and attitudes. All governments, non-government organizations, foundations, and other entities can be part of the partnership in differing ways. We're going to have a call to action in New York during the high-level political forum. That's the body that's going to meet every year at ministerial level, except for every 5 years when it'll be head of state to review progress on the SDGs. As I said at the outset, Agenda 2030 is for us all, and the partnership is a real test case for universality. Now, just to conclude, since I'm here as your guest in the Capitol, here in the United States, congressional champions for the protection of children in overseas development, in consular and trade matters, are desperately needed. Violence against children is also relevant at and within the borders of this great country. I know of two particular organizations who've actually reached out to us. One, the Avielle Foundation, and Cure Violence, which you may have heard of, working in inner city Chicago, in New York, and in other parts of the world, South Africa, Jamaica, together with others, are calling for a White House summit on violence against children before the election this year, before the administration changes. The partnership is supporting that call and working with a 501c3 entity called Civic Nation, which is where the U.S. campus initiative on It's On Us is actually housed right now. To everyone in this room, I want to conclude by asking that we all be inspired by the 1 billion reasons that exist to end violence, the 1 billion child victims here and everywhere in the world. Let us be buoyed along by the knowledge and the evidence that violence against children can be prevented. The solutions are in our hands, in all of our hands. So I want to thank again Georgetown University and for the warm welcome here today and for allowing me to be part of this important discussion. Thank you.
Thank you very much, Dr. Bissell, for that extraordinary talk. We have time for some questions and answers. Dr. Bissell has agreed to take them, so if I can get this to work. In any case, does anybody have any questions? Eric? And if you would identify yourself again, and anybody else who has questions, so Dr. Bissell knows who you are. Thank you.
Yeah, hi, my name is Eric Rosenthal with Disability Rights International. Fascinating to hear your story from photocopying at the drafting session of the Convention on the Violence Against Children work. And given your knowledge and experience with the sweep of the development of international law, I'm interested in your views on orphanages and institutions for children, and whether we might ever see a day when it's considered inherently a violation of human rights to put children in institutions. My organization documented atrocious abuses, not only in orphanages, but the kind of uncounted children who end up in psychiatric facilities, many other kinds of institutions. And, the international standards all say, that children should be in families except for the following, and you can go through the check marks that are there as a last resort, and yet we have, millions of children who remain in institutions today. Where do you see that going, and what might we see in our lifetime or sooner an end to the institutionalization?
It's such an important question and an important area of work. So a couple of things maybe to the negative, and then I'll try to take it a different direction. But first of all, we are seeing, now let me start with positive trend, and certainly in parts of Eastern Europe, I don't know if your data shows this, but declines in the use of institutions, especially large-scale institutions, as homes for children needing alternative care. And the one example I used, I think, is probably one of the better ones, looking at Montenegro and some of the surrounding countries. So wherein, parents don't abandon kids for minor disabilities or things that could be managed in the home if there was support and if the medical health professionals treated differently children born with disabilities. So there's a whole kind of body of work right now on deinstitutionalization. And I think on one hand that's encouraging, but where I've seen it playing out in a few places it's not being done well. It's being done too quickly. It's being done without due regard to follow-up, without proper planning. It's actually, deinstitutionalization is actually more expensive in a period of time, as you probably know so well, rather than saying, well, you're going to save money by doing this. Actually, it's going to cost you a little more in the interim as you transition kids and change your system. So for me, that's a little bit of a challenge. So my preference is this whole issue of preventing institutionalization. And I think where we are seeing some trends, and as I said, one of the strategies for violence prevention in children, and if we consider that institutions are sites of violence for many children, early intervention in families, family support, that whole piece is just something we have to do a better job of, obviously linked to social protection, linked to family support mechanisms, livelihood creation, and it's fairly complex there. The super negative thing, and I hate to end on this, but in the third committee of the UN, might have been 18 months ago, maybe 2 years ago, actually called for, just like the Michelle study and the Pinheiro accent, but I'll sort of give you the tone. Do children really have rights? And it was a serious question. If you could have seen my facial expression, it was sort of a deer in the headlights kind of thing, but thankfully we weren't on Skype, we were just on the phone. When you work for UNICEF for 25 years and when your career has grown from the drafting of the UN Convention and you've focused on the implications of that treaty, you never ask yourself whether children have rights or not. They just do. As a little aside, I will say that one wavers slightly from one staunch, hard, fast child rights positions when you have your own children, but I digress. So this query from a journalist reminded me that undoubtedly for most people, the notion of children actually having rights is a foreign one. For many, children are dependents. They lack agentive capacity. They do not vote. They're even seen as property in many parts of the world, or they're just mini adults. As you have by now confirmed, the Convention on the Rights of the Child, and you mentioned this in your opening remarks, is the most widely and rapidly ratified convention in human history. It is a treaty that covers children's economic, social, political, and cultural rights. And the UN Convention on the Rights of the Child, I'm sure we'll hear more this afternoon, has 4 general principles. And these are principles that intend to govern its implementation irrespective of specific context. First, the right to survival, actually in no particular order. Non-discrimination, the best interests of the child to prevail in decision-making, and child participation according to evolving capacity. Governments, non-government organizations, and UN agencies took part in drafting the convention. It took them 10 years to reach agreement on this historic text. So I was actually, in my very first job, the chief photocopier in residence during the last 2 years of the drafting process at UNICEF in New York. I was 24 years old, and with a newly minted undergraduate degree, I arrived in New York from Toronto to take up an internship. I was probably pretty good at it because they did actually offer me a job 3 months later. But suffices to say, I was instantly gripped by the mission of this incredible organization and its newfound commitment to taking a rights approach to children. I use the term newfound deliberately. UNICEF came late into the game of convention drafting. There were many reasons to be hesitant in the mind of the then executive director, Jim Grant. The completion of the convention drafting must be credited to a full range of civil society and other partners. UNICEF helped to bring the drafting to a finish, and I accompanied the clever political maneuvering that resulted in the convention's swift ratification and entry into force. Now, I don't know if you have to be obsessed with children or obsessed with the law to get excited about an international human rights treaty, but for those of us who were concerned with the protection of the world's children, this was a groundbreaking and international human rights piece of legislation, and it still is today. A few facts. Children in the convention are defined as those under 18, and there are articles in the convention ranging from child labor, trafficking, to children and war. Other articles touch upon children having a voice in decisions affecting them. The convention mentions the right to a name and a nationality, and Article 4 of the convention calls upon states parties to allocate financial resources to the maximum extent possible, and also asks for their assistance where they have the capacity to other countries. Equally interesting and important are 3 optional protocols to the UN Convention on the Rights of the Child. I think these protocols demonstrate that this is very much a living convention, that it's adapting to current issues and contexts and looking at things that were perhaps overlooked or too contentious in the drafting process to be included. One protocol refers to the sale of children, child prostitution, and pornography. Another protocol focuses on the effects of children and war. And the third and latest protocol creates a complaint mechanism for individual children. In my opinion, and having seen the convention brought to life in varying degrees in countries around the world, I submit to you that the convention forces us or allows or encourages us to see children in a different way. They are human beings with rights. In so many places, from Europe to Africa to Asia and the Americas, the convention and its relationship to national and state or provincial legislation has triggered a very important process of social change. Now, this is especially true, that social change component is especially true in contexts where domestic law reform involves public discourse and debate. When citizens, including young people themselves, discuss issues and give voice to matters affecting children, and with a view to possibly even codifying them, things start to change. Examples of this are endless, but I want to give you two, each at opposite ends of the political, cultural, and geographic spectrum. For the first example, travel with me to a small Nordic country. With a manageably sized population and admittedly socialist politics, this country, I'll give you a hint, they speak Swedish there, decides that all forms of corporal punishment against children must be banned. In Sweden, then, there was much public discussion, laws were reformed, information flows about this new legislation were dramatically boosted with public financing, and over the course of a generation, the practice of beating, berating, and degrading children to punish them ended. I don't want to really get into a debate about cause and effect, and I'm most certainly simplifying what is a very complex process and what it takes for social change to be cemented in a culture. But suffices to say that public and dialogue-informed law reform has an important role to play. The second example is a much more current one, and it takes us to South Asia and the beautiful country of countries, India, where I spent a good part of my UNICEF career. You may recall the gang rapes, as we all learned about on a bus in New Delhi in 2012. Sexual violence is neither new in nor exclusive to India. However, the particular case in New Delhi brought with it national and international public outrage. As an aside, 120 million girls around the world experienced sexual violence last year. However, it was in India that students protested on campuses across the country. I would argue that this was at the very least linked to the rapid turnaround of the Verma Commission, and that in part responsible for some important changes in Indian legislation on rape. Has sexual violence ended in India? Most certainly not. As this abhorrent form of violence continues, including on college campuses in the United States, in the Indian case, it is arguable that social change is emerging in the context of this crime. It will necessarily need to be accompanied by changes in attitudes towards women and girls, and in addition to addressing other aspects of discrimination and inequality that prevail in far too many places. Ending impunity is and will continue to be of prime importance. So a little final comment from me on children's rights, rhetoric, and reality. To be sure, enormous gaps exist between the national legal reforms that have followed the ratification of the Convention on the Rights of the Child and practice. And I think we heard a little bit of this morning, actually, where we have the sort of international rhetoric and even maybe some federal, and how it translates is just so fundamentally important. But laws have to be resourced and implemented. Where I see the biggest omission and the greatest inaction are places, even with functioning democracies, where the social construction of childhood is stuck in time. In these places, of which there are far too many, children's lack of political voice translates for policymakers and politicians into inertia. As mentioned earlier, Article 4 of the Convention tells states that they have to allocate resources for children to the maximum extent possible. That is, for too many, far too big a loophole. How long is a piece of string is pretty much synonymous with to the maximum extent possible. The rights of children, I argue, and will continue to argue, are not an add-on or something to factor into whatever is left over at the end of budget talks. They should be front and center. So to turn to the UN itself for a few minutes, when we ponder on the inertia we see and the loopholes I've referred to, it's pretty much everywhere. Who makes things happen for children? Who creates change, and how? Just as it takes a village to raise a child, it takes an international community to save and protect its children. I'll turn to governments and civil society organizations in a moment, and I'll lead with the UN. Rest assured, I hasten to add, I'm not making a plea for the UN as an unflawed, perfectly effective, always doing the right thing institution. I'll let you pause on that for a second. I am saying, however, that having had a frontline view of UNICEF in action in a number of countries, I remain convinced that the world would be a worse place without at least this complex, well-intentioned bureaucracy. I'm equally convinced that we can do better in partnership. So for those of you that are not aware of the organization, it's the leading UN agency when it comes to children, and it was born in the aftermath of the Second World War. UNICEF was then called the International Children's Emergency Fund. The late and very dignified Audrey Hepburn recalls benefiting from milk that UNICEF delivered to her and other children. And another example of the long recollection of receiving from the organization, there are many elderly people in Japan who recently participated in a survey and who hold UNICEF as dear to their heart as some of their family members for the day that food supplies they received from UNICEF reached them as children. This fund, related to but financially independent from the UN, has evolved from that supply-driven, emergency-focused mission to one which embraces human rights and the rights in particular of children in all settings, so humanitarian as well as non-humanitarian. Other UN agencies also have the rights of children within their mandates. The UN High Commission for Refugees has a special interest in statelessness and children and best interest determination in the context of separated and unaccompanied children. The Office of the High Commission for Human Rights is home to the UN Committee on the Rights of the Child, for example. And this is the 18-member body that oversees implementation of the Convention on the Rights of the Child. The ILO, the International Labor Organization, oversees implementation in particular of its two conventions, 138 and 182, that govern work on child labor. The UN Office on Drugs and Crimes has a special focus on child trafficking, and DPKO, or the Department of Peacekeeping Operations, has had a hand in the work to keep children safe in war-affected settings, not doing so well with the peacekeepers. UNFPA works with UNICEF and others on issues such as female genital mutilation and cutting and child marriage. And finally, but in no way exhaustively, WHO addresses a range of child health issues, most recently including mental health, non-communicable diseases, and importantly, violence. And I quote, this is their resolution on violence against women and girls and children. We could talk about that in Q&A if you like. It's fair to say that there is an unprecedented high level of commitment from the current Secretary General, whatever criticisms or observations we may have about the Secretary General. He has given particular primacy to issues important in the lives of the world's children. I am reminded of a meeting I attended with the Secretary General a few years ago with the New York representative of the Holy See and the chair of the Committee on the Rights of the Child. We were to discuss sexual abuse and the church. And when I left that meeting, I remember looking across the lawns of the UN at the East River, thinking how incredibly historic that moment would be to millions of victims and to the future protection of millions of children. The UN also has a never-before list of special representatives of the Secretary General and special rapporteurs working unstintingly and for no money that are advocating for children. There is a special representative of the Secretary General on children in conflict, a second on children in violence, and a third on sexual violence in conflict. The special rapporteurs, again, not exhaustively, cover subjects such as education, health, torture, trafficking, and the sale of children, nutrition, and a litany of child-related issues. And again, as I mentioned, they work on an unpaid basis to sustain the interest of states parties in fulfilling their obligations and to apply a little pressure where it's needed. I've used this word already, and I want to dwell on it for a minute. Partnership is crucial. In every country where I've been posted, local civil society organizations have been on the ground at the forefront and are there to stay. And I think in the panel this morning, we heard about the importance of those organizations, both advocating for children and also doing some service delivery. These organizations, these civil society organizations, go places that others will not, speak truths that others will not, and are there for the long haul. I have met some amazing people with incredible dedication in these organizations, and they have indulged me over the course of my career as I have learned and grown. Time is too limited to name names, but I have the strongest recollection of working with the late Salma Soban and Hamida Hossein in Dhaka, and I just want to use this as an example. They, together with, and you heard in the introduction, Tarek and Catherine Masood, Bangladeshi-American documentary filmmaking family, basically. Tarek was the first Bangladeshi director ever nominated for an Oscar for his work on the War of Independence in '71 in Bangladesh. So Salma and Hamida and Tarek and Catherine taught me firsthand about the complexities and intricacies of childhood in a place like Bangladesh. Salma and Hamida had a grassroots organization called Aino Shalish Kendra, working with urban slum and street children. And I want to just use them as an illustration of impact of a civil society organization on a very intricate a piece of documentation, which I think is relevant even when we think about the migrant children from the Northern Triangle. I know Shalish Kendra tackled a problem too big for any UN agency and squarely a child rights concern. Street children in Dhaka were being, and during my time there, before and after, I'm sure, picked up by police, brutalized, raped, and even made to disappear in some instances. Unable to get officials to crack down on law enforcement, Salma and Hamida studied the problem. The children on the streets with some kind of identity, a card, a birth certificate, anything stated that someone knew them or they were attached to someone, were not harassed. Children without ID were victimized. Aino Shalish Kendra could not swiftly reform a defunct civil registration and vital statistics system, but they could produce ID cards, and that they did. These were small, laminated cards with the child's name, some identifying features, and with the address and the phone number of Aino Shalish Kendra on the back of the card. The message was clear. If this child goes missing or is hurt, someone will be looking for him or her, and you will be held accountable for any harm. This is but one example of civil society in action. International non-government organizations are powerfully important too. In addition to community-level access, unlike UNICEF as a government-to-government body, NGOs have an enviable nimbleness and freedom. They can, among other things, work alongside the faith-based community in very simple day-to-day ways, and I'm thinking in particular of World Vision. But others, like SOS Children's Villages, take up very specific issues, such as creating permanent family-like environments for children without parental care. SAVE, Plan, Terre des Hommes, and the Child Fund Alliance are others in the civil society or NGO world that are doing powerful and important work in the lives of children. And in contrast to UNICEF, many of them are operational in high-income settings, like here in the United States, shedding a light on children who bear the brunt of inequity in these societies. It's been a great honor for me to work alongside these organizations during the course of my career. And as you heard in the introduction, that has largely been a career focused on child protection. For the organization, this has been a non-traditional area of focus. UNICEF started, as I said already, with the delivery of emergency foods and medical supplies, and it developed into an organization that really had child survival at its core. Under the leadership of the aforementioned Jim Grant, growth monitoring, oral rehydration, breastfeeding, and immunization with the acronym GOBI became the mainstays. Arguably, nothing has done more to save the world's children than the investment in and delivery of vaccines. The global partnership Gavi has a great deal to be credited with. But for someone like me, who entered into the work in the final days of the drafting of the UN Convention on the Rights of All Children, I was pretty unsatisfied. My first field posting was in Sri Lanka. That might have been why they got me out of New York fast, where there was a real war going on. Its impacts on children were devastating. I arrived there in 1988. Villages were being massacred not once but twice. Children living with disabilities were suffering exponentially. And if you'll allow me to digress for a moment, I want to share with you one thing that, as I was writing this, came up as probably one of my most powerful memories of that work now 25 years ago. But I remember we were visiting a remote village where there was a child living with cerebral palsy, and he was locked in a shed day in and day out. His food was slipped in under the door. He was about 7. And I remember just being so kind of shocked by that. And this was a village that had been experiencing war. And one of the most important lessons I learned at that exact moment was that his parents were not horrible people. They were told he was cursed. They didn't know what to do with him. And with the war raging on, there was little access for experts or even paraprofessionals to help him. I remember then saying to myself, this is it. I knew that just saving children would never be enough for me. Save children from preventable diseases? Yes, absolutely. But then and now, I had a conviction that we must help children live completely, wholly, safely, and with dignity. Lest this sounds heroic or crazy, on some level at about the same time, UNICEF got its first executive board paper on what were called Children in Especially Difficult Circumstances, CEDC. There were people in that boardroom in 1986 reading that paper who learned about children as soldiers, children on the streets in Latin America, and children in brothels in South and Southeast Asia. If those were transformative years for me, they were profoundly transformative for UNICEF. Some of you will recall that by 1996, the seminal study by Graça Machel for the UN Secretary General on the horrific impacts of war on children was completed. She wrote of their recruitment and use as soldiers, the sexual violence they experienced, and of their killing and maiming. What ensued was an extraordinary commitment of the UN and the Security Council to the protection of children from war. The Secretary General appointed the special representative I mentioned earlier, a position occupied today by an incredible SRSG from Algeria, a lawyer and human rights advocate, Leila Zerougi. The creation of this office accompanied a litany of Security Council resolutions of the impacts of war on children, including Security Council Resolution 1612. And this is a resolution that allows the Secretary General to name and shame parties to conflict, and that holds them accountable for ending violence and crimes against children. Interestingly, UNICEF's work to protect children from violence is the only part of UNICEF's mandate that is considered and guided by the Security Council via, in particular, the Security Council Working Group on Children in Conflict. Now, fast forward 10 years, in 2006, not so long ago, again at the behest of the Secretary General, Brazilian lawyer, Brown professor, and human rights advocate Paulo Sergio Pinheiro completed a global study for the Secretary General on violence in children. As with the Machel study, he forced for the Secretary General a discussion at the UN on violence against children, and this time in all settings, with the exception of war, which we all felt had been well covered by the Machel study. I was part of the editorial board of that violence study, and rest assured, there were some very tense moments in the write-up. Taking a public health and human rights approach to violence against children, the study suggested that violence knows neither geographic nor economic nor cultural boundaries. It cuts across all settings, is experienced by boys and girls, those living with and without disabilities, the LGBTQ community. It painted a grim but somewhat optimistic picture, suggesting at the end in its conclusions that violence is neither justifiable but nor an inevitable part of life, that violence against children is preventable, and I'll come back to that at the end of my remarks. The study was published just prior to the adoption of UNICEF's first board strategy on child protection in 2008. So it took the organization a pretty long time to move from 1986 and kind of paying attention to these issues to really demonstrating the conviction from its board that this was squarely at the heart of the organization's agenda. And that's when I got the phone call when I was very happy at the Florence, Italy Research Center doing my work, and would I come to headquarters and help the organization to embrace this new strategy and make sense of it. I'll come back to the strategy for a moment. I want to just take a couple minutes, since we're at a law school, to talk about the alignment of international law for children as it plays out on the many issues that you talked about this morning and that I've touched on. There are in fact three streams of international law, and maybe you've covered this in coursework, but that are relevant to the protection of children from violence, abuse, exploitation, and neglect. And it's the only part, I think, of work in the field that brings these three legal streams together. And of course, I'm talking about, and I'm not doing these in any order, but human rights law, the public law in this category, treaties like the UN Convention on the Rights of the Child or the Palermo Protocol on human trafficking. These are powerful instruments open for state party ratification, and they form a reference point for both advocacy and action. So another stream would be international humanitarian law. It's also crucial to our work to protect children from violence. It is applicable in situations of conflict, and you can think, probably some of you have studied the 4 Geneva Conventions that are particularly relevant. They aim to limit the impacts of armed conflict, in particular on civilians. And within international humanitarian law, we find powerful calls for humanitarian access during times of war so that supplies and other resources can reach families and children in distress. And the third stream that I don't think probably gets talked about very much, and how all of these three sort of come together in certain contexts, is private international law. In this regard, I'm referring to the 3 Hague Conventions that address child protection, child abduction, and inter-country adoption. Private law has neither a humanitarian focus nor universal applicability. It is a law that binds 2 countries calling for their agreement on matters of jurisdiction, among others. And I want to just dwell for a second on the law on inter-country adoption. And I do that because I'm very close friends with the U.S. Ambassador on Children's Issues, who's wrestling with this law every day and doing an absolutely fantastic job. But I think it's kind of a good illustration where best interest is sort of in the Convention on the Rights of the Child. We have it in the Hague Conventions, and it's kind of, it creates some complexities, I think, that are pretty interesting. So to quote the State Department website, to bring this example home for you, the Hague Convention applies to all adoptions by U.S. citizens habitually resident in the United States of children habitually resident in any country outside of the United States that is party to the convention. These are called convention countries. Adopting a child from a convention country is similar in many ways to adopting a child from a country not party to the convention. Sorry for reading this off. However, there are some key differences. In particular, those seeking to adopt may receive greater protections if they adopt from a convention country. So the Hague requires that countries who are party to it establish a central adoption authority to be the authoritative source of information and a point of contact in the country. And this is what I think is so important about the convention, and I know there are criticisms and there are ways it could be improved, but the Hague Convention aims to prevent the abduction, sale of, or trafficking in children, and it works to ensure that inter-country adoptions are in the best interests of children. The convention recognizes inter-country adoption as a means of offering the advantage of a permanent home to a child when a suitable family has not been found in the child's country of origin. It enables inter-country adoption to take place when certain steps have been followed. So I think that I've just really flown through those 3 streams of law, and I'm dying to get someone to write a thesis on the intersection of public and private law and best interest principle or something, just throwing it out there. I've been doing that for the last 4 years. So I wanted to just talk a little bit about the 2008 strategy that I mentioned UNICEF's executive board adopted. And when the board adopts a strategy, it isn't for UNICEF. It's meant to be for the UN as a whole and for member states and then for other partners who are helping to do things for children. So the board recognized, I think, the strategy because, importantly, it was written at a time when UNICEF and major civil society organizations and governments in many parts of the world were realizing that this issue-by-issue approach to keeping children safe really wasn't very effective. So we were seeing sort of, the rescuing of trafficking victims, and then they'd reappear in a child labor site of exploitation. And so the issues, if you just deal with them in a siloed approach, really approaches tend to be not as effective. And I say that both from a cost-effective as well as the perspective of creating sustained change. And I think child trafficking is probably the best example of that, and I think that holds true here. But even the panel this morning, I felt like if we're not taking a systemic approach, also in countries of origin, I think the possibility of sort of stemming the flow of discrimination and marginalization is could be less effective. Shifting focus to establishing or strengthening systems from social welfare to justice to law to education to health. Again, relevant to this morning's panel. It's all of those pieces that really need to come together. But I wanted to point out that at the same time, there are harms to children. So one part of the strategy talked about system strengthening, but the other really addressed harms to children that are not fixed by service delivery or remedied by by service delivery in isolation from social determinants. Again, it's such a perfect setup this morning with the panel. I think one of the questions at the end was really, a lot of what's happening to children is about attitudes. It's maybe not that schools aren't there or not that there aren't services, but it's mindsets that need to be changed. And I often refer to these as social norms, societal attitudes and practices, and societal acceptance of various forms of violence, marginalization. There are endless examples, and I'm certain you can come up with a few more of your own, but I'll give you a few that have resonated for me in my career around the world. In some countries, the norm is the abandonment of children born out of wedlock or with a disability. When we see norms change, we see families raising children with disabilities appropriately counseled by medical health and social welfare practitioners, and this is a trend we're seeing in Eastern Europe right now, where children with mild to medium disabilities are actually able to be raised in their families because of the support they're provided and because the medical health professionals don't go, oh my goodness, and react in a way when the parents are told what the child is going to be living with, but in fact, sort of changing the way the medical health professionals counsel families too. The same holds true in communities that would exclude young single mothers. And let's say, and I've seen this in various parts of the world, but a 15-year-old girl who herself was a victim of sexual violence, she is isolated often, abandoned by her own family, and struggles to raise her own child, and cycles perpetuate themselves. The community can be changed by community members from the inside out to accept her and go further, to be supportive and helpful. There are countless other examples of socially determined practices that rely on changing attitudes and behaviors, which one would think is not particularly costly. Child marriage, female genital mutilation and cutting, corporal punishment, and the stoning of women and girls. They depend on people for them to change. At the same time, they're deeply embedded in families, communities, and societies, so change is actually a lot tougher than it looks. It can take a generation or more. The best two examples of this, where there has been change, but where it's taken a very long time, I mentioned already corporal punishment in Sweden. Think about foot binding in China. These are two practices that are now historic, but not without decades of effort, law reform, public discourse, and campaigns. I wanted to talk to you very briefly about a couple of settings, and I think they're important because we're living in very rapidly changing times right now, and the settings where this work to keep children safe from violence are changing, and I'll share with you an opinion about that. Humanitarian settings are contexts where there is a conflict or natural disaster or some combination of both. By contrast, the situations outside of war and disaster have been called development settings in my field. But increasingly, and again, this is an opinion, but you could say you were here when it was sort of put out there, so I think it's going to stick. Not because I said it, but it's the way the world is. The use of the word development is becoming irrelevant. All countries are developing economically in one way or another, and all countries are developing socially. Development used to mean rich countries of the north versus poor countries of the south. Data now tell us that by 2020, the bulk of the world's most marginalized children will live in middle and high-income countries. Now, we may end up, I would posit that we have terminology like humanitarian and non-humanitarian lowering the north-south divide. And this is in part the spirit of the post-2015 agenda, Agenda 2030, that I mentioned at the outset. The so-called playing field is being leveled as an increasing number of countries become middle and high income, and as countries the world over, irrespective of income, find that they have shared challenges and solutions to those challenges. So this will turn me to the last part of my remarks, but the SDGs, Agenda 2030, and this new global partnership to end violence against children. Think of it as the Gavi for violence prevention in childhood. There is no immunization, but we have some solutions. This is a perfect segue into sort of sharing with you, I think, maybe some of the anguish of the first 6 months as the director of this new global partnership. It's being set up as a means of implementation, just one means of implementation of the new agenda, the new Sustainable Development Goals. It is buoyed along by a professor from Georgetown who is my boss, Anthony Lake. who I think had the wisdom to see that we're entering into a new era of work as an organization, and that partnership and this level playing field I've referred to are just so incredibly important if we're going to make a difference. Child Fund, International World Vision, SOS Children's Villages, Plan, SAVE, and a number of other NGOs are a big part of the inception phase of this new partnership. Likewise, the World Health Organization has played a major role, and we are generously supported, in addition to UNICEF financing, by a small group of foundations that refer to themselves as Elevate Children. Violence is a phenomenon that impacts children in every country in the world, including in the United States and in my own home country of Canada. To the point of this being a global problem, I wanted to share with you, after being outside of Sri Lanka for 25 years, 3 weeks ago, I was asked to come to a discussion there on violence and children in the region. And during the few days I was in Colombo, I was consulting with Sri Lankan officials and others in the region on violence. And though the war has ended in Sri Lanka, I listened to story after story of sexual violence, child trafficking, child labor, online violence, bullying, child trafficking, to name but a few of the experiences of children, both in the country and in the region. So indeed, it's true that there is peace in Sri Lanka now, but for countless children, there's no freedom from fear. And globally, the statistics are pretty staggering. Every 5 minutes, a child somewhere in the world dies as a result of violence. I mentioned already that 120 million girls, but also 73 million boys have been victims of sexual violence over the past year. And according to a recent study published in Pediatrics, and the authors were 2 or 3 scientists from the Center for Disease Control, in the paper they published, they suggest that roughly 1 billion children between the ages of 2 and 17 experienced violence during the calendar year 2014, and that's based on some pretty robust surveys that are going on. 1 billion children. I had a New York Times writer just tell me he just couldn't believe it. You couldn't publish the op-ed of a professor at Harvard. He's quite famous for his work in this area because they just thought the number was inflated somehow. And in my opinion, that's 1 billion reasons to step up, speak out, and to take some action. Now, some of you will recall the glaring omission of the protection of children from violence, abuse, exploitation, and neglect in the Millennium Development Goals, or the MDGs, which we've just ushered out. The omission undoubtedly had an impact on the achievement of goals that were in the MDGs, such as in education and health, for example, perhaps also in gender. A child who faces violence on the way to school, or we heard on the panel this morning, who may have come from violence or is fearing structural violence, I think we could call some of what we were listening to, those children will stop going to school. In the same way, success in keeping children alive in the first 5 years in some parts of the world, those success stories in the first 5 years are lost to violence in the ensuing 10, and I'm thinking in particular about the Northern Triangle. Violence in childhood is a stark and definitive impediment to a country's economic and social progress and a moral outrage. So it's not an accident that on the 4th of January this year in New York, the new global goals entered into force with the protection of children from violence, exploitation, abuse, neglect, torture, etc., became an integral part of the international agenda. Like-minded leaders and dedicated lobbyists and activists had a vision, and they were unstoppable in negotiating the right agenda for children. In particular, in Target 16.2 of 17 Sustainable Development Goals, but in other targets going beyond 16, the rallying cry is clear. We need and want to create a world where it is safe to be a child. So the new global partnership is but one platform for Agenda 2030. Our intention is to change the way all of us, including policymakers, governments, and campaigners, think about the prevention of violence. We need to be winning the argument that societies should and can be safe for children. The partnership is based on a commitment to the rights of all children. It will turn the belief that no violence against children is justifiable, all violence preventable, into a compelling agenda for action. The partnership will serve as a multi-sectoral, multi-stakeholder platform. The stakeholders are governments, civil society organizations, academic institutions, the private sector, leaders of the faith-based community, foundations, the UN, and young people themselves. At the global level, the partnership will focus on building political will to end violence and making violence prevention a priority. It will also serve as a catalyst for expanding the movement to end violence based on an understanding that there must be a change in the attitudes and the norms that tolerate violence. This can be done at all levels, but importantly, the real movement building in the partnership will take place in communities all over the world, ideally with young people active and engaged. Civil society will be a key part of the movement we hope to ignite. We are solution and prevention focused in our zero draft strategy. Experts under the leadership of the World Health Organization and from a variety of sectors have come together to create an evidence-based package of solutions. They are not creating them on the basis of goodwill or some kind of crystal ball. They've actually looked at randomized control trials and other evidence bases that tell us that these solutions, these strategies for violence prevention have been effective over the last 2 decades. They include social norm change, legal and policy reform, early intervention in families, social protection, service provision for victims, and the empowerment of young people and their caregivers. This is one of the most exciting developments, I think, that I've seen in my time. A whole field from child protection to health to education to justice coming together behind a common set of interventions that work. They work differently in different contexts, but we're speaking a common language now and undertaking some common actions. In our zero draft strategy, we introduce a concept of pathfinder countries. And these are places where there is demonstrated strong commitment to accelerating efforts to make children safe. In pathfinding countries, for example, partners will provide technical support to a whole-of-government approach to violence prevention. This will involve the development of a roadmap for implementation of the strategic package I just mentioned, and a national commitment to increased financing. We'll create a platform for knowledge, live knowledge sharing across countries, and catalytic funding from an associated trust fund will be provided where possible. And that trust fund benefits from an initial £40 million commitment from the UK government. We're hoping to raise $1 billion over the course of the next 5 years for that fund. These Pathfinder countries will be demonstrating that violence can be prevented. Pathfinders will both innovate and scale up. So unsurprisingly, and there's a bit of a joke about this, that if you can't get Sweden into your partnership, it's probably not a great idea, but Sweden, at the level of the Prime Minister, was the first country to declare interest in pathfinding. Sweden was swiftly followed by El Salvador, Paraguay, Mexico, and the Philippines. The partnership is in conversation with Romania, Tanzania, Indonesia, and Sri Lanka, and we've had informal discussions here in the United States and in Canada and the UK. So you can see it's quite a range, and this really speaks to, and we consider the partnership to be a test case for the universality of the Sustainable Development Goals and Agenda 2030. In 2017, most likely in the fourth quarter, we're going to have a solutions summit, and Pathfinders will share experience of what's working and what the challenges are. From that point, the partnership will continue to strengthen online and other knowledge-sharing means. New Pathfinders may emerge. We have, for example, already been asked if regional bodies, such as the Global Movement for Children in Latin America and SIBAC, the South Asian Violence Against Children Coalition, can become Pathfinders. Chicago also queried us informally about the possibility of being a Pathfinder city. Pretty excited about that. And I was in Beloit, as I mentioned, a couple weeks ago, and I threw that challenge out to them too. As a global platform for advocacy, the partnership will use its convening power to help expand the global movement against violence both within and across borders. There are many efforts in existence to protect children. I'm thinking of Together for Girls, Girls Not Brides, the Movement to End Female Genital Mutilation and Cutting, and the Global Alliance for Children, funded by the US government, to name but a few. We're going to work with these existing partnerships, build on their strengths, and fortify what we hope will be an unstoppable force for change in the lives of millions of children the world over. As I mentioned earlier, this work will have to include strong engagement with civil society that are working in particular to address social norms and attitudes. All governments, non-government organizations, foundations, and other entities can be part of the partnership in differing ways. We're going to have a call to action in New York during the High-Level Political Forum. That's the body that's going to meet every year at ministerial level, except for every 5 years when it'll be head of state to review progress on the SDGs. As I said at the outset, Agenda 2030 is for us all, and the partnership is a real test case for universality. Now, just to conclude, since I'm here as your guest in the Capitol, here in the United States, congressional champions for the protection of children in overseas development, in consular and trade matters are desperately needed. Violence against children is also relevant at and within the borders of this great country. I know of two particular organizations who've actually reached out to us. One, the Avielle Foundation, and Cure Violence, which you may have heard of, working in inner city Chicago, in New York, and in other parts of the world, South Africa, Jamaica, together with others, are calling for a White House summit on violence against children before the election this year, before the administration changes. The partnership is supporting that call and working with a 501c3 entity called Civic Nation, which is where the U.S. campus initiative on It's On Us is actually housed right now. To everyone in this room, I want to conclude by asking that we all be inspired by the 1 billion reasons that exist to end violence, the 1 billion child victims here and everywhere in the world. Let us be buoyed along by the knowledge and the evidence that violence against children can be prevented. The solutions are in our hands, in all of our hands. So I want to thank again Georgetown University and for the warm welcome here today and for allowing me to be part of this important discussion. Thank you.
Thank you very much, Dr. Bissell, for that extraordinary talk. We have time for some questions and answers. Dr. Bissell has agreed to take them, so if I can get this to work. In any case, does anybody have any questions? Eric? And if you would identify yourself again, and anybody else who has questions, so Dr. Bissell knows who you are. Thank you.
Yeah, hi, my name's Eric Rosenthal with Disability Rights International. Fascinating to hear your story from photocopying at the drafting session of the convention on the violence against children work. And given your knowledge and experience with the sweep of the development of international law, I'm interested in your views on orphanages and institutions for children, and whether we might ever see a day when it's considered inherently a violation of human rights to put children in institutions. My organization documented atrocious abuses, not only in orphanages, but the kind of uncounted children who end up in psychiatric facilities, many other kinds of institutions. And, you know, the international standards all say, you know, that children should be in families except for the following, and you can go through the check marks that are there as a last resort, and yet we have, you know, millions of children who remain in institutions today. Where do you see that going, and what might we see in our lifetime or sooner an end to the institutionalization?
It's such an important question and an important area of work. So a couple of things maybe to the negative, and then I'll try to take it a different direction. But first of all, we are seeing, now let me start with positive trend, and certainly in parts of Eastern Europe, I don't know if your data shows this, but declines in the use of institutions, especially large-scale institutions, as homes for children needing alternative care. And the one example I used, I think, is probably one of the better ones, looking at Montenegro and some of the surrounding countries. So wherein, parents don't abandon kids for minor disabilities or things that could be managed in the home if there was support and if the medical health professionals treated differently children born with disabilities. So there's a whole kind of body of work right now on deinstitutionalization. And I think on one hand that's encouraging, but where I've seen it playing out in a few places it's not being done well. It's being done too quickly. It's being done without due regard to follow-up, without proper planning. It's actually, deinstitutionalization is actually more expensive in a period of time, as you probably know so well, rather than saying, well, you're going to save money by doing this. Actually, it's going to cost you a little more in the interim as you transition kids and change your system. So for me, that's a little bit of a challenge. So my preference is this whole issue of preventing institutionalization. And I think where we are seeing some trends, and as I said, one of the strategies for violence prevention in children, and if we consider that institutions are sites of violence for many children, the early intervention in families, family support, that whole piece is just something we have to do a better job of, obviously linked to social protection, linked to family support mechanisms, livelihood creation, and it's fairly complex there. The super negative thing, and I hate to end on this, but in the third committee of the UN, might have been 18 months ago, maybe 2 years ago, actually called for, just like the Michelle study and the Pinheiro study, called for an independent study on behalf of the Secretary General on children deprived of liberty, which would have, if it was executed, probably shed a lot of light on these things. I would include drug detention centers, and I've seen them in Southeast Asia. They're appalling. But no government has stepped up. No UN agency has stepped up to house it, and no government has stepped up with money to fund it. And I think that's a pretty good indication that we don't have the kind of political will to change what you're describing. The Special Representative of the Secretary General on Violence did phase 1 of that study from her office, so it's hardly independent, but she did sort of try to keep the flame alive there, and Human Rights Watch and Defense for Children International are also pushing to have the study done. I'm a fan of those studies when they yield some kind of result, and on this one, because it's so in the shadows or in the dark, I think it would be important that we get that done. So if anybody can influence the U.S. government to put some financing into it, that would be a big start. I think it's a scary one for many organizations.
Is it working? Yes, it's working. Hi, I'm Marty Scher. I'm with, as are a number of other folks here, with the U.S. campaign for ratification of the CRC. I know you're familiar with the organization. I'd like to ask you to comment a bit. As a Canadian, you may be a little reticent to do so, but go ahead anyway. Other than symbolic, how important do you think it might be for the U.S. to ratify the CRC?
Are we still being taped here?
Yes, we are, Dr. Bissell.
Okay. Well, I think it's symbolically and practically important. As some of you will know, the United States has ratified 2 of the optional protocols, and I actually helped write the reporting guidelines for the optional protocol on sale, prostitution, and pornography, and we made them sufficiently broad so that any non-ratifying country of the main treaty would still be reporting on quite a bit. And to the credit of the Americans in this room, the reporting has been excellent. So it's not like there's a lot that's being missed. I would, however, say that, and I'll say in the face of the issues that the panel so eloquently presented this morning, I think that it's more than symbolic that the rights of children from other countries are recognized as children, and that the convention could go a long way, I think, to shining a spotlight on that. I also feel strongly about it now in my new vantage point. UNICEF doesn't work in the United States, and the partnership won't actually be operational, but we're going to be talking about these things, and these issues that we're facing in Agenda 2030 are global and universal, and they're squarely in the Convention on the Rights of the Child. So for me, it doesn't make a lot of sense to be, trying to beat down doors on these issues when there's this glaring treaty that's right there, that the 4 general principles for which are actually relevant in things that are happening here. So, I'm a big fan of trying to get the job done, and I know we'll hear about that at the end of the day, but maybe there's a chance. But I think it's important.
Any other questions for Dr. Bissell right now? One last one. Excellent.
I'm Nassim Kurosh. I'm also with the U.S. Campaign for Ratification. This is perhaps a third rail issue, and you may or may not want to address it, but you spoke about corporal punishment, in Scandinavia, and this is something that is a very live issue in the U.S., as many of us saw with the Adrian Peterson scandal and the whole question of child abuse. And I think really in the U.S., law and policy may not be a solution, may not be the way to solve the problem, at least in the short term. And what I'm thinking about is sort of the discourse, the public discourse around the issue, and to your point about social norms and attitudes. How can we talk about this in a way that is, not divisive, not politicized, but actually gets at the human rights core of, the child abuse issue. And I think in the US, they did some studies after the Adrian Peterson scandal, or they did some polls, and there was still something like 60 or 70 something % of Americans still approve of, corporal punishment, physical discipline. And of course, then there's also the issue of where you draw the line between what is, quote unquote, appropriate physical discipline, if such a thing exists, and child abuse. And why is it that there's actions that we would consider criminal if committed against another adult are acceptable when committed against someone half your size who can't defend themselves? So I'm just wondering if you have any thoughts about, this is way outside the wheelhouse of the campaign and the CRC efforts. This is not something we engage in at all, and I don't think can necessarily be remedied through these kinds of channels. But just to the point of social norms and attitudes and the public discourse around the issue, if you have thoughts on that, for us here in the US, I'd be interested to hear them. Thank you.
I'm glad you said thoughts and not, recommendations or anything. That would be pretty arrogant. But, I was hopeful. Was the case you were talking about was the football player, right? Yeah. So I was somewhere else in the world when that happened, and I went, oh, great, because there's a chance, we can crack open a conversation in different communities in different ways, because that's how I think it really happens. I used the expression once, my own team were sick of me saying change happens from the inside out, both as individuals but also as communities and as families. We need to get into these places where there are examples, where there's leadership that comes from within the community and the culture. So the sporting world, I think getting in there, and I was disappointed, by the way, at where that all kind of landed at the end. But we have other examples, and I'm sure that we just need to give more of a platform, encourage the conversation. And here's the other thing I wanted to say when I first heard you talking. I think we have to get out of the kind of corporal punishment discussion and think about parenting. And what are some alternative forms of parenting that don't involve violence? And there are. I mean, and not to use my own country as an example, but the Canadian Health Ministry, on their website have stuff on parenting and disciplining kids. And we need to dispel some myths and find mythbusters in towns across the United States who realize we're not saying that you kids just go run willy-nilly and do whatever they want, and that's not what the convention says, and it's certainly not what's suggested by what I hope will become a movement to end the practice here. Maybe some scare tactics. Children who are living with disabilities are twice as likely to be violently disciplined than their non-disabled peers. What's going on there? Is it that there are more horrible parents who have to say, no, there's something going on around parenting. So if we could get off, I think, the myopia of actually corporal punishment and everything that invokes for people, and talk about the fact that, and I'll say to conclude in true Pollyanna fashion, as I'm known to do, but I haven't met parents anywhere in the world, give or take a couple, who don't want to do the right thing by their kids. So, if given the opportunity and the skills and the access to information and peer support and whatever else, I think the game could be changed here, and then get the NFL back on children, not just violence in women, which is very important, but I think that somehow we lost kids in that whole conversation. So thank you very much.
So thank you very much, Dr. Bissell, for that thoughtful reflection on your wealth of knowledge, and it's really fascinating to hear about the new partnership, and look forward to ways of engaging together. We're going to take a short break now, and in 10 minutes we're going to regroup, and we'll have our second panel. We'll have Professor Malenik, who will be moderating that, and the lawyers and advocates who will be talking about ways.
Yes? Yeah. Hi, if we could start getting back to our seats, we'd like to stay on schedule so we could get you food and drink when we hope to do that.
Are you all going to stand or talk?
I'm going to. I do better when I stand.
I think I will too because I have slides. So.
Yeah.
That's okay.
All right, thank you. Thank you. We're going to get started. We're going to get started with our afternoon panel, which is going to talk a little bit about how international instruments are actually being used in one form or another in different aspects of the law. And I would thought, different aspects of policy, I thought I'd give a little bit of an overview. You've heard a little bit about the CRC from Dr. Bissell and from other people, but many of you, maybe the students, don't know much about it. As Dr. Bissell said, it was adopted by the UN in 1989 and came into force in 1990. And as she said, the U.S. is the only nation on earth that has not ratified this treaty. That is in some ways not surprising, and not as an excuse, but sort of as an explanation. Let me say this about the ratification process. Unlike many other nations, we don't have unitary law. We have a federalist system, so we have states and we have a federal government. Other nations are unified, so if the federal government decides to sign a treaty or ratify a treaty, it comes into force. In the U.S., it's a three-step process. The treaty is first signed, it's then sent to the Senate, and then the Senate has to vote, and that vote is even harder than getting past a filibuster because we need 67 votes rather than just 61 to ratify a treaty. As I said, it's not all that surprising that it hasn't been ratified. I've been told by people more knowledgeable than me that non-commercial treaties sometimes take 25 years. It's not surprising for a treaty like this to take 25 years to get ratified. Also, this is not a very good time for ratifying any kind of treaty because sounds like we're fighting the Civil War again in some states. Governor Perry wants to secede. Everybody's thinking states' rights supersedes federal rights. Most of the people screaming the Constitution at you have never read it, and yet they have a very, very firm idea about how it works. But because we have this federalist system and this more complicated system, treaties have a tough time. So, for example, the Treaty on Disability Rights, also a UN treaty, came before the Senate last year or the year before, I can't remember exactly. A treaty that was based on many aspects of U.S. law failed to be ratified in the United States. Surprising, since we were so instrumental in getting it produced. Similarly, with the CRC, most of the opposition comes from what we would call the right wing of this country. They probably don't know that the Reagan administration was very instrumental in actually getting this treaty written. So it's also surprising that we've, as Susan said, we've ratified the protocols, which is sort of strange, but haven't ratified the main treaty. And again, it's a question of federalism. There are some notions that the craziest notion is that if we sign the treaty, there'd be nannies in blue helmets walking into every parent's home to tell them how to live their life and raise their children. Of course, none of that makes any sense, and yet the animosity towards the treaty is really quite large from the right. It comes from religious people, it comes from, not all religious people, but from certain segments of religious denominations. It comes over corporal punishment, it comes over abortion, a total misreading of the treaty because the Vatican has ratified this treaty. So as we go forward this afternoon, we have to understand that it is probably not likely that this treaty is going to be ratified under the Obama administration. The campaign's goal is at least to get the president to send it to the Senate, and we'll move from there. There are 41 separate provisions in the treaty that gauge not only the rights of children, as we normally understand the concept of rights, but also certain entitlements which raise to the level of rights, rights that the United States has never really recognized before. Today, we're going to look at three areas for the most part. One is criminal and juvenile justice, juvenile delinquency cases. There are at least three really salient provisions, 12, 37, and 40, which create a certain amount of due process rights that apply to children in the United States, that actually most of which apply to children in the United States. It talks about notice, it talks about confrontation, it talks about compulsory process, and the kind of things that we're used to. It called for the abolition of the death penalty, which we now finally do. It called for the abolition of life without parole, which is a little bit complicated still. And it protects against torture, cruel and unusual punishment, and, as I said, life imprisonment and other kinds of deprivations like that. We're also going to talk a little bit about children's rights in immigration. Article 10 protects the rights of children and their parents to enter or leave a nation for the purposes of family reunification. Article 22 governs the rights of refugee children and states that they're entitled to protection and humanitarian assistance. All state parties are responsible for reuniting children with their families when they're separated. Whether we do those things or not, as we'll hear today, is another issue. The third area we're going to look at is trafficking in labor, which is something we don't think much about in terms of the United States, but I'm sure you'll learn later today that the notions of labor and violations of provisions in the Constitution with respect to the Convention with respect to labor still exist in the United States. Article 32 protects children's rights in labor, prohibiting performance of work likely to interfere with a child's education, health, or development. Interesting crossover between immigration and labor issues right there. Mandates a minimum age, which we have in most places in the United States, but is not uniformly applied. It prohibits the use of children, of course, in drug business, trafficking business, and other kinds of harmful behaviors, labor. And of course, prohibits to some extent the transfer and non-return of children when these things have been found. I won't talk about education. I think we got a great look at education this morning. Let me again just thank you all for what was an extraordinary job. As Andy and Patrick may tell you, I don't impress easily. That's sort of my reputation around here. I was really dazzled by what you did, so thank you very much. So we're going to move on to this presentation. Let me tell you how we'll do it. I'm not going to go through biographies. They're well written up in your book. We have Marcia Levick from the Juvenile Law Center, Amy Fettig from the ACLU, Maria Wolchin from the Youth Center for Immigrant Children, and Margaret Worth for Human Rights Watch. The way we'll proceed is that each speaker will take 20 minutes, about 20 minutes, and at the end, rather than doing questions after each speaker, at the end, we're going to try and engage in a conversation between the panel and you all in another 20 minutes or so of conversation. So with that, Marcia, thank you.
Good afternoon. Thank you all. Thank you to the Institute for inviting me to participate in this very interesting set of discussions that we're having today. I have to say that I was struck by Dr. Bissell's comment about being asked by someone recently about whether or not children have rights. So I've been doing what I do for over 40 years, and I thought that perhaps it was a failure of Juvenile Law Center, the ACLU, and other national, state, and local children's rights organizations that our message somehow hadn't filtered down. So I feel doubly charged to make sure that I keep at this work that is so important. My charge today is to talk about issues of punishment as they relate to children in the United States and the intersection with the CRC. And it's been an interesting relationship, I would say. When we first talked in preparation for the panel, and Wally raised the question, so, you know, what can you say about the role of international law in the sentencing of children? And I said, well, really, it's had no traction at all. And then I said, well, that's not quite true. It's actually more that it's lost traction, but it had some very significant traction in some of the progress that we've made in the last 10 years. I think everybody in this room, based upon certainly those of you whom I know, those of you who have introduced yourselves, you know that the United States incarcerates more individuals than anybody else in the world. We have 25% of the incarcerated population in the world and about 5% of the world's population generally. So we are way ahead of our neighbors around the world in how we feel about punishment. And I think it's not just that we incarcerate a lot of people and over-incarcerate a lot of people, but it's also that the function of our criminal justice system is largely affected through a lens of retribution and vengeance. And when you focus on retribution and vengeance, it becomes very difficult to see the individuals who are the subject of those policies. And I think nowhere is that truer than in how we have thought about the punishment of children who commit all kinds of crimes in this country. Because let me be clear, we're not only talking about children who commit violent crimes, but also children who commit nonviolent crimes. And the same conversation that we are listening to in the country right now about trying to reduce prison populations by thinking about nonviolent drug offenders, for example, is a conversation that we need to be having about how we punish children generally. Again, as I said, not only for nonviolent crimes, but violent crimes. So up until 2005, the death penalty was permitted to be applied to children under the Eighth Amendment to the U.S. Constitution. In 1989, the Supreme Court had struck the death penalty for children who were under the age of 16 as a violation of the Eighth Amendment, but they also upheld the death penalty for 16 and 17-year-olds. And the theory was largely one that looked at state legislation. So the standard under the Eighth Amendment that determines whether or not a practice is constitutional by considering the question about what are the evolving standards of decency that mark the progress of a maturing society, a phrase you've all heard in whatever state of your legal careers you all are in. It turned out that in 1989, we hadn't progressed so far that we could still tolerate the execution of 16 and 17-year-olds who were convicted of homicides. In 2005, that issue went back to the Supreme Court, and the case was brought by a 17-year-old, Chris Simmons, who had been convicted of a homicide in Missouri and sentenced to the death penalty. Interestingly, as a matter of legal shenanigans, the Missouri Supreme Court decided that Chris's sentence of death violated the Eighth Amendment, even though the U.S. Supreme Court had not decided that. And of course, that probably guaranteed that the Supreme Court would grant the petition for cert filed by the Missouri Attorney General to resolve that question for itself. There were a couple of interesting things that happened in Roper. The court, of course, struck the juvenile death penalty, finally, for all children under the age of 18. And there were a couple of very significant pieces of the court's decision that are worth noting in today's conversation. One, of course, is about the adolescent development research. And we now all can talk fluidly with great authority about the adolescent brain. We know every part of it, and especially the frontal lobe and how it's still developing, and we know exactly what the frontal lobe does, and that sometimes it's blue and sometimes it's green in pictures. But what the court really focused on in 2005 was developmental research that identified specific attributes of adolescents and youthful offenders that the court felt distinguished juveniles from adults in ways that mattered in terms of punishment. And those attributes, which were in shorthand, immaturity, surprisingly, immaturity of judgment, susceptibility to negative peer pressure, and of course the capacity for change and rehabilitation. While that drove the court's ruling, what Justice Kennedy, who wrote the decision in Roper, also talked quite eloquently about was the influence of international law and the influence of looking at what was happening around the world. And so in 2005, when the court was asked to address the constitutionality of the death penalty, it turns out that the United States was the only country in the world that gave official sanction to the juvenile death penalty. So we know what that means. We know children are executed elsewhere. But we were the only country that actually provided for it as a matter of our laws. And Justice Kennedy noted that really since Trump v. Dulles, which had set forth this evolving standards of decency test, that the court had looked to the laws of other countries around the world as being instructive of what our laws might look like in terms of interpreting the Eighth Amendment. And this is what Justice Kennedy said in Roper. He said, "It is proper that we acknowledge the overwhelming weight of international opinion against the juvenile death penalty. The opinion of the world community, while not controlling our outcome, does provide respected and significant confirmation for our own conclusions. International law underscores the centrality of those same rights within our own heritage of freedom." Now, this wasn't the first time that Justice Kennedy, of course, had addressed and recognized the influence of international law on thinking about American policies and practices. Of course, he had done this with respect to homosexuality and crimes against sodomy, which he had likewise found unconstitutional, and looked to the international community for perhaps both guidance and assurance. But it was, of course, quite unusual to see Justice Kennedy invoking international law in striking a sentencing practice under the Eighth Amendment, very specifically, and again, for children. 5 years after Roper came down, the Supreme Court was asked again to address the constitutionality under the Eighth Amendment of another extreme sentencing practice, and that was the sentence of life without parole imposed on juveniles who were not even convicted of homicide crimes. And in fact, the subject of that particular case, Terrence Graham, was 16 years old when he was convicted in the state of Florida for a home invasion burglary. There was some victim injury, but again, it was not a homicide. He was convicted of that crime. He was placed on probation. He was suspected of having participated in subsequent home invasion robberies while he was on probation. He was brought back before the court on a probation violation, not actually charged with any new crimes. And the sentencing judge literally threw the book at him, said he'd had his chance, he'd wasted that chance, and he could, in his view, he had clearly made a choice to pursue a life of crime, and sentenced him to life without parole for a non-homicide crime, which was permissible under Florida law. His case went up to the U.S. Supreme Court with a companion case of a 13-year-old, also out of the state of Florida. And again, in looking at whether or not the court should strike or uphold a sentence of life without parole for a juvenile in a non-homicide case, Justice Kennedy, who also wrote the Graham decision, again looked to international law. And what the court noted there was that there appeared to be a global consensus against JLWOP. Now, of course, you heard Wally talk about the two provisions of the CRC, one of which bars the juvenile death penalty, one of which bars life without parole for anyone under the age of 18. For any crimes, by the way, not just non-homicide crimes. So what Justice Kennedy noted was that there were only 11 countries around the world that authorized, that official sanction idea, that authorized a life without parole sentence for children under the age of 18, but only 2 that actually imposed it. One of those was the United States, the other was Israel. At the time that the Graham decision was decided, and actually at the time that it was argued, it was pointed out to the U.S. Supreme Court, again remembering that Graham was a life without parole case involving a non-homicide crime, that while Israel did have the sentence, that they were no longer imposing it on individuals convicted of non-homicide crimes, not addressing the homicide issue. So that left the U.S. once again alone in imposing this very extreme punishment. So why did Justice Kennedy again look to international law? This is what Justice Kennedy wrote. The judgment of the world's nations that a particular sentencing practice is inconsistent with basic principles of decency demonstrate that the court's rationale has respected reasoning to support it. I should point out that in both of these cases, there were dissents filed, including by Justice Scalia, that really objected to any consideration or reference to international law. I recall at one of the arguments, I don't know whether it was Roper or Graham, it might have been both, where Justice Scalia in particular got into an argument, I believe with Justice Breyer, about why in the world would we care what England thinks about a particular sentencing practice. And so that was the heyday for international law in the U.S. Supreme Court around sentencing of children. We've had one other decision, arguably 2 other decisions, since the Graham case. Of course, Miller in 2012, and most recently Montgomery, which ruled that Miller was retroactive, where we have not seen a reference to international law. In Miller, the U.S. Supreme Court struck mandatory life without parole sentences for juveniles convicted of homicide crimes. The court left in place, it appears, the possibility that juveniles could receive a discretionary life without parole sentence. There was a question following Miller about whether or not the Miller decision was in fact retroactive. There were many of us in the advocacy community who thought it was rather obvious that it was retroactive to the extent that it appeared to work a very substantial change in sentencing practices in states. No longer able to impose a mandatory life without parole sentence, they would suddenly have to imagine a whole range of sentencing options for these individuals. However, that proved confusing and confounding, apparently, for a number of state courts around the country. There was a significant split, although the majority of state Supreme Courts ruled that Miller was retroactive. And just this past January, the Supreme Court decided in Montgomery versus Louisiana that Miller was in fact retroactive. A couple of interesting things that I'll note about those cases, and then just point out some areas where I think there is potential for forward movement, and I would say ratification of the CRC could be really helpful on some of these issues. In Miller, the court was consistently, again, Miller was a decision written by Justice Kagan, not Justice Kennedy. And Justice Kagan really adopted everything that the majority had said in both the Roper decision and the Graham decision in terms of reiterating the developmental differences between children and adults, again, repeating almost as a religion at this point, those distinctive three attributes between adolescents and adult offenders: immaturity of judgment, susceptibility to negative influences, and peer pressure, and this capacity for change. The court in Miller really looked to its death penalty jurisprudence, which is interesting to the extent that, of course, while the death penalty is not practiced in most other countries around the world, we, of course, remain an adherent of it, but saw things in its death penalty jurisprudence that focused on the importance of mitigation, the importance of being able to consider the individual characteristics of each offender. The court talked about the importance of proportionality as being central to our Eighth Amendment, and that proportionality required not only a consideration of the crime, matching whatever the punishment was, but also including the characteristics of the offender, as well as the nature of the offense, and trying to fit all of that into an overarching proportionality principle that should drive the Eighth Amendment. This is unusual because the court, on the adult side, of course, has not been particularly warm to concerns about proportionality and have upheld 3 strike sentences, mandatory minimums, mandatory life without parole for adults under situations that were not necessarily homicide cases, and where I think all of us would recoil at the idea that these are sentencing practices that have been upheld by our Supreme Court. But nevertheless, there was a very strong feeling that has now reverberated through these 4 decisions that children are truly different, and children have rights of a sort. They have very profound rights with respect to thinking about how we sentence them. And I've had, when you work in our field, you know, we're a relatively small field of lawyers around the country who do various kinds of civil rights litigation. And certainly my colleagues who work on the criminal justice side and have worked on certain other aspects of civil rights litigation really in the last 20, 25 years since President Reagan began appointing all the federal judges. You know, it's been very hard to win, but kids have been winning in the last 10 years. Kids have been winning remarkably well in terms of really upending, and I would argue also creating an entirely new subset of Eighth Amendment jurisprudence with respect to the sentencing of children. So where do I think this might take us? So Amy's going to talk about solitary, and I'm not going to address that, although certainly that is an issue that is ripe for CRC consideration, and that I think fits well within the prescriptions and rights declarations that the CRC represents. I'll say 2 other things that I think we will continue to advocate around, and where the relevance of international law is present, though whether or not it will influence the outcomes remains to be seen. One, interestingly enough, is felony murder. So felony murder, which is a doctrine that we actually took from England, is a doctrine that has largely been abandoned across most of the rest of the world. It's been abandoned by England. It's been abandoned in Canada, through most of Europe. And yet we hold very dear to it. We punish very severely individuals who are convicted under a felony murder theory. So the person driving the car, the person who's present, the lookout, anyone involved in a felony that leads to, that ends in the murder of a victim, however minimal or limited their participation is. Many of those individuals, in fact, as many as 30 or 35% of them receive mandatory life without parole sentences prior to the Supreme Court ruling those sentences unconstitutional. We'll see how they end up being sentenced in their rehearings, which leads me to my second issue, which is also something like just mandatory minimums. Again, to return to my first theme, the United States is a very punitive country, and we punish out of revenge and retribution. And when you do that, for the most part, there is no sentence that is too long. There is no number of years that are too long to lock people up in prison. And so while we can rejoice in the idea that we have eliminated life without parole and the death penalty for juveniles, I know as I continue to work on implementation, particularly of the life without parole cases, that many end up considering it a victory when someone is sentenced to 35 years or 25 years or even 50 years simply because they have an opportunity for parole. If any of you watched 60 Minutes this past week, there was a very interesting piece about prisons in Germany, which don't look at all like our prisons, but also about sentencing practices. And most European countries don't sentence the way that the United States does, and certainly don't impose the kinds of sentences that we do, even in cases of homicide. So let me conclude with this. So international law hasn't been so helpful lately. It was odd because it had this moment where it really felt like it was driving where the Supreme Court was going, and I think that its value in presenting the isolation of the United States in terms of its sentencing practices to the 9 members of the Supreme Court was invaluable. What I would say, and sort of my glib response to all, it was actually, it doesn't have much meaning at all, is that it is very interesting how it has fallen off. That, you know, a year or two after Roper came down, a year or two after Graham came down, there was this rush and this urgency to insert international law arguments in all of the briefs that we filed, opposing sentencings or opposing other harsh practices involving kids. There was a view that we needed to get this information in front of state legislators as they might be considering changes to sentencing legislation involving children. And the bottom line is it had no consequence at all, and I don't even see it really appearing so much in much of the briefing in the work that I do anymore. I think that's unfortunate. Again, I applaud, and I think it's important to credit the value that it had in both Roper and in Graham. I think it absolutely influenced Kennedy. He seems to have been quashed a bit in his enthusiasm for it, and let's hope we can bring it back.
So between 1967 and when Roper was decided, there were about 7 or 8 cases in the Supreme Court involving juvenile delinquency in one form or another. And interestingly enough, it was only at the time of Roper and only around the issues of sentencing that the notion of international law came up. And what is telling to me about that is that in those other cases between 67 and 2005, the court was dealing with due process protections. It was those same due process protections that got incorporated into the international treaty in the first place, in the Convention on the Rights of the Child. So all of those things that Galt said in 1967 were actually a preamble to what was going to happen in the convention. The convention took those notions further and brought them into the sentencing field, which for the most part did not gain traction until we were sending a bunch of, well, we've been sending children into the adult system for a long time, but it had effect on the children in the adult system as opposed to the children in the delinquency system. In addition to the sentencing, though, the provisions of the treaty also affect conditions of the kinds of incarceration that children will experience, either in the juvenile court or in the adult court if they are transferred up. And Amy's going to talk a little bit about that.
I'm actually going to stand because I'm just one of those people who can't sit still. I think that's why my teenage clients get along with me so well, because we're all hyper. Good afternoon. It's great to be back at Georgetown. I'm an alum, and I'm always thrilled to see that Georgetown continues to really organize innovative, progressive, human rights-focused events, conferences, talks, and classes. It's great for the students, and certainly as a lawyer practicing in Washington, D.C., I benefit enormously from Georgetown students who have been energized in their law school classrooms to go out into the world and make a little change and do a little social justice. So thank you, Georgetown. So I'm going to talk a little bit about the practice of solitary confinement on youth in the United States. But before I do so, I want to tell you the story of Kalief Browder. Some of you may have heard Kalief's story in both the New York Times and the New Yorker. It has been eloquently written about. But if you haven't heard Kalief's story, I want to share his story with you today and honor the struggle that he engaged in. So Kalief Browder was a young man from the Bronx, and he was picked up by the New York City police because they believed that he matched the description of a young boy who had stolen a backpack. He was 16 at the time, and because New York State is one of the few states in the country, there are only two, that automatically prosecute all 16 and 17-year-olds as adults, Kalief was brought to Rikers Island Jail. You may have heard a little bit about that place. And Kalief had to sit there because, unfortunately, the judge set his bail at $3,500, which his mother could not pay. So Kalief had to stay in Rikers Island while he awaited trial on a charge of stealing a backpack. And he waited there for 3 years. He was often given the opportunity to plead guilty. That's what the system tries to push on people. But because Kalief said he was not guilty, he thought it was a miscarriage of justice for him to be forced to plead guilty simply to get out of the hell of Rikers. And hell it was. While Kalief was in Rikers for 3 years, he was beaten by other juvenile prisoners. He was beaten by the guards, and he spent 2 of those 3 years, actually a little bit more, in solitary confinement. And while he was in solitary confinement, Kalief tried to commit suicide, not 1 time, not 2 times, not 3 times, but 6 times. And every time he tried to commit suicide, he was either ignored by the officers or denied the mental health care that he needed. Kalief had come into Rikers Island without any history of mental health problems. He left Rikers Island with some severe disabilities as a result of his experience in extreme social isolation and solitary confinement for all that time. Now, Kalief actually left Rikers, as I mentioned, 3 years after the date of his incarceration. He was finally set free because the charges were dropped against him for the theft of the backpack. So he had spent 3 years of his wasted childhood without appropriate education, being brutalized, being beaten, and being driven crazy in solitary confinement. Now, a very talented journalist at the New Yorker, Jennifer Gonnerman, found Kalief, and she substantiated his story. He could actually give her the dates and times in which he was beaten by guards and beaten by children. And so she publicized his story through the New Yorker, which apparently every grass-tops person in this country reads. And so it got a lot of press. Kalief was soon known to the media. He was on Huffington Post Live, and his story helped change the policies and practices at Rikers Island so that now juveniles are not placed in solitary confinement, or at least that's what the policy says. They are kept in a separate unit and allegedly not subjected to the extreme social isolation that Kalief suffered. Kalief even made it into community college. In fact, during the last semester of Kalief's life, he wrote a very poignant, and I would have to say well-written, term paper about the practice of solitary confinement in this country and the need for change. Things seem to be going okay for Kalief, but this summer, his mother came home and found him dead in their home, hung by his own hand. And now, you can say that solitary confinement didn't kill Khalif while he was in it, but you can certainly point to it as a practice that damaged him so severely that he was never able to return to the community a whole person. And unfortunately, Khalif's story is not singular. There are hundreds of Khalifs who have committed suicide as a result of their experience of solitary confinement. We just know Khalif's story. There are those who killed themselves while they were incarcerated in solitary confinement, and there are the children who return to the community, like Khalif, who find that they can no longer function and later kill themselves. So I want you to remember Khalif's story, but importantly, he is one of thousands. This is a practice that is pervasive, regardless of whether or not you're held as an adult. If you're a child in the adult system, there's a great chance that you're going to be held in solitary confinement, either because the system can't protect you from sexual or physical abuse. Khalif was held in solitary for that reason, or because you break prison rules, because it turns out that teenagers actually don't do very well in adult systems, especially with officers who aren't trained to deal with kids. In short, they're a pain in the neck to manage. So they break rules, they get into trouble, they talk back, or like some of my clients, they get placed in solitary confinement because of horseplay. Sounds like they're just being a kid to me, but unfortunately, when they're in the criminal justice system and in the juvenile justice system, that kind of behavior gets you put in solitary confinement. And we're not talking about small numbers here. There are about 70,000 kids in any given day in the juvenile justice system. In most states and jurisdictions across this country, solitary confinement is used to either protect those children or implement some kind of discipline. And then for the 1,200 kids who are in state prisons and the tens of thousands more who circulate through our adult prisons and jails especially, kids are subject to solitary confinement there as well. So this is a pervasive problem. Probably if there's a juvenile justice or county facility or county jail in your backyard, there's a kid who's been placed in solitary confinement there. And this is pretty astonishing because we know that solitary confinement really hurts adults. We now have decades of research, most of it as a result of civil rights litigation, that demonstrates that adults, some of them perfectly healthy when they went into solitary confinement, soon exhibit symptoms of mental illness, whether or not it's hallucinations, severe depression, uncontrolled rage, an inability to sleep, the inability to track. Many of my clients, when I talk to them and they've been in solitary for a while, they have no ability to track events or time. They lose their thought processes. They become confused very easily. Very common. You can imagine that if this practice, solitary confinement, actually hurts adults in this way, what does it do to children? Children whose brains are not forming, 13-year-olds, 14-year-olds, 15, 16, 17, 18, and older. What happens to them if in the seminal time of human development, they are deprived of normal social relations? They're deprived of actual normal physical activity. Well, what the experts tell us is nothing good. And that's why, for example, the American Academy of Child and Adolescent Psychiatrists has a standard and a policy directive saying children will not be subject to solitary confinement because they're worried about that psychological damage. As I mentioned, we also have pretty strong proof that kids subject to social isolation commit suicide. 50% of all suicides within the juvenile justice system occur in isolation units. 60% of them are kids who have been subject to solitary confinement. And we actually know from Rikers Island, which has the largest database of medical records actually in the country that have been looked at and reviewed for signs of mental distress and suicidal ideation, self-harm, the children who are placed in solitary confinement are 700 times more likely to commit suicide than the children who are in general population. And we also know that kids in solitary confinement tend to have mental disabilities. Many of them are IDEA eligible. Many of them do have pre-existing trauma and psychiatric problems before they even come into the juvenile justice system, and then they end up in solitary confinement. We know from studies of adults that if you place an adult with a mental disability, a serious mental illness in solitary confinement, they will degrade. They will suffer. And because that is so well known and so well established, nearly every federal court that has been confronted with this issue, the placement of adults with serious mental illness in solitary confinement, has found that practice violates the Eighth Amendment's prohibition on cruel and unusual punishment, and yet we do this to kids all the time. So, in addition to all these debilitating developmental issues with solitary confinement, We also have the simple fact that if you put kids in solitary confinement, you're not giving them education, you're not giving them rehabilitation. They're sitting alone in a cell 22, 23, 24 hours a day, not engaging in any of the things, especially in the juvenile justice system, which is in most states mandated to engage in rehabilitation. None of that's going to happen. So this is a dreadful, dreadful practice. It's pervasive in the United States, but change is coming. And before I talk about the particular situation in the United States, I do want to outline a little bit of the international protections, because it may not surprise you that this is a practice that has been widely found to violate human rights in the international community. When I talk to my counterparts around the world, they are always shocked to learn that we actually play, well, number one, they're shocked to learn how many people we put in solitary confinement, how long we put them there, but also that we actually put children in these conditions. Because frankly, like under the CRC, Article 37, protection from torture and other forms of cruel and inhuman or degrading punishment, well, that has been, the Committee on the Rights of the Child has long found that solitary confinement actually qualifies for that. Not surprisingly, it is torture. But even when we look at standards that are specific to juvenile justice, like the Riyadh guidelines, which are the UN guidelines for the prevention of juvenile delinquency, and the Beijing rules, which are the UN rules for the protection of juveniles deprived of their liberty. A mouthful, but they all prohibit the use of solitary confinement as a form of torture and cruel and inhuman degrading treatment. Indeed, the Special Rapporteur on Violence under the Convention Against Torture has spoken out many times against the practice of solitary confinement for people with mental disabilities, for children, and for anyone over 15 days. But I got to tell you, there are a lot of children like Kalief Browder who spent more than 15 days, indeed 2 years, in solitary confinement in this country. It's not unusual. So we have all of these rules. We even have the Istanbul Statement against the use of solitary confinement, which said don't do it against kids. Don't do it against kids. And most recently, I think it was in October of 2015, the new UN rules on this, the UN Standard Minimum Rules on Prisoners, which thankfully have been abbreviated to be called the Mandela Rules, have incorporated all these protections for children against solitary confinement, and have also incorporated the Special Rapporteur's other recommendations against solitary confinement in that ban it on kids, ban it on pregnant women, ban it on people with mental disabilities, and don't do it for anybody over 15 days. So those are pretty strong protections. And I have to also say that the United States approved the Mandela Rules. It was unanimously approved by the member states, which is pretty unusual. So we had the United States government saying, yeah, sure, we agree to this. And yet, if we looked in our own backyard, of course, solitary confinement widely practiced on children. So unfortunately, all of that is persuasive authority in the United States. We don't yet have great constitutional law on the use of solitary confinement on children. And there are a number of reasons why that is so. For one thing, the law in general around solitary confinement, other than the cases I mentioned for mentally disabled, seriously mentally ill adults, it's thin. We simply don't have a lot of cases. So there's not a lot to build upon. And part of this is because we've been pretty successful. A lot of these cases are settling. And in fact, in the most recent litigation around children, in the state of Ohio, the Department of Justice came into a civil rights suit and settled statewide to ban the practice of solitary confinement in Ohio. So they have actually done a good job. That case just closed. It's encouraging, but it also means that we don't have any new law to build upon. But I don't think that means we shouldn't keep trying. As Marcia mentioned, we've got the Roper-Graham-Miller line of cases from the Supreme Court. And I want to just mention that also because 12 days after Kalief Browder committed suicide, Justice Kennedy wrote a concurring opinion in a case called Davis v. Ayala. It's actually a death penalty case. But the individual involved, the prisoner, had spent 20 years in solitary confinement. So Justice Kennedy took that opportunity to write a concurring opinion addressing the issue of solitary confinement. And in that concurring opinion, he talked at length, and I will have to say quite eloquently, about Kalief's struggle and his recent death. That framed his entire concurring opinion. which went through the history of solitary confinement in this country, the questioning of the use of it in terms of human dignity. And indeed, he closed that concurring opinion positing that perhaps the court might need a case and might be called upon to decide a case. So that's something that, of course, excites every single civil and human rights lawyer. You don't often have a justice of the Supreme Court, let alone Justice Kennedy, asking whether or not just maybe there should be a case to address this issue, and also asking whether or not perhaps alternatives might exist that the court might have to decide upon as well. So very, very exciting. We've got this opening in the Supreme Court, but there is also opening around the country. In January, President Obama actually announced a ban on the use of solitary confinement for federal prisoners, for kids, so exempting out that important group of folks. It actually impacts a small number of kids because there aren't that many children in the federal system, but it is important as a national marker of the practice in this country, the standards by which all juvenile justice and criminal justice systems should be judged, and by that standard, of course, they fail pretty miserably. However, in addition to President Obama speaking out and actually ordering the Bureau of Prisons to stop putting kids in solitary confinement, what has also happened is that we are seeing a lot of action on the state level through legislation, policy reform, advocacy, grassroots activism to really push against the use of solitary confinement against kids. And frankly, in the juvenile justice system, we're seeing some movement, some states that no longer rely on the practice, and some states that are moving away from the practice. So there is a great deal of momentum. And this is where I'd just like to briefly address the issue of using human rights standards. Because one of the things we've seen, I've worked on our Stop Solitary campaign at the ACLU for almost 6 years now. And one of the things that has shocked me in the advocacy that we do, even at the local level, is that we have heard over and over again, well, isn't the United States kind of an outlier about solitary confinement? We use it more than other countries, right? And isn't the international standard that we shouldn't do it more than 15 days and that kids shouldn't be subjected to it? I've been amazed at how often these issues around human rights standards and the fact that the United States is such an outlier have come up in the public dialogue, in discussions in front of state legislatures even. So I think it is important and incumbent upon the advocacy community, on lawyers, to continue to really harp at this issue. Bring it up. Don't be afraid. It is part of those contemporary standards of decency that we will eventually push in front of the court. Thank you, and I look forward to your questions.
Thanks, Amy. So let me say a couple of things. Amy mentioned the Beijing rules. There's also the Havana rules, the Istanbul rules. And she said we agree to these things. Actually, what we've done is agreed with these things because they have not risen to the level of treaties. And so while we may agree with these declarations by the UN, we haven't signed a treaty to subscribe to those rules. So many of you are probably sitting there thinking, God, if we could just get the CRC passed, ratified in the Senate, all these things would end. But let me just say one bit of caution here. The United States, because of its federalism system of government, often adds what we call RUDs, RUDs, to different treaties. And these are reservations, understandings, and declarations. And we often do that with respect to our federalism issues. Keep in mind that crime generally, but especially juvenile delinquency crime, is a state matter under our federalist system. There are very, very few people that are processed through the federal system for delinquency events. In many states, the federal government relinquishes jurisdiction to the state because they believe it to be a state activity. Consequently, merely getting the treaty ratified may not actually compel changes in the state rules on these issues. I'm not saying it won't, I'm not saying it will. I'm just saying it'd be another hurdle to implementation of this treaty if it were actually ratified. We are going to move now, what might seem to you as a large leap from crime to immigration, but remember that it's not in the juvenile community because there are so many kids who come in as undocumented undocumented children. As we heard this morning, many of them are not going to school, and so they're just hanging out. And when you're hanging out, lots of things happen. Maybe you're committing crimes yourself, but maybe you're just standing there watching crimes being committed, not realizing that you are an aider and abettor to a crime and just as likely to be charged. So while we're going to talk about some different kinds of immigration issues as well, there is an overall linkage between these two, we shouldn't forget about them.
Okay,
Thank
thank
you.
you very much. Hi, everybody. I might need some help with fixing this PowerPoint here, being very incompetent when it comes to these things. So my name is Maria Walgen. I run a program at the University of Chicago with law students and social workers, and we serve as child advocate for unaccompanied immigrant kids. So we have actually had the freedom, I would say, to incorporate the Convention on the Rights of the Child, largely because there's no existing law on best interests, no statutes, no regulations, no century of case law that we have to worry about. And there is a history around the world of looking to international principles when it comes to immigrants and refugees. So given that we haven't had the law, what we've done is proceed as if there is a law and put it into practice, and the hope being that there would then be policy and eventually there would be law. So our job is to advocate for the best interests of unaccompanied kids who are in custody. But here's the thing, there is no best interest standard in our immigration law. So the statute says that our job is to advocate for the child's best interest, but doesn't say what that is or how it's supposed to factor in to cases involving immigrant children. I began this project in 2003 with a very tiny bit of seed funding from the federal government. Baker McKenzie gave us office space for the first 2.5 years, and our task was to develop what was then called a Guardian program, because under international guidelines, child advocate was called a guardian. And I'd actually worked in juvenile court on a variety of issues before starting to do this work. I worked on transfer issues, arguing that kids should not be transferred to adult court. And here I found myself in the immigration world where kids were actually tried in the same courts as adults with the same rules, the same principles applied to these kids. I realized very quickly that there was no standard. There wasn't even language that said, you judge or decision maker before you send a child back to home country have to consider the child's best interests, or at its bare minimum, safety and whether there's an adult available to care for that child if they return. So at the time, the world was very different. There were 4,000 kids a year coming into custody. This was 2003. And as we all know, the universe has changed. And as we heard this morning, in 2014, it was 68,000 children who came in. Last year, around 40,000, and I'm not sure, Michelle might know the projections for this year, but still very, very high number of children. So we started just with some guidelines from the United Nations High Commissioner for Refugees and a 3-page memo written by Wendy Young. This is many, many years ago, and not a lot more guidance. So we looked at existing authorities, and of course, the first authority we looked at was the Convention on the Rights of the Child. There was a program in Europe that provided guardians for kids, separated children in Europe. We got their permission to adapt all of their materials. We looked at the Fordham Symposium on Children in the Law, and I recommend for anybody in this room who's going to work on children's issues to look at that. I pull that out all the time. And lastly, we looked at the law of all 50 states. So in every single state, there is a best interest law which says you judge when making a decision about the protection of children have to look at the child's best interests. So we didn't have a law, and we didn't have any official authority back then in 2003, 4, 5, 6, and 7. But we acted like we did have authority, and everyone around us went along with it. The immigration judge, the lawyers, the shelters, Office of Refugee Resettlement, and we went about advocating for individual kids. So back then, as I said, 2003, there was one shelter in Chicago for 70 kids. Today, there are beds for 500 kids in Chicago, 1,600 beds in Harlingen. But Chicago had kids from all over the world, not only the kids who were Spanish speaking. So China, India, Ghana, Somalia, Eritrea, Romania, Poland, and of course, kids from El Salvador, Guatemala, Honduras, and Mexico. So it was very clear that with the $60,000 we got from the government to start the program, that we couldn't hire very many staff. So, and given that the kids spoke so many languages, we realized we needed to develop a volunteer program. So we went very slowly, feeling our way along. We modeled it similarly to court-appointed special advocate program. And the first training, we had 6 people. It was 3 law students who spoke Spanish, a teacher who spoke French and Moroccan, and an attorney who spoke Mandarin. So we advocated with ORR on a variety of issues. We had the volunteers go into the facilities and just simply spend time with the kids. They were not allowed to go in with an intake form or even a notebook. They were supposed to go in and spend time with the kids and learn their stories over time, because these kids are questioned over and over and over and over. We advocated with all of the different stakeholders in the system. So Office of Refugee Resettlement is charged with care and custody. So we would advocate for release of the kids in some cases, either to family or institutional sponsors. Back then, kids were routinely in custody 6 months, 9 months, longer than a year. And these facilities, the people who work there are wonderful. They really care deeply about the kids, but they are detention facilities. The kids can't leave. They can't walk out the front door. They can't even, in most places, go from one room to another room in the facility without being accompanied by an adult. We advocated with ICE to release kids from custody before when they turned 18, instead of sending them to adult immigration detention. Sometimes we advocated with the lawyers to take a case. So back then, and still today, there was only government funding for doing screenings and kind of know your rights presentations for the kids, and these legal services organizations had to either place cases with pro bonos or find private money to take the cases themselves. So very hard for them to take cases, and we thought they were screening out a lot of the cases that really had some merit, and also believed that every single child should be represented zealously, but that's another issue. We advocated for safety for these kids after they got released, and we advocated for kids regarding their safety if they were to be deported. So since there wasn't a federal best interest statute, we looked to the Convention on the Rights of the Child, obviously the principle that says that in all decisions that are made, all actions, the best interest of the child shall be a primary consideration. So we have thought very carefully about best interest. We're very careful, and to your point, it can be very problematic. There are some folks who want to be very paternalistic and decide, I know what's best for you, child. So we're pretty careful, and we feel that best interest should be child rights driven, that what the child wants should be right up at the top. Okay, so, and we really do believe that the kids have a right to express their own opinion, and that opinion should be given the highest value, and only if that child's safety is at issue are we going to try to trump what that child is asking for. So we started taking cases, and I'm just going to describe one case to you that kind of illustrates the different pieces that we pull from the CRC to do our advocacy. This is a girl, I'll call her Stephanie. She was 10 years old. She was in custody on the border in Harlingen, Texas. She'd been detained for 11 months, a very long time for any child, but especially for a child that young. Her mom was actually in the United States, but the government wouldn't release her because the mom lived with a man who had been convicted of human smuggling. But he had what was called, this is a little complicated, an S visa, snitch visa, which meant he'd been cooperating with the government, and our government said, okay, we'll give you a work permit and you can stay. But nevertheless, the government wouldn't release her to her mom. Another family friend came forward, nope, government said we're not releasing her. She was adamant about not going to any foster home, so she either wanted to be released to her mom or go back to Honduras and live with her grandmother. But the shelter staff were very concerned that there were problems with the grandmother's home back in Honduras. So given that we didn't know very much, we hired a social worker in Honduras to go and visit her home. And he visited the grandmother, he interviewed neighbors, gathered information, and he was from this community. We didn't fly in somebody to go and investigate, he was from the community. What he found was that the grandmother was selling liquor out the front of her house, that prostitutes were in and out of the home. The grandmother told the social worker that Stephanie had witnessed her being raped by a police officer, and also said in the same conversation that she was dating another police officer. Neighbors said it was a house of prostitution. So the social worker found and recommended that it was not safe for her to go back, that she would be at risk for sexual exploitation. So obviously with that information, we argued to the decision makers that it was not in her best interest to go home, and it was based on facts. We didn't just go in, we cannot just go in and say, Your Honor, it's not safe in Honduras, she shouldn't go back. We have to have fact-based information about the child. So we cited, obviously, to the Convention on the Rights of the Child, Article 3. We argued that Stephanie's wishes should be considered pursuant to Article 12. This is just a piece from the letter that was written on her behalf. Then we advocated with the government to go and do another what's called home study on the mom. And that came back, finally it came back positive with the recommendation that it was safe for her to go live with her mother and her stepfather. So Stephanie changed her mind about wanting to go back and decided she wanted to stay and fight her case, and the attorneys used that report and that best interest recommendation in their request for asylum. So we used a variety, obviously Article 9 says children should not be separated from their families. We use that because family unity is a central principle and widely recognized. And we argued that she wouldn't be safe if she was repatriated, again, citing to the Convention on the Rights of the Child. So this is just a diagram of how we look at best interest. Again, just trying to be really, really careful about how we look at this. And every single one of those factors is pegged to an article in the Convention on the Rights of the Child. And as I said earlier, child's wishes are right up at the top. And it's really only if there's a safety issue that we can demonstrate factually that will go against what these kids want. So fast forward 12 years later, we still have a program, we're still alive, and we have offices in Chicago, on the border in Harlingen, Houston, New York, Washington, D.C., and this year we're opening in Los Angeles, San Antonio, and Phoenix. We don't serve every single child, even though all of these international principles say that every single child should have a guardian. There are only resources to serve the most vulnerable kids. So a tender age child for whom there's a cross-border custody dispute, a child with capacity issues, cognitive or mental illness, a child who's traumatized and can't provide any detail, so even the lawyer says, well, he can't even tell me what the case is about, so he must not have a case. He can't give me any facts. He says his family was killed, but he can't tell me when or where or how. We'll advocate for those kids. And then kids who, and we do see this, and this relates to the lengthy detention of kids, we see kids who have been detained for so long that they ask for voluntary departure. And we still today see kids who've been detained a year, 14 months, and sometimes actually in jails, not just the typical government shelters. So there has been progress, I will say. In 2008, the government passed the anti-trafficking law, I'll call it, and provided for appointment of independent child advocates. So finally, we had official capacity. We didn't have to pretend that we had that official capacity anymore. And it states, again, that our job is to advocate for the best interests of the child. But again, still, we have no best interest standard. So I'm going to just briefly transition into my last point, which is we've put these things in practice, gone to judges and argued for best interests, argued to other stakeholders, and part of it has obviously been to advocate on behalf of that individual child, but another part has been to educate the court and really get the court to want to know this information and to ask for recommendations, and at its bare minimum to ask for information about what is this child going back to if I sign my name on this deportation order. So this last year, or actually for the last 2.5 years, we engaged in a process through, it's called the Interagency Working Group on Unaccompanied Children, and that's comprised of all of the federal agencies involved with unaccompanied kids, and then NGOs. So Department of Homeland Security, including Border Patrol, ICE, which is enforcement, and Office of Chief Counsel, Department of Justice, the acronym EOIR, they oversee the immigration judges, Department of State, and then, of course, Health and Human Services. And then most of the NGOs involved with kids, the Women's Refugee Commission, Kids in Need of Defense, UNHCR, which is not an NGO, but they were involved, USCRI, ISS was involved. There were 3 in-person meetings moderated by Professor Schoenholtz, who presided over all of these meetings, and sometimes these meetings can devolve into a lot of argument when you have government folks and NGOs around the table, but that didn't happen with Professor Schoenholtz in the room. These were all-day meetings, and people paid incredible attention. I didn't see people pulling out their cell phones. And I don't think it was because it was such a scintillating conversation. I think that the people around that table really had the will to see this happen. So the idea of this project was to develop a framework for considering best interests in the absence of a law. So everybody acknowledging we don't have a law, we don't have regs, but we're all going to sit down together and figure out how to develop a framework. It really had 3 parts. The first part is just the underpinnings of the framework. You can't see it, but, and then the second was decision-making along the continuum from the point the child is apprehended all the way, placement, release, decision by immigration court, asylum officer, and safe repatriation. And then at the end is a very practical checklist for government agencies, and they asked for this. They had lots of conversations with us in between these meetings. My amazing colleague Jennifer Nagda was in charge of this project. She spent hours and hours on the phone with all of these agency people, and what made it work was that we had these conversations off the record and not for attribution. So we were able to talk to these folks and get their best ideas about how we could incorporate best interests into their decision-making without pointing any fingers or naming any names. And so at the end of the document is a checklist in the form of questions. If it's a judge, does this child have an attorney? If this child seems to have some cognitive issues, have they been appointed a child advocate? And again, it goes through every single point along the continuum. So obviously, the hardest part now is implementation. We have a third grant from the MacArthur Foundation to work on implementation. We're just going to focus on a couple of very small pieces of that and try to get the government now, which has expressed its enthusiasm for the document in public. No signatures, but enthusiasm. And we're now going to work with these government agencies on actually implementing these procedures. So again, for me, what this has been about is taking a practice and then moving it into policy. I'm very excited that we have a policy. And of course, now it's the hard part. And my dream, of course, and I hope that it happens in my lifetime career, would be an actual law that requires immigration authorities to consider best interests. So thank you.
Thanks, Maria. Maria's presentation actually brings out one thing that we seldom think about, and that is courts, especially Article III courts and state courts, are bound by precedent, and they tend to be rigid organizations. They don't make things up new. They like to move from the past and take incremental steps. But when you're not dealing with these kinds of courts, you can be incredibly creative. Right. You can take these international instruments and not set them out as reasons to change things, but show how they are consistent with other things in U.S. law. The other thing that I thought was really wonderful, and this is a great place to be doing it, is to look at vacuums. And like you did with best interests and guardians, and always remember the Jesuit maxim. better to ask for forgiveness than permission. Do it until somebody tells you you cannot. And then alter your process a little bit and move it forward. Always move it forward. Thank you. Thank you. Now, let me say, labor is not that far from this topic either, because many of these kids who somehow avoid INS and avoid the juvenile court are here, either legally or illegally, working in some capacity. Sometimes they lie about their age. Sometimes they don't lie about their age and the employers don't matter. So all of these topics weave together today into the international instruments and into the way the U.S. courts and agencies treat it.
Thank you so much. My name is Margaret Worth. I am a children's rights researcher with Human Rights Watch. And I hope most of you are familiar with our organization. We're an international, non-governmental organization. We're independent, and we do work in 90 countries around the world. We have a dedicated children's rights team we have for more than 25 years. And one of the core issues that our children's rights team has worked on for the entire time we've been in existence is child labor, and in particular on eliminating the worst forms of child labor. International standards are pretty clear when it comes to child labor. You know, not all work by children is bad or harmful. It's actually good for kids to have opportunities to work, to develop skills, but only at appropriate ages and when they're in safe conditions that don't interfere with their education. The CRC protects kids from economic exploitation, from hazardous work, from work that interferes with education. And there are two core ILO conventions, the Worst Forms of Child Labor Convention and the Minimum Age Convention that have clear restrictions on what type of work children should perform. So today I'm hoping to walk you all through a case study of Human Rights Watch's work on one child labor issue here in the United States, and that's hazardous work in tobacco farming. So what's the human rights problem here? The U.S. actually has pretty good child labor laws when it comes to every sector except agriculture. And in agriculture, there's a double standard, so kids can work from younger ages for longer hours and in more hazardous conditions than they could in any other job. So in the U.S., for most jobs, you have to be 16. 14 and 15-year-olds can work a few hours a day in certain sectors as long as they still go to school. In agriculture, the minimum age for children to work is 12. And at the age of 12, you can work unlimited hours on a big commercial farm of any size as long as you have your parents' permission and don't miss school. And at age 16, child farm workers can do hazardous work, where kids would have to be 18 to do hazardous work in any other sector. My colleagues at Human Rights Watch and many other champions of children's rights, an incredible coalition of groups, worked for more than 15 years to try to change this double standard in U.S. law and to try to update federal regulations to give kids better protections. And, you know, to make a long and ugly story short, those efforts failed. So my colleagues and I decided to focus in on one particularly hazardous crop, which is tobacco, and to try to push for incremental change by keeping kids out of tobacco fields. I had hoped to start by showing you a video because I think it's so powerful to hear the voices of the kids themselves, but we're having technical difficulties. So instead, I'm going to just tell you a story of a child I met when I did research for this work. So it was 3 years ago. It was 2013. It was one of my first times doing field work, interviewing child farm workers. It was a hot day in July, and I, through a local partner, was able to get out to a tobacco farm. It was pretty early in the morning, and the field was dripping wet. And I walked up behind a boy who was working in the fields. He told me his name was Miguel, and he was 12. It was his first summer working in the fields. And around the time I talked to him, it was probably, 7:30 in the morning. He was going to be out there until 7 o'clock that night at least. So, working 10, 12 hours a day. And he was wearing shorts and a t-shirt, and it was very muddy in the field, so he was just walking around in his socks. And then his protective equipment was a black plastic garbage bag that he'd pulled on, he'd poked a hole in the top for his head, pushed his arms through the sides, and pulled it on over his clothes. And that was his attempt to protect himself from the toxins that are in the tobacco leaves, which is nicotine and the pesticides applied to the crop. And, I asked him why he was doing the work, and he said, he wanted to help his family pay the bills and make ends meet. And I asked him how he felt when he worked in the fields, and I'll never forget what he said. He said he got headaches, and he said it felt like there was something in my head trying to eat it. And I knew that these headaches that he suffered are one symptom consistent with acute nicotine poisoning. So you're out in a tobacco field, you're surrounded by plants, you can actually absorb that nicotine through your skin and it makes you sick. It gives you headaches, makes you feel dizzy, and it causes you to vomit and feel nauseous. That boy continued working. I, went back to my air-conditioned hotel room and, flew back to my office in New York. He was just one of 141 children that my colleagues and I interviewed for our first report on this issue. The vast majority of them experienced these similar symptoms consistent with acute nicotine poisoning: nausea, vomiting, headaches, and dizziness. About half of them said they saw tractors come through fields where they worked spraying pesticides, and they could smell it and feel the spray, and many of them said it made them feel immediately ill. They were mostly working 50 or 60 hours a week. They were hired workers, so these are not kids out there, helping out the family, taking a nice long lunch. These are kids who are hired laborers. And just to be clear, this is perfectly legal under U.S. law. So, under our U.S. labor law, the way it's written, to work in tobacco farming is treated the same way as any other agricultural work. And so a 12-year-old working 60 hours a week, getting poisoned by nicotine and pesticides is legal. So what did we want to do to try to change this? Our goals were threefold. We wanted to get the world's largest tobacco companies to eliminate child labor in their global supply chains. We wanted to push Congress to change U.S. child labor law to address this double standard for child farm workers, or at the very least, to ban kids under 18 from working in direct contact with tobacco. And then our third goal was to get the Obama administration to update child labor regulations. So at Human Rights Watch, we often describe our work as investigate, expose, change. So we do fact-finding, human rights fact-finding, research in the field, legal and policy analysis, a review of secondary sources, and we publish all of these in massive reports, which I brought some copies of in case any of you want to take some home. And so we do our investigations. Then we expose our findings in these reports and also through media coverage. And our goal really is to change laws and policies to better protect kids. But in this case, it was not just policymakers in Washington. It was the tobacco industry and really pushing them to address this issue. Our strategies, we had a number of them. So we went to the companies early, more than 6 months before we published our findings. We wrote detailed letters to 10 of the world's top tobacco companies. These were companies that we knew were buying tobacco grown in the U.S., and we shared our findings with them and asked them questions about their policies on child labor. And at that point, they were all across the map. So some companies had, better protections for kids, banned hazardous work. Other companies said, we tell our growers to follow the law, which meant 12-year-olds could be working legally out in their fields. So we engaged with them early. We tried to get a sense of their policies. We also engaged through multi-stakeholder initiatives. So the companies formed industry groups. There's one based out of Geneva. There's one based in North Carolina. Through these groups, they try to set industry-wide standards and take on initiatives to address child labor and other labor rights abuses. So we tried to engage with these initiatives. We pushed for really damning media exposure, and we were fortunate. We got some good coverage in major outlets in the US and internationally. We got strong print coverage, including editorials in both the New York Times and the Washington Post. And it was interesting because the New York Times came out very strongly saying that the companies should eliminate hazardous child labor in their supply chains, and the Washington Post put a lot of pressure on the Obama administration to tackle this issue, so they were very complimentary. We also had a little bit of welcome comic relief. The Daily Show with Jon Stewart covered this issue and did a brilliant segment that they called Nicotines, where they found a tobacco farmer in Kentucky who defended the practice of children harvesting tobacco and contrasted that with the voices of some of the child farm workers that we'd interviewed in North Carolina. And it was very smart and I think got a tremendous amount of coverage. We also worked on getting pressure not only from elected officials to try to change U.S. law and regulations, but also to get elected officials to put pressure on the companies. So in June, after World Day Against Child Labor, we saw 18 U.S. senators write to the CEOs of the world's largest tobacco companies, urging them to update their child labor standards. We saw a number of members of the House of Representatives write to the U.S. Secretary of Labor urging for regulatory action. So it was interesting to see how elected officials picked up on this issue. There was also a bill introduced in Congress that would ban children under 18 from handling tobacco. It was sponsored by Senator Dick Durbin and Representative David Cicilline, and it has a number of co-sponsors in the House. And I think the media attention generated interest from elected officials, which drove these measures. So there was some interesting interplay between these various factors. We also tried to harness public pressure, and Avaaz organized a petition that had more than 40,000 signatures calling on the U.S. Secretary of Labor to update regulations. And we've seen some impact. So as I mentioned, when we first went to the biggest tobacco companies in the world, they were all across the map. Some of them didn't have child labor policies at all. Since we published our report, the two largest growers associations, groups of tobacco farmers came out and said, we don't think children under 16 should be hired to work in tobacco farming. Now, that's only 16, not 18, which is, of course, what we're pushing for. And it's only hired workers, not children working on their family farms. But when you look at the protection for children in U.S. law, that kids 12 and up can work, and you bump that up to 16, that's a significant difference. And shortly after the farmers came out, the two largest tobacco companies in the U.S., Reynolds American and Altria Group, adopted similar policies. We've also seen the members of the Eliminating Child Labor and Tobacco Growing Foundation, which is based out of Geneva, make a pledge of commitment to eliminate child labor in their supply chains. And this is where we see the international standards come to bear, because these companies have global operations. So the same companies buying from the US are buying from Brazil, China, India, all the world's largest tobacco producers. And the policies they commit to on paper have to be in effect worldwide. And so they look to the International Labor Organization for these international standards. So even when U.S. law is weak and inconsistent with international law, these companies' voluntary policies are citing international law, which is a positive thing. I have to end on a solemn note, because despite this progress, there's a lot more work that needs to be done. I wanted to end with a few images of children I met last summer when I was working doing follow-up research in North Carolina. And these are all kids who are 16 and 17. And they're still children, right? They're still under 18. But under the new policies that have been adopted, they wouldn't be protected. And, my other panelists have already commented on everything we know about the developmental stage of these teenage kids. And they're, left out of a lot of these new tobacco company policies. And then the other glaring gap is really change in Washington. So, voluntary initiatives by the industry, it's a good thing. But it needs to be backed up by strong and enforceable laws and regulations, and we just haven't seen the political will in Washington to tackle this issue. There were regulations introduced in 2011 by the U.S. Department of Labor under the Obama administration that would have banned children under 16 from working in tobacco farming. And there was tremendous pushback from agricultural lobbying groups, largely due to misconceptions about how these rules would affect family farms. But in 2012, April of 2012, those regulations were withdrawn, along with a promise from the administration not to pursue this issue for the duration of the Obama administration. So they essentially said regulations on child farm workers are a closed door. We continue to push them because, we have new evidence of the dangers of this work. We have new commitment from the industry. If the industry itself is, taking voluntary steps and adopting higher standards, the U.S. government should follow suit. But the battle continues. So I will stop there. Thanks so much.
Thank you. Of course, the whole notion of labor and agricultural industry is a complicated one, because as these children get moved out of the workforce, then their parents are losing a source of income as well. So while we definitely need to move in this direction, we also need to deal with the fact that farm laborers generally are unprotected, underpaid, just so we can have our vegetables at a pretty low price. Thank you.
Yeah.
So we started this afternoon with, what did you say, Susan? 1 billion children being subjected to violence every day. And that just was the ones that had active violence. The passive violence that we see in the criminal and juvenile justice system, the passive violence that we see in the immigration system, the things we haven't talked about like trafficking and how these children get snared into this all leaves us with an immense amount of work to do. But fortunately, we have 3, 4 organizations up here that are doing God's work. I think it's God's work. And many of you who are in the HRI program, hopefully going back into the work, and the rest of you who are here doing the work, gives us pause and hope. And we'll move forward. So we have time. We have actually quite a bit of time for questions at this point. So Andy, you have the microphone. Patrick? All right. So questions.
Yes, we'll start here. And again, please identify yourself to the panel.
Okay, my name's Carl Mintz, and I've got questions that I wrote down. For Marcia, I see bandied about a lot of statistics about who has the most incarcerations, and I've heard that China beats the U.S. Would you comment on your analysis of that, what you've heard? That's the first one. And Maria, which government agencies have been most helpful and which ones least helpful? And Margaret did you think about buying shares of the companies that you were trying to get to change, go to the annual meetings, give them a hard time, put stuff on the ballot to get them to change and at least publicly humiliate them a little bit?
Take them in order.
Just remind you, you're on the record.
Yeah. Thank you. In terms of official numbers, the official record is that the United States incarcerates the largest number of individuals. And the list that I recall seeing most frequently is a list that places Russia as number 2. But whether or not there is a reason to suspect that numbers may be higher in other countries, that may well be true. But the official record continues to place us at number 1.
And I don't think that we should use China as our baseline.
Okay, I'm not going to answer your second question, but I will answer your first because we're on the record. But actually, the irony is that the most helpful agency was Department of Homeland Security. There were teams of people there who really, really wanted to push this forward, and it may have been that we were doing this work at a time when there were just some amazing people at the helm. The interagency working group that I mentioned it's co-chaired by somebody from Department of Homeland Security and then somebody from the immigration courts. And so actually both agencies were really helpful. They would convene teams of people. They would all meet and they'd prepare their comments and they'd have a whole group of people ready to talk to Jennifer on the phone and give their best ideas. So I was really surprised at that. And my theory, which is quite naive probably, is that there are folks in both of these agencies who are very uncomfortable making decisions when they have a child in front of them. They're working under adult rules and they simply don't like having to make that decision, and they would like some guidance about how to, move things towards a more child-appropriate decision-making system.
Yeah, in response to your question, it's one I've been asked before, and up to this point, it's not a strategy that Human Rights Watch has taken, though some of our partner organizations do good work in that way. But yeah, thank you for raising it.
Carlos?
I'm Carlos Vasquez on the faculty here at Georgetown. Thank you for an excellent panel. I think it was very illuminating to hear the ways in which advocates can use the Convention on the Rights of the Child, despite the fact that the U.S. is not a party to it. But that leads to my question. To what extent do you think your advocacy would be helped by U.S. ratification of it? I mean, it might seem like an obvious question, but I ask this for a couple of reasons. First, as Wally mentioned, when we have become parties to human rights conventions, we have become parties subject to numerous reservations, understandings, and declarations, which include not just the federalism declaration that Wally mentioned, but also an understanding that it's not self-executing and therefore can't be used in litigation in courts. And in addition, we've attached substantive reservations. So if we disagree with a particular norm that's part of the convention, we say we don't agree to the convention to that extent. So for example, for the Covenant on Civil and Political Rights, we took a reservation saying that we reserve the right to execute minors. So, the trend has been to attach more reservations and declarations. So when the Convention on the Rights of Persons with Disabilities was submitted to the Senate, the administration attached, in addition to the usual ones, other reservations such as we don't consider the work of the committees to be binding, the monitoring committees. We don't consider the work of the monitoring committees to be evidence of customary international law. So when we have ratified subject to reservations that would seem to limit its usefulness for domestic advocacy. On the other hand, or on the other side of the scale, the convention can be used in a number of ways without us being a party to it. So you mentioned a number of ways, for example, in sentencing, the standard is cruel and unusual punishment. It would seem that anything that in any respect that the U.S. deviates from the CRC, we are unusual. And so it can be used through that clause. In addition, I would think there'd be a strong argument that everything in the convention is customary international law because every other country in the world considers it binding on them, so that it's binding on the United States as well as customary international law. And then finally, there are a number of the norms in the convention are also covered by conventions to which we are parties. For example, on solitary confinement, we are a party to the Convention Against Torture, and the Committee Against Torture has ruled that solitary confinement is torture. As mentioned this morning, we're also a party to the Convention on the Rights for the Elimination of Racial Discrimination, and that's been interpreted to protect immigrants, so persons with in migrant status, and also ILO conventions to which we are a party are relevant. So in light of all of that, to what extent do you think your advocacy would be helped by being a party? I think there are obviously reasons to ratify it apart from the usefulness it would have for domestic advocacy. But my question is, in the context of domestic advocacy, how useful would ratification be? How much would you?
Right. I can answer that, and then anyone else who wants to chime in. I see any time the United States ratifies a human rights instrument as incredibly useful, despite its Swiss cheese approach to international treaties and human rights, for a number of reasons. One is if the United States is going to take a reservation that says we reserve the right to kill children, then we need to know that as the American people. Ferreting that out, exposing it to the light of day, that's always really helpful. I also think it would be incredible to have the CRC ratified and approved by the Senate because that would indicate an incredible change on the Hill that would help us in many, many, many other ways. So the more we can see the United States adopting human rights norms and frankly holding it up to the rest of ourselves up to the rest of the world and saying, look, we're either doing this or we're not, but really taking an approach that's more active towards human rights, accepting it as something that we need to pay attention to and that we have a problem with, because so often in the U.S. we're like, oh, well, no, that's not our issue. That's not our issue. We don't have problems. Our Constitution covers it. Don't worry. In fact, when it doesn't, and in many instances, especially with the CRC, it's quite clear that our domestic laws don't. So that would be my take on it. Please ratify the CRC, even if you want to turn it into a Swiss cheese instrument.
Yeah, I mean, I would add, obviously, it certainly can't hurt. It can only be helpful. I think that there is certainly a question between binding legal authority versus some kind of binding spiritual authority.
Right.
And I think that, as we saw in the case of both the death penalty and juvenile life without parole, without binding legal authority, it played a very powerful shaming role.
Mm-hmm.
And that could, while that spirit has temporarily appeared to have left the Supreme Court, it certainly could return to the court under any number of circumstances. And I would add to thinking about the issues of things that the United States wants to hold on to, it's also the issue of transfer. So throughout Europe again, and I believe this is in the CRC, the age of criminal responsibility is 18, and children are not tried as adults in essentially the rest of the world, and certainly not in Europe, but it is something that, of course, we hold on to quite dearly. It is more dear to us than execution and life without parole, just the ability to try children as adults. And I think that if we could ratify something that prevents that, though we would probably do it with some weird reservation. It just has a power of its own. It doesn't change the world, but it gives us a little extra oomph behind our effort to change the world.
Just to add a little bit of perspective here. First of all, Carlos is an expert in international law, so his questions are going to dig deeper than a lot of us who dance around international law might do. But the notion of effectiveness is interesting because it's not only the effectiveness in the work we do, it has spillover effective work as well. So when the campaign for ratification was visiting senators during the Obama administration, we had a response from a Republican senator who said to us, you know, just get the damn thing ratified because I can't have a conversation with any counterpart in any country who doesn't start the conversation with, when are you going to sign it, ratify the treaty? So for that reason alone, we should just get it out of the way. In terms of customary law, I don't think any of us, Carlos, are prepared to answer that question. You could tell us what that means later. But I wanted to say one word about the age of jurisdiction. The committee on the ratification, which issues reports, has taken the position that 18 is the age of the convention. But if you read the provisions about age in relationship to a country's ability to set the age for crime, it's not quite so clear. And we had a conference here on the CRC about 5 years ago, and I said, where does that come from? I mean, I read this a little differently. And she said, well, we wrote the opinion. So it's another example of ask for forgiveness rather than permission. But it is a little unclear as to what that is. I had one other piece. Carlos mentioned the enforcement mechanisms of these things. And you heard earlier this morning that the third protocol is a protocol that actually gives what we would call a cause of action to bring complaints against the United States by a citizen. There were many of us, well, Marty, maybe not many, there were several of us in the campaign for ratification. I do some work with them as well, who were very, very worried about that provision because one of the arguments is that, the blue nannies, they could come and make us do things we don't want to do. But we used to be able to hide behind the defense that there is no enforcement mechanism. The most we have to do is make reports about the work we're doing. Nobody can take the United States to some international court and thereby lose our sovereignty. Now we got to deal with Protocol 3. And certainly, as Carlos says, we could always issue reservations, understandings, and declarations, but it again sort of takes us out of the solidarity of the treaty. So a lot of complications in international law. Our Constitution calls it supreme law of the land, and what that means has always been an interesting question as well. Other questions from the floor? Good.
Hi, my name is Risha Mather. I work with First Focus and also with the campaign to ratify the CRC. My question's for Margaret on the ILO conventions. So can you speak to if the ILO convention, since that is instruments that we've signed, if that has helped move the dial forward in child labor? Because you mentioned, U.S. law is pretty good, except in the agricultural arena. So I just looked it up. They were signed in the 90s. So I was just wondering if you could speak to how that has actually helped and how that argument could be used for signing other international documents.
Yeah, it's a great question. Thanks. Under ILO Convention 182, children under 18 are banned from performing hazardous work. The ILO leaves it up to individual countries to determine what exactly constitutes hazardous work. They give guidance and a recommendation, and the guidance includes things like work underwater, work underground, work with harmful substances. But really, when it comes down to it, it's up to each individual country to specify which jobs are prohibited for kids under 18. And there aren't that many countries in the world that explicitly put tobacco on that list. Brazil does, and my colleagues and I did research there and found that actually Brazil's approach to child labor and tobacco farming is a very positive model. They ban children under 18 from working in the crop, but they've coupled that initiative with really comprehensive safety and health training, with, efforts to provide education and social services to rural families. And, over time, attitudes and practices are changing. When it comes to the companies, the companies cite ILO standards in their policies. The difficulty is, because ILO doesn't specify exactly what constitutes hazardous work, it's up to the companies basically to determine what tasks in tobacco farming they consider hazardous. And so for some, they have, fairly comprehensive lists. For others, they don't have a list at all, and they just look at what's the law in the country. So for example, in the US, there would be nothing related to tobacco that would be considered hazardous. There is a process underway now, a tripartite process between the ILO, governments, and the industry to come up with authoritative guidance on what will constitute hazardous work in tobacco farming. And we at Human Rights Watch think it has to be a clear, strict, implementable ban, no direct contact with tobacco. We think if there's too many carve-outs, it becomes too difficult to follow, and there's too high a risk that kids would be exposed to nicotine or other dangers. So we're going to do everything we can to influence that process, but it'll take quite a few years before there's anything authoritative from ILO.
And I'll go first, Jaron, and I'll let you go. My name's Wendy Cervantes, again, with First Focus. And I was just thinking, as you all were talking, and as someone who's worked on some of the issues that you've talked about today, is that in every single one of your areas, I've thought about how children of color are treated differently, right? So whether it's criminal justice, whether it's unaccompanied kids coming across the border and having two different standards of child protection and child labor, like, Latino kids primarily being those kids. Is how we think about the importance of the CRC as our child population is getting more and more diverse. There is now primarily children of color. So I just was thinking about that, and I think I'm just looking for a reaction and comments from you all on how you've thought about that in your work and who you're partnering with, and how you kind of see that as part of the dialogue moving forward.
Well, I would offer what will probably sound like a general answer, not a specific answer. And that is that certainly when you see references to international law discussed within the courts, there is a reference to concerns about human rights, international human rights, and the dignity of each individual. And again, I think that's more of a moral imperative than perhaps a legal imperative. But I think that those kinds of terms that we associate with international human rights law, which is certainly reflected within the CRC and other pieces of international law that we've heard talked about today, become central in our fight as we continue to address issues of disproportionality and the extreme degree to which obviously individuals of color certainly are disproportionately treated poorly within the criminal justice system. And I think the entire immigration conversation that's going on today is very reflective of that as well.
Yeah, I would just say I think it's, certainly incredibly relevant when you talk about child farm workers. It's a predominantly Hispanic or Latino workforce. And, even though many of the children themselves are citizens, they're still affected by their family's vulnerability because, their parents might be here without documentation. And, I think we have to look at the whole picture of issues affecting these kids and what's kind of driving them into the fields. And farm workers are such a vulnerable workforce. They have far fewer protections under U.S. law than any other workforce. So, if you're talking about a child farm worker, maybe one or both of their parents also work in the fields, don't get paid overtime, don't have the right to form a union. These issues are all connected, and it's connected to the family poverty and the root causes of child labor. So I think it's something that we just have to keep in mind.
I would just say in the context of the juvenile justice system, the criminal justice system, and solitary confinement, the argument made for solitary confinement that I've heard repeatedly across this country is, well, those kids aren't really kids. They're different. And that's just code for saying, those kids are my kids, those kids are poor, and they are kids of color. And that, unfortunately, repeatedly is the way administrators, state legislators, the public, and the police justify their treatment of these kids. Because you would never, ever lock your child in a bathroom and leave them there for weeks at a time. That would be child abuse. But too often, Americans think it's okay to do it to other kids, to kids that aren't their children, because they assume that we're talking about children of color, who to them aren't really kids.
Yeah, and I would just really briefly add on to that. I mean, I hadn't thought about it, Wendy, when we all sat up here, but you're absolutely right. And I think it goes to your point, Amy. I mean, I think we think about these kids as other and not us. And it's, you know, it's been that way for generations of immigrants. It's somebody else, it's not me. And right now it's people from Central America, and they're not us, and it's poor, you know, it's poor kids, it's Black kids, and they're not us either, those of us who are in places of power.
Hi, I'm Joanne Lynn. I work with the ACLU on immigration and refugee issues, and I just want to congratulate the panelists on both the breadth and depth of this conversation. And then my question is specifically directed to Maria and Margaret. Both of you talked about the engagement of the federal government, and you had intensive engagement with multiple executive agencies. Some success, but I have to tell you, Margaret, I didn't know the end of your story, and I was hoping for a positive denouement, and then I felt like my heart was broken. But but in the end, here we are in the final year of the Obama presidency, arguably an administration that should be as knowledgeable and as receptive to the set of issues that we've discussed. And yet, the Obama administration has targeted Central American unaccompanied children as the top priority for deportation. And you talked about, Margaret, the total, I guess, failure of federal regulations by the Labor Department due to political pressure. So looking ahead to 2017, and I'm going to make a big presumption here because we have to think optimistically, that we have a presidency that is receptive to these issues. I'm not going to name a presidency, but you can fill in the blank. What do you see as additional or alternative in 2017 that you and collectively we can bring to these campaigns so that the federal government is forced to reckon and engage, and we can get a positive denouement on both of these issues 4 years from now?
Well, I mean, I guess I'm hopeful that we'll have a president who is good on these issues, and then we'll have perhaps more people in the Senate or a majority in the Senate so that we can, move comprehensive immigration reform forward. I mean, there were some really good pieces in comprehensive immigration reform, such as legal representation for all kids, that it died without that. But I'm worried too, because public statements by some of the candidates have not been good. Certainly on the issue of unaccompanied kids, they've been right in line with the Obama administration, and the administration hasn't been good. I mean, we were fortunate enough to work with some really great people in the agencies. I'm not sure how many of them are happy about or are still there, who have seen what's happened in the last 9 months to a year.
Yeah, the Obama administration, I mean, they turned their backs on child farm workers with that promise not to pursue new regulations, but there's still time. I mean, they could still issue a new regulation, they could issue an executive order, there's still time. And so, we're not quite ready to let Obama off the hook for this one. But looking to a new administration, our hope is that they wouldn't be bound by this same promise, and that there could be, a swift initiative to introduce regulations that would keep kids out of tobacco fields, and also update other types of hazardous work to keep things off limits for child farm workers that are working in crops beyond tobacco. But I'm not done with Obama just yet.
Hi, Michelle Brunet with the Women's Refugee Commission, and also lucky enough to be the adjunct with this amazing group of students this morning. So I wanted to actually bring it back to the education issue. And for Margaret, I'm curious, obviously a lot of the kids that are currently working in agriculture and in other child labor situations are some of the very same recently arriving children that the students were looking into regarding access to education. I think one of the gaps was that given the time and capacity, there wasn't the ability to look into the children that are not attending school or who may never even have tried to attend school because they went straight into the workforce. But I'm wondering whether you all thought about using truancy laws or mandatory education as a way of sort of at least getting into how many hours, for example, some of these kids might be working.
Yeah, so I didn't go into our findings on access to education and the impacts of the work on education. The good news is that most of the children that we interviewed do attend school. And, you know, tobacco is grown primarily in the summer months, and most of the children that we interviewed live year-round in communities where tobacco is grown. School lets out for the summer. They head out to the fields and work 60 hours a week in tobacco farming. We did meet some kids. You know, these were more often, as you said, sort of recently arrived unaccompanied kids or children who migrated from state to work in different crops. For those children, we did document some interruptions in their education, a few kids who had never enrolled in school, but the vast majority of kids that we interviewed were attending school, so it was a positive finding.
Can I just ask too, though, I think my concern though too would be using truancy laws against those kids. So you're gonna, it's a status offense and you're gonna haul that kid into court and the parents and, yeah.
One more question back, or two more questions, excellent. These will be our last two questions, I believe.
June Gargis, I'm with the Human Rights Institute here at Georgetown. It seems that with juveniles in adult courts, as well as in these ICE issues of confinement, that they're suffering from very similar issues of whether it's psychological issues as well as, you know, the conditions of confinement themselves, of isolation. And although it seems that the Supreme Court in Romer and similar cases have provided some protections for children, there seems to be this gap in the law that would help address the needs of children based on our evolving understandings of developmental differences between children, not just disability differences, but also immigration differences, psychological differences, and just general issues of variations in development generally. And this might even justify lesser conditions of confinements for children at older ages, even up into their late teens. So I'm wondering, in attempting to protect these children and to protect juveniles in their psychological development and their individual autonomy, how do you see the law needing to evolve to address the individualized developmental needs of different children?
If I understand your question, are you asking about sort of potentially kids over the age of 18?
Both over and under. So I know there's some like hard and fast rules about even younger children who are, you know, 13, 14 years old going into particular levels of confinement or lengths of confinement. But obviously there's 15-year-olds that are far less developed than a 13-year-old and things like that. So how do we get past these hard and fast rules of age and start looking more towards the developmental differences? But that could also include over the age of 18.
So that's a really interesting question and is in some respects not an easy one to navigate where we should actually be headed for this reason. Let me talk about sort of the under 18s first. You know, when the Supreme Court initially addressed the death penalty for juveniles, the court drew a line at 16 and 17 versus everyone below the age of 16. And the court specifically rejected its analysis in Stanford in 2005 in the Roper case in saying that we're going to treat everybody under the age of 18 the same, and we won't treat children differently depending upon where they fall along that continuum of childhood and adolescence. And Kennedy, in fact, in his opinion in Roper, because he has to address that, talks about the reason for drawing that bright line at 18 is drawn primarily from looking around the country, and there's an appendix to the Roper decision that includes references to all of these state statutes around the country that limit children's participation in adult society or adult activities, largely at age 18, some at 16, some obviously older, some at 21. But that this view that the consensus seems to be at around 18 is where we're willing to draw the line, so the court drew the bright line. Roper didn't look at the brain science at all, didn't look at any of the neuroscientific information in terms of reaching its conclusion. In Graham and in Miller, the court is much more focused on what the neuroscience has taught us about the adolescent brain and its continuing development. And that has forced a whole other really interesting conversation about whether we should be pushing that line up to 20, 21, 24, where we draw that line at the age of both criminal responsibility, interestingly enough, and also the age of juvenile court jurisdiction. And there is a new research project underway, recently just announced at the Kennedy School, that will be specifically looking at that question. So I think that, I don't want to be long-winded here, I think that there's a value in not cutting off the age too soon. So while we know there are obvious differences between a 12-year-old and a 17-year-old, and in fact, in the police interrogation case, JDB versus North Carolina, Justice Sotomayor, who wrote that opinion, said, you know, a 12-year-old is different than a 17-year-old is different than a 25-year-old. Like, the court gets it, but they still wanted to treat all kids under the age of 18 with the same, provide them the same benefit of that opinion, which was to provide greater protections in police interrogation. By the same token, we have too many young adults who are suffering extreme sentencing in the adult criminal justice system, and whether there is some way to use the benefit of science and the information that we're learning to either push the boundaries of juvenile court or to imagine, I don't think a third rail is the right word, but a third way that we might think about sentencing young adults differently than we sentence adults who don't fit within that still developing frontal lobe part of the brain category, that might push us closer toward a more humane justice system.
I just want to address that quickly. I don't think in the context, for example, of solitary confinement that we would ever want to push through the courts an individualized determination, because you have to think about who makes that determination, and it's going to be the correctional officials. So we've already seen that in the context of seriously mentally ill being excluded from solitary confinement. In American prisons and jails, it's the only place where you can be cured of schizophrenia, because people get de-diagnosed in order to be placed in solitary confinement. So individual determinations, especially when we are in the context of the Eighth Amendment, where we want to say, this is human dignity, this is punishment. It doesn't matter if you're 14 or 16, you shouldn't be subjected to these types of conditions. And then just to touch base on the evolving idea of brain development going beyond 18 years old, where what we're really seeing is it's much older, 25, 24, 21, that those folks should be distinguished in the criminal justice system from adults. And in the context of solitary confinement, we're actually seeing this play out. For example, in Rikers Island, regulations were passed to protect kids who are under 18, but there are regulations coming online that are going to exclude folks who are 21 and under from solitary confinement in recognition of the neuroscience. So that's where we're seeing actually the science drive some of the rights more. And even the Obama administration in its report on solitary confinement noted the fact that 18 to 21-year-olds really should be treated differently in the context of solitary confinement. So I think that's an exciting area where the law is developing.
I'm Gabe Tews from the American Psychological Association. Thank you all for fascinating presentations. I learned so much. I have a two-part question for Amy. You primarily talked about judicial remedies for solitary confinement, juvenile solitary in particular, which sound very promising. How about legislative? Do you see anything getting through Congress anytime soon, even if it's just federal? Or is that a foolishly optimistic question? And second, when I talk about juvenile solitary, I try to make the same kind of arguments you did, albeit not as eloquently, but I focus on mental and physical health consequences.
Mm-hmm.
When I talk to certain groups of people, I get the response, yeah, that's all well and good. What can you tell me about behavioral consequences, particularly recidivism? Can you comment?
So to your first point about federal action, we've actually seen protections for kids against the use of solitary confinement show up in several pieces of legislation, like the REDEEM Act and the Sentencing Reform and Corrections Act, I'm going to get the name wrong, which, you know, in this Congress, nothing seems to be moving. There was some hope for the SRCA because it has bipartisan support, and actually so does REDEEM. So that there's actually been a surprising frisson of federal legislation around the issue of youth solitary confinement, and indeed, actually, the Obama administration has adopted the policy recommendations that were embodied in the SRCA, and those actually come from the JDAI best practice standards for kids, which limits the use of isolation to 4 hours. So that's actually good news. Whether or not it will pass in this Congress or the next is another. It's a great question, but it's important that that legislation is out there because it's actually influencing what the states are considering, and that's quite frankly where the vast majority of kids are. So that's the race that we need to win. In terms of actual data on the use of solitary confinement, I mean, one of the things about the practice, both for adults and youth, is the fact that there's no mandatory reporting in most jurisdictions. So how many kids are there, how long they're there, why they're there, very difficult to determine. What we're seeing is some jurisdictions like Nevada and Nebraska actually pass laws that mandate reporting just to even understand what the practice looks like at the state and local level for youth and for adults too. We do know, we've got some of the preliminary data that came out of the suicide study that was done by BJS, I believe, Lindsay Hayes. That's where we know that 50% of all youth suicides occur in solitary confinement. And then, of course, we've got the more recent Journal of Public Health report around the Rikers records and the data set that demonstrated that youth are disproportionately impacted by the use of solitary confinement. But frankly, we need more data and we need more analysis. And we need these facilities to be held accountable for their practices, and the only way they will be is if they're more transparent to the public.
Please join me in thanking this excellent panel, Wally, Marcia, Amy, Maria, and Margaret. And let me introduce our final speaker of the day. We're delighted to have Christine James Brown come to deliver some closing remarks. She is the President and Chief Executive Officer of the Child Welfare League of America, and that's all I'm going to say to introduce her. And we'll have a little reception afterwards, some drinks. I hope you will stay for that. Thanks.
So I'm really here in my capacity as a member of the campaign, and I'd like the other members of the campaign who are here to stand or raise your hands. Over the course of the day, the majority of the executive committee of the campaign have been in this room. It's always a win-win for the audience and the speaker when almost everything that needs to be said has been said. And that was the case today, including, I think it was Marcia or Amy who said, let's not let Obama off the hook. And that's what I'm going to talk about today, the fact that we don't want, as a campaign, to let Obama off the hook. We want him to send the treaty to the Senate before he leaves office. We know that if he doesn't do that, it's going to be a number of years before that will happen. And we cannot afford to let those years go by. So we are launching a social media campaign to encourage the president to send the treaty. It's simply hashtag send the CRC to the president between today and the 15th. So take your pens out or get your fingers ready, and hashtag send the CRC is what you need to do. But let me say, we had a pretty interesting debate among the campaign members about whether it made sense to do this. You know, was it going to seem like, is there any possibility of the president really doing anything? Is it going to be ratified? It's not going to be ratified. We know it's not. But the reality is, if it gets to the Senate, it can sit there until there is readiness for it to be moved forward. And at least we've made that step. We also had a lot of debates, and you even heard some of our members asking questions about what difference is it going to make anyway, even if it is ratified. And some of your questions were similar, but I think some of the answers you heard were very important to listen to. I think the most important thing for us ultimately was we have to be part of the global community. We cannot afford not to be on such a significant issue. We can't afford any of us to travel internationally, as I do and many of you do, to be embarrassed with the question of why have you not ratified it? We can't afford that. We can't afford not to learn from other countries about what they're doing and how they're addressing the needs of children and families. And we can't afford not to share what we know. So being part of a shared learning environment is critical. So being part of the global community, being part of the shared learning environment is very, very important. I think also it's important that we see this as an opportunity to raise the needs of children to a national priority. And as an organization that's been trying to work on this issue for almost 100 years, making children a national priority, I'm always shocked by the reality that they are not. Your children may be a priority in this country, your child, your grandchildren, your neighbors, but too many of us see the others as not a priority. And we've even talked a little bit about that today. So really getting this country to think differently. I see ratification as an opportunity similar to a public health campaign, where you set the vision, and then from the vision you have, through the treaty, measures and an opportunity to evaluate progress. So in many ways, we're setting the vision and trying to move it forward from there so we can really change how this country thinks about and feels about its children. The other thing I want to say is that the need is there. You heard it in every single presentation, whether it's children that are in the prison system, children, undocumented children, and their plight. But what we didn't talk about is the children in Flint, or the children that are in some of the schools that I know exist in this country, particularly in inner city areas where children can't even go to the bathrooms during the day because the bathrooms are filthy. We know about it because there's so many children who don't have access, even despite Obamacare, who don't have access to the right, particularly rural children, to the right type of providers. So the need is clearly there to say that we're not so well put together in this country that we don't need to worry about ratifying it. And then it's the moment in time. You know, we have a matter of months with this administration. We finally have the treaty signed by the Clinton administration, and it could be ready to go and sent forward by the Obama administration. And we have a very short window of time to encourage him. We don't know who's going to be in office after him, so we have a very short window of time to move it forward. So with that, I want to say the only message I want to leave you with today is to please remember #SendTheCRC. There is a whole body of information online that's available, childrensrightcampaign.org. There is a youth strategy to get youth engaged and involved this week that you can get toolkits and information about. And there is the opportunity to learn more than you ever want to know about the significance and importance of the CRC. I really just want to congratulate particularly this group of young adults for your extraordinary presentation, and actually everyone today. I learned so much today. And Susan, who's my hero, and will be forever. I always learn from you. I told her as she was sitting at the table with me that I tore up what I was going to say when the young people spoke, and then she spoke, and I tore up what I rewrote and said, I'm just going to come up and say, please make sure the #SendTheCRC. Is everyone going to do it? No, is everyone going to do it? Okay, I want to tell you one thing. We were at a conference, the CWLA conference on kinship care a few years ago, and there was some legislation that wasn't moving fast enough. And we asked everyone at the same time to send a message about passing the legislation, and we got calls saying, what in the world happened? Why are we getting all these messages? There's something about the power of doing everything at one time. So before you leave today, turn your phones back on and send the message. Okay? Good. Thank you.
The website is childrightscampaign.org.
Is that what I said? No? Oh, I'm sorry. Childrightscampaign.org.
Thank you very much, Christine. So we've come to the formal end of our program. There are obviously some great conversations that you've begun, and I hope you'll continue them. We have some drinks to, to talk things over a little more. Thank you so much to all the presenters today and our moderator, Wally Malenik. We really appreciate everything that everybody has done today. So please enjoy the drinks, and thanks again for coming to this DASH conference for 2016.